All of a sudden, everybody got quiet just because I stood up here. I'm going to let people get seated. Good morning, everybody. I guess I need to use the mic. Good morning, everybody. It's so nice to actually see people in person. So, you guys ready over there? Okay. Good morning and welcome to John Jay College of Criminal Justice. In case you're wondering who I am, my name is Carol Mason, and I'm the president of this wonderful institution. And I am standing on the shoulders of someone you'll meet later, Jeremy Travis, who was the president for 13 years before I got here. Though I'm heading to my 5th anniversary, Jeremy, it's scary that it's gone that fast. We are so grateful for your participation, those of you here in person and those of you joining us online for this important conversation. I hope you know how important it is, particularly at this time, for us to engage in real deep conversation, listening, talking, engaging with each other on something that's a very difficult topic, but really important, and a conversation about something I think that at the bottom line, we all want the same thing, which is we want a system that is fair and equitable that keeps our communities safe. It's just in the middle that we struggle a little bit with figuring out what do the contours of that look like. And this conversation today it's my hope will give us a pathway to figuring out a consensus pathway. We're not going to reach decisions today, but I hope we will have a pathway. And so this is a conversation, about bail reform in New York State. But I think New York has an opportunity to lead the country, not just in how we resolve the issue, but how we go about resolving the challenges of this complex issue with stakeholders with different views. Here at John Jay, if you don't know John Jay College of Criminal Justice, we develop fierce advocates for justice, ethical visionaries, engaged citizens, scholars, and future leaders capable of creating pathways to justice and opportunity for all of our communities. Today's convening is a wonderful example of the ways we engage and educate our students, faculty, and the public, and all of you on key issues related to justice and safety. It builds on our future of public safety work, which started in 2020. In the wake of the George Floyd killing and a national dialogue about what we do about policing, funding police, defunding police, that conversation, I realized that's not the conversation we all want to have and should have. The conversation I thought that we all needed to have together was, how do we create safe communities where all of us want to live and thrive? And in partnership with the National Organization of Black Law Enforcement Executives, NOBLE, we had a series of 6 conversations with stakeholders across the spectrum about the future of public safety and produced a report that we hope is, again, a roadmap for people to use in terms of creating safe communities. And thanks to Erica Bond, who's our Vice President for Strategic Initiatives, she is leading that work because it is not just something that sits on a shelf. It was the first step in helping build safer communities in partnership with people across the spectrum. Our Future of Public Safety series brought together experts from across the ideological spectrum, from community organizers to elected officials to health and public safety experts to line officers, union officials, everyone, to develop a common vision for public safety. And we covered so many topics. It's online if you want to see it. The report is there. I hope you use it. But at the core of each conversation, the question was, how do we rethink and reshape public safety so that it supports healthy, safe, thriving, racially just communities? And today's convening builds on that conversation. As I mentioned at the start, I have every confidence in the world that as a result of these conversations, we can reach some common ground and a pathway to figuring out how do we engage in this very difficult subject and lead the country in bail reform. The initial set of New York's bail reform statute went into effect in 2020. It was passed with the goal of ending wealth-based disparities and racial inequities in our jails and prisons. The legislation also sought to promote public safety by exposing fewer people to the harms of jail that research shows can increase the likelihood that someone engages in criminal activity when they are released. In the years since bail reform, New York statute has been hotly debated across the state, with many questions raised about its impact. And there's a narrative developing that isn't always based on facts, and today's conversation is to take us back and to have the nuanced conversation that we need to have in a safe space so that we can talk about these issues in detail and from a fact-based perspective. And we hope that we will help by working with our students, community members, elected officials, and the media to better understand this topic. And we appreciate Errol's presence, which I'll introduce him later. Because again, I think that if all of us are in conversation together, listening to each other, staying at the table, talking about the difficult things, we can reach resolution. And this conversation will influence what's happening in other states. And again, we can be leaders in guiding this. So we are fortunate to have some real experts and researchers on bail reform here at John Jay to help us with this conversation. And they are the prime sponsors and drivers of this conversation. So where's Mike? So I want to introduce Mike Rampell. There he is. He is the leader of our Data Collaborative for Justice. And they just released a report about bail reform in action, pretrial release outcomes in New York State, which details the impact of bail reform on court practices, judicial decision-making, and racial disparities throughout New York State. We want the conversation to be based on data, based on true information, so that we can begin thinking about what do we really want to do and what do we need to do. So I want to thank Mike Rampell and his colleagues for this conference today. I also want to thank Mindy Bockstein, who's watching remotely, who is our Director of External Affairs, who made this possible as well. And again, I want to give a big thanks to Erica Bond, who is, again, our Vice President for Justice Initiatives, for leading this work across the college. And as you know, John Jay creates the space and programs to encourage people to have these kinds of dialogues across the public, practitioners, local government, and community leaders, and we do not do this alone. I mentioned him earlier as the most recent president of John Jay, but he's also the person responsible for Arnold Ventures leading this conversation today. So please join me in thanking Arnold Ventures and Jeremy Travis. And again, I think that because of this, we will have a path forward. We are also grateful for all of you who are attending, because you show by your presence online and in person that you really are committed to this issue and you're committed to staying in it to help us work through this. So please give yourselves a round of applause for showing up today. I mean it. Give yourselves a round of applause. And we're also grateful for all the public entities, advocacy organizations, research organizations, and public servants who have prioritized justice and fairness in the state of New York, offered guidance on how everyday New Yorkers would be impacted by bail reform, and continuously make their voices heard. And we need those voices. We need the voices of protest, because that means, as I like to say, that people have hope that change is possible. If people are quiet, that means they've resigned themselves to the status quo, and I know that we're not resigned to the status quo. And so next, I'd like to thank our moderator today, New York One's Errol Louis. He is known to many of us, I hope. He's a longtime journalist and commentator, most recently as the public anchor of New York One, and he hosts Inside City Hall, which is must-watch TV for me. I told him, I said, I tape it at 7 and 11 in case I don't make it home, so I don't miss anything, or in case my recorder messes up. But we are grateful to have him leading this conversation. I'm always impressed with the research that he does before he talks about any topic. And I think that he joins us in wanting to help us have these conversations in a way that produces a productive pathway forward. And I also want to thank our first panelist, who is Senator Gianaris, who is the primary architect of the bail reform statute and serves as our deputy majority leader in the New York State Senate. I want to thank Senator Gianaris for being here, for leading off this first panel. The second part of the opening session will be another panel that Mr. Lewis will moderate, with a conversation of leading voices on bail reform, again, from many different perspectives, because that's what we need. We need people engaged in the same conversation, not competing conversations, the same conversations, so we can develop a pathway forward. So please join me in giving a warm welcome to Errol Louis and Senator Gianaris.
Socially distant?
Yes.
Yes. Okay. Well, thank you very much, President Mason. Always great to be here. I am the son of a John Jay alum. My dad, the late Edward J. Lewis, was NYPD officer who went here under a program that allowed cops to go here for free. And he did it while working full-time for the NYPD. And it took a long time, but he did end up getting a bachelor's degree. I'm glad to be here in part because this is a question that we have been talking about at Spectrum News New York 1 for quite a while, and in trying to both cover the news side of it, but also provide some analysis and some context to watch the narrative depart from the factual basis that we all hope it would rest on, has been a challenge professionally and personally a little frustrating. You know, I mean, you spend a lot of time reading through reports from places like John Jay and trying to make sure that you have the numbers right and the facts right and the trends right and the percentages right, only to hear people, some in positions of political authority, say, well, none of that matters. Let's just use common sense, right? Let's depart from the facts and just, you know, do stuff to people. It all reminds me, Senator, of a phrase that was very much in the headlines in the late 1980s called preventive detention, which is really what some people are calling for, which is very different from what you all had in mind. So let me just start by invoking the frequently quoted and misquoted, I'm probably misquoting it too, it's often attributed to Otto von Bismarck: if you like laws and sausages, you should never watch either one being made. But as one of the top chefs in the sausage factory, I would like to talk to you for a little bit about how this all came about, you know, because among the things that are now departing from the facts is the chronology, the history, the legislative intent, I guess you would call it. Take us back to 2019. This is before George Floyd. This is before the nationwide protests. This was on the agenda. This was something the legislature was taking up and working on quite diligently, along with some other jurisdictions around the country. What was the intent? Why was this on the agenda? What made 2019 in particular a propitious or politically viable or attractive year to try and move this legislation forward?
Okay, thank you. And let me just take a moment to thank also President Carol Mason and Jeremy Travis for getting us together today, and you, Errol, for continuing to do the great job you do. I didn't go to school here, but I went to school right across the street at the Lincoln Center campus for Fordham, so it's a familiar neighborhood for me as well. As to your question, I'm going to take you back further than 2019. 2015 is when I introduced the bill to enact bail reform. Now, we were in the minority then, so it didn't have a lot of chance of passage, but 2019 was a momentous year in the state. We took the state Senate. We had two functioning houses that were passing laws of great import on so many issues. Most people today are most pleased with the fact that we codified Roe versus Wade in January of 2019, our first few weeks in the majority, and that is proving to be prescient, but we're not here to talk about that today. But the other thing that happened in 2015, which is why that bill got introduced, was a young man who spent years in Rikers Island unjustly killed himself, and that was Kalief Browder. Very high-profile case, but a case that is representative of hundreds and hundreds, if not thousands, of more people that entered the system. And we were committed to doing something to bring about justice. And then you take the 10,000-foot level thought about it, and like, what is bail? By definition, bail discriminates against the poor. You're asking people to pay for their freedom. And you don't hear any complaints about wealthy, awful people who do awful things and are home because they have enough money to be home. You know, I was reading last year, the year before, I forget when it was, but I guess we were in the pandemic, maybe it was the year before that Harvey Weinstein was like at comedy clubs and out at restaurants. And why? Because he had enough money to pay bail while he's waiting for his trial and all the awful things he's accused of doing. Of course, young, poor people, primarily of color in this city, don't have that ability. And one of the things I had done, I've always been interested in criminal justice issues, and have worked on wrongful convictions and other issues over the years. I've been in public service, but I also had volunteered with the Fortune Society to mentor people who were incarcerated at Rikers and try and help them integrate into the community once they come out. And it was eye-opening just to talk to these people and get their perspective. It's such a different perspective than you and I would have. Because I was asking one of the gentlemen I was dealing with, I said, well, why, what happened to you? And he had bail set at some incredibly low number. It might have been like $500 or something, low for you and I. And he's like, I just never had a thought that I could round up that kind of money. So he's like, I'm here. And I just knew I was going to be here. And oftentimes, especially on low-level charges, these people are held at Rikers for longer than their sentences would be if they are actually convicted after trial. And the injustice in that is obvious, or should be obvious to everyone, especially in a system that we're taught from when we're children. We take great pride in the American system of justice, innocent unless proven guilty. These are all pretrial incarcerations we're talking about. These are people who are denied their freedom before they're convicted because they don't have enough money to pay for their freedom while they're waiting for their day in court. So if someone wants to defend that system, I'll have at it all day, every day with them, because that is unjust in so many ways. And then, of course, we set about trying to fix that. And the reforms of 2019, subsequently amended in 2020, and again this year, are our best effort to do that.
In New York, famously, the law specifies that bail can only be set in such a manner or according to factors that deal with whether or not the person will show up for trial. That immediately became sort of the touchstone of the opposition, as far as I can tell. What was that conversation like? Because, essentially what we have had, and this goes all the way back to the fights when they would attack former Judge Bruce Wright and others, softy judge that let this guy out, that sort of a thing, where it became clear along the way that some people did not see bail for what it was legislatively intended for, but basically as a sort of a tool to hold people that, for whatever reason, they thought should be preventively detained.
That's 100% correct. And bail in New York has never been used to, or the pretrial system, I should say, has never been used to make a judgment about whether someone is dangerous. And you hear about this dangerousness standard all over. But in New York, that was never in place. And so rewind 10 years, 15 years, everyone was so happy with how safe things were. We did not have a dangerousness standard in New York, so we know how to make the system work without that. Because, of course, the problem when you start evaluating that, a criminal trial is our system for evaluating whether someone committed the crime they're accused of. When you start evaluating whether someone is dangerous, when a judge and a prosecutor are evaluating whether someone is dangerous before they've even been adjudicated, the consequences, as data will show, have a horrible impact on particular classes of people, typically young people of color, again, who always seem to be getting the short end in our system. And it is not something that we need, we ever had, or actually makes us safer.
Is New York unique in its adherence to that standard of, only to ensure appearance at trial and essentially no other reason?
Yes, in a word, yes. I mean, we are maybe one of the few, if not the only state that does not consider that.
Yeah. When you began drafting legislation in that period, 2015 up to 2019, was there serious consideration in the legislature about doing away with that standard, about bringing New York in line with the other 49 states?
It is the reform conversation, the legislation took a lot of different forms over the years, and a lot of different ideas were explored. The original draft of the bill eliminated bail for everything across the board, take money out of the system entirely, and it wasn't a dangerousness standard, but it did have some mechanism for determining when remand was appropriate, not based on theoretical dangerousness, which to me sounds like, the pre-crime evaluators in the Minority Report, right? Like there's obvious problems with trying to predict when someone's going to do something when they haven't actually done it. But for me, the dangerousness standard is a problem and always was a problem, and it's a problem in the states that have it. Some places now say they have algorithms to make proper determinations, but then you could, you could dig into this 7 different ways. At the end of the day, what tends to happen is the same people who are always getting screwed by the system end up getting screwed by any type of predictive model as to whether or not they're going to be dangerous on the street. And yes, for every New York Post headline about someone who did something awful or is accused of doing something awful, there's dozens of more who have more stable lives because of what we've done, who are home with their families, who get to keep their jobs while they're going through the system. And that ultimately makes us all safer, which is another part of this that really gets at me. It does not help anybody. It doesn't help the people, certainly, who are incarcerated. It doesn't help our communities in general to take somebody, put them in Rikers for several months or a year or however long they're waiting for their trial, and then release them back out into the community. What's happened in the meantime is they've lost hope. They've lost their families, they've lost their jobs, they've lost their school opportunities, and then you're throwing them back onto the streets without any ability to provide for themselves. And then you're more likely to have them commit additional crimes or do things they shouldn't be doing. So none of this makes sense to me, and ultimately, I don't want to filibuster, I want to let you get in with your question, but what has become clear to me over the last couple of years is there is just, our legal system is adversarial. Each side makes its case. Prosecutors are not supposed to be in an adversarial posture. They're supposed to do justice, whether by acquittal or conviction. But in fact, they're adversarial. And they sit there and they count how many people they put in jail, and they think that's a good thing. And usually they're in league with the law enforcement. And they are defending their turf, so to speak. And their turf is, we want more people in jail, and we want to keep people off the streets who they might deem are unsafe.
Was that the process as you were drafting the legislation? I know there were, lots of hearings, lots of people who weigh in, the lobbyists, have your phone number. The DAs, I imagine, weighed in, maybe the sheriffs, a lot of other law enforcement?
And I don't want to paint with too broad a brush. There were some DAs who were very productive in terms of the suggestions they made and were genuinely interested in getting us to a good conclusion. But writ large, the law enforcement lobby, so to speak, and look, they're very effective. They're the reason we're standing here today talking about why this issue has been so misunderstood, is between them and the editorial boards. They just are relentless. And what's happened is, because crime has gone up, not at all related to bail reform, by the way, because it has gone up in every city and every state in this country over the last couple of years due to a variety of factors. And we're the only state that did this bail reform. So I don't know why Chicago or LA or these other cities are experiencing similar crime spikes because we did bail reform. Obviously, it's not directly related to that. But the people that don't like what we did are using it very effectively to completely mischaracterize the law.
The part of the legislative process is that if, for whatever reason, even if you don't like the reason, if you don't respect the reason, if it's based on something other than the facts as you understand them, compromise is how the system works, right? So there were the 2020 amendments to the package that you originally got passed, and I wanted to drill down on a particular phrase. It makes people eligible for bail if both a current and a pending charge involve, quote, harm to an identifiable person or property. What's the origin of putting that in as an amendment? What was the fight about there?
Yeah, and you're right. The sausage making on this, as with most laws, it takes you in directions you may not have originally intended. I mentioned the original bill got rid of bail in every instance and replaced it with a different process. What we ended up with was something that mostly got rid of bail for certain categories of charges, and we started calling it the bail bucket in terms of the negotiation. And then the 2020 amendments were primarily about adding additional charges to the bail bucket. One of the things we did, because we constantly are trying to listen and actually accept good ideas and make changes when necessary, is this idea of repeat offenders, people who just cycle through because they're not being held, are just committing the same, or accused of committing the same crimes over and over again. And so the idea was, if you're out on a charge and you're pending trial and you're charged yet again with something that would be harmful to a person or property, that you can then be bail eligible. Interestingly, that those words, we thought we knew what they meant, but judges kind of looked at it differently. And so I think we had always, in those 2020 amendments, intended to capture like the person who keeps, robbing banks day after day while they're out. But it was not harm to property was not interpreted to include stealing property, and so the changes we made this year clarified that.
And the clarification says what? That it's, in effect, at least the way the judges are interpreting it, it's capturing a lot of misdemeanors, right? Repeat misdemeanors?
Yeah, but only certain kinds of misdemeanors, right? First of all, we never go below a misdemeanor because the actual maximum sentence after conviction of a B misdemeanor or lower is less time than you'd get waiting for your trial at Rikers. So none of those are in the categories we're talking about. But what we did in this year was we defined harm the way we intended it to be defined. So we made it clear that theft of property is included in these repeat offenses that would be bail eligible.
At the time that the main body of legislation was being done, the governor at the time, Andrew Cuomo, weighed in. The mayor at the time, Bill de Blasio, weighed in. That's where, in my memory, serious talk about adding, fundamentally changing the law and putting in a dangerousness standard started to be heard. Were they, I don't want to use the word posturing, but were they sort of just announcing a position, or were they serious about trying to persuade you to fundamentally change the way New York does bail?
It's a good question. The mayor had his position, but didn't really influence the conversation very much. This was, as we discussed, this is something that had been getting discussed and thought about for years. And yes, I think former Chief Judge Lippman had a whole report that also advocated for dangerousness. This dangerousness question has been raging long before we've started having this conversation. It has been a subject of serious debate in New York policy for a long time, and it had been settled decades ago that we weren't doing that. And then in the effort to reform the injustices of bail, I think people who have that point of view saw it as an opening to reintroduce that as part of the discussion. In the end, Andrew Cuomo signed, obviously, what we came up with, and so he didn't hang on to that position terribly strongly. But the mayor, this is a statewide policy. The mayor is always an important person, important local leader, but I think many mayors have been frustrated by their lack of the influence they would like over state laws, and so I don't know that the Mayor de Blasio was terribly influential one way or the other.
The Kalief Browder case that you mentioned is one of the sort of the founding issues that led to some of the reform efforts. There were a lot of different problems there. There was a speedy trial problem, for sure. In one of the early versions of the legislation, you included maximum detention time limits. It would have been 120 days for people charged with a felony, 30 days for a misdemeanor, very aggressive schedule. I'm looking here, and it says as of May 5th of this year, people at Rikers before trial had been in jail for an average of 325 days. Why did the maximum detention time limits, even something less aggressive than 120 days, why did that fall out of the legislation?
Because of the sausage making, is the short answer. Look, speedy trials or speedier trials would solve a lot of the problem we're discussing. The fact that people have to wait almost a year on average at Rikers Island for their trial is a big part of the problem. If the detention we're talking about was a few weeks before your trial, that's a very different conversation than people who, Kalief Browder, 3 years, right, at Rikers in the extreme cases. But the system doesn't have the resources, is not geared up to handle things that quickly, particularly now with the pandemic having shut the courts down for so long. They're still catching up, from what I gather. But even in 2019, some thought that those were impractical time limits.
You've done some, the legislature has done some discovery reform. The mayor has expressed publicly a great deal of frustration with other elements of the system, including the courts, and whether or not they're moving cases quickly enough. Is that an area for future conversation about reform? Is that something you're looking at?
Well, we enacted discovery reform as part of the criminal justice package in 2019. We amended it just this past year, but there's an example, a good news story is all sides agreed on the changes we made this year, and so both the prosecutorial and defense bars. We're happy with what we ended up with. And that's ultimately, look, legislation works best when it's done that way. You do something, you find out what people like or don't like about it, and you make changes that make sense. On bail, we can't agree on having an honest conversation about it, and that's the problem. And you have circumstances where, as we speak, crime is a concern in New York City, obviously, for so many of us, and people are, in our line of work, are always finger pointing and trying to avoid getting tagged with it. Mayor Adams is out there, just yesterday, I think, trying to make sure he's not getting blamed for not doing anything about it. So he's blaming Albany, he's blaming guns, he's blaming, and there may be elements of truth in all of it, but everyone is pointing at bail in a way that is so frustrating. There was a story just a few days ago in Rochester, the Monroe County Sheriff, I think it was, and the headline and the entire story made absolutely no sense. It says, "Sheriff blames parole bail reform for increasing crime." I don't even understand what those words mean all put together. Like, if you're out on parole, you're not in a pretrial bail situation. By the way, if you're out on parole, no matter what you do, you're bail eligible if you're charged with something else. But it's just become the thing that everyone throws the mud at to get it away from themselves. Why is the clearance rate so low? Someone should ask that sheriff. Why are they only solving a certain percentage of crimes in New York City? It's a very low number. 30% of crimes are solved. That startled me when I learned about it. That means if you're wanting to do something you shouldn't be doing, if you want to break the law, you got a 70% chance of getting away with it. That seems to me to be much more a factor in people's minds than whether they may or may not have to put down some money that they may or may not have to avoid a few months in Rikers while they're waiting to actually get convicted or not. Like, I don't know that someone who's thinking about committing a crime is calculating all that so much as, I might get away with it. That's the bigger factor to me.
Right. Well, in our last few minutes, I mean, there are the facts that we're going to hear about later in the conference today, and this being a institution of higher learning that has top researchers and can sort of crunch the numbers up, down, and sideways. We'll get to the bottom of that. But you're in a world where there are political facts, right, in an election year. And if the political fact is that voters are concerned about rising crime and are going to punish at the polls anybody who doesn't sort of do something about it, it sort of creates facts on the ground. It creates a governor who says, we've gone too far, whatever that means, and we've got to make some changes. It creates legislators, I'm sure people in your conference who are saying, look, I got to say something, I got to do something, I can't sign on to this. What does that mean for the existing reforms and whether or not their intended effect on the system is going to be cut back or continue?
Well, look, we've now had 2 rounds of this subsequent fight from the 2019 reforms, and we have drawn a hard line. There was a problem we all identified. Even our opponents on this issue agreed that there were problems with the system that has existed in 2019. We are committed never to do anything to take us backwards from there, and that's why this dangerousness question keeps coming up. Imposing a dangerousness standard when we've never had one, that would be like rewinding to 2019 and go backwards in time to make things more regressive instead of more reform-oriented. So to the extent people want to keep having that conversation, they can. They bludgeoned us with it in 2020 in our campaigns. Ron Lauder spent $5 million trying to beat up our candidates. The PBA in New York City spent $1 million in Nassau County in a race to try and beat us, and we came back with a supermajority. So obviously it's a different political climate now. We could talk about redistricting another time, but we don't know what our lines are going to be just yet. We'll do our best to make our cases. We always do, but that's our system. That's democracy. I think money is too influential in our democracy, but nonetheless, we fight the fights, and we've been pretty successful in the Senate with a lot of opponents over the years.
What would you say to the many, well, there's a combination of scholars and students and activists and other people who have some influence and want to be part of this conversation going forward. What would you urge them to do to become part of this?
Well, there's a number of organizations that are involved on this issue, and I'm sure John Jay can point people to the right ones, but we have, and I don't want to pick individual ones I would direct people to because there's so many good ones, but if someone wants to reach out, we can, and I'm sure John Jay could do this too, point them to any of the multitude of advocacy groups that are working on this and other issues. But there's not not a dearth of them. There's lots of them.
You know, one way to interpret all of this, I wonder why I never hear, or I haven't heard more from you and some of your colleagues. It's like, this didn't just fall out of the sky. You all were duly elected. I couldn't introduce you because of the current circumstances as the senator from, you know, some set of neighborhoods to be determined. But if this reflects the supermajority will, as expressed through the voting system, you know, despite the amount of noise or intensity or arguments made by other people, you, I think, probably have some basis to say, this is what the people of New York said that they wanted. They elected us. We went through at least one election from the time that we started talking about this in 2020. We're going to have another one. Will you feel like your efforts have been ratified if you come back with a supermajority next year?
Well, I think our efforts have been ratified by coming back with a supermajority in 2020, because we had the kitchen sink thrown at us on this issue specifically. But again, I try not to get too worked up about it. This is our process. This is our system. People get to run against our candidates and make whatever argument they think works. We defend what we've done, and the voters have the final say. And so we'll do that again. We've been very successful. We have the largest majority in the history of the New York State Senate right now. And so I think we're doing something right that the voters appreciate in order to kind of get into that place.
Okay, that brings us to the end of our time. Thanks so much for a great conversation.
Thank you, Earl. Thank you, everybody.
Okay. Okay, very good. Okay, we're going to move forward with what has been described as a lightning round. I don't know if that's necessarily the way it's going to feel, because we're going to have so much substance and so many great ideas moving quickly through this room. And we certainly welcome as well everybody watching on the live stream. What we're going to do is have a series of various stakeholders come and share some of their best ideas about where things stand on bail reform and where things need to go. And we'll talk for a few minutes with each of them. And then we believe, if timing works out, we'll have a chance for me to ask some questions and maybe probe a little bit into some of the ideas that they want to bring forward. So we'll follow, I guess, our legislative sort of baseline with some ferment, a lot of different ideas, and then you'll get the factual. In the second plenary, you'll hear more about the sort of the facts and where they're taking us. So first up, we're going to hear from people on very different sides of this issue, from very different perspectives. First up, though, we're going to hear from Jim Quinn. He's a senior executive district attorney in the Queens District Attorney's Office, or he was for a long time under Judge Brown. And he's got some things to tell us from his perspective about where things are. Oh, there he is. Come on up, Jim. Good to see you. Thanks for being here.
Thank you very much. Nice to be here.
Yes. Well,
Nice to be anywhere, actually.
Well, something I've mentioned as I often do on panels is we urge people to talk not necessarily from their professional title or what position they're expected to take, but just as a New Yorker, somebody who's thought about this stuff and has a great deal of expertise. Where are we on bail reform, and what are some things that you think needs to happen?
Well, I think, first of all, you're going to hear from me what you're not going to hear from any of the other panelists here in this lightning round. I think bail reform was a terrible mistake. And I think it was based on a bunch of false assumptions, first of all. It was based on the notion that the people on Rikers were there for minor offenses with minor criminal records simply because they couldn't make $500 bail. It's not true. The people who were on Rikers charged with non-violent felony offenses or misdemeanor offenses had an average of 15 prior arrests, 8 of them felonies, 7 of them misdemeanor, and 2 failures to appear. That was the population that was the target of the bail reform. Those were the ones who were going to be released under bail reform. When bail reform was passed in April of 2019, there were 7,800 people on Rikers Island. By January 1st of 2020, that population had been reduced by 2,000 people all at once. And all the people who were released were almost every drug dealer in New York City, almost every car thief, every burglar, a lot of robbers, anybody charged with grand larceny who was only in on bail. They were all released at once. And what happened, once those people were released, crime in New York City started its rise. As of November of 2019, before those people were released, crime in New York City was down 1.7%. 2.5 months into bail reform, crime in New York City had gone up 20%. And it had gone up in robbery, went up 18%, felony assault went up 10%, burglary. And you got to remember, every person charged with burglary was released from Rikers Island by January 1st of 2020. Burglary went up 26%. Grand larceny, every person charged with grand larceny was released from Rikers Island. Grand larceny went up 15.8%. Auto theft, every person charged with auto theft, auto crime went up 68% in just the first 2.5 months of 2020. And that's after crime declining in almost every one of those categories in all of 2019. The fact of the matter is that bail reform has been a disaster for New York City. I know there's a lot of talk about how it affected violent crime. The crime that really got affected in New York City was the nonviolent crime and the petty larcenies and the misdemeanors have just been increasing in New York City because of the people who are released.
And what does that mean for public safety?
It means that more people have their cars stolen, more people have their houses burglarized, more people have their telephones stolen while they're sitting in a restaurant, more people have their kids have their telephones stolen from them on their way to school. It has an enormous impact on public safety. It has an enormous impact on the quality of life in the city. Now, you know, another thing I wanted to get to, I don't know if you're going to ask me the question, but I've only got 5 minutes, so I want to get it all out.
Have you say, absolutely.
There's a lot of talk, in fact, State Senator Cousins says that only 2% of the people who are charged with a crime get rearrested for violent crime in New York State while their case is pending. Now, that is technically true. And there were 284,000 people arrested in the 18 months of the bail reform. And I think it's 5,600 of them were arrested for violent felony. And that is true, and that comes out to about 2%. But what you have to understand is that the people who are impacted by bail reform are the repeat offenders charged with nonviolent crimes. Those are the people who were released. It is not that the person is arrested for shoplifting at a Duane Reade for the first time. Bail was never set on those people. Even the second or third time, bail was never set on those people. People charged with nonviolent felonies very rarely had bail set on them unless they had extensive records or failures to appear. That is a fact. So when you look at the people in New York State who are in what's called non-monetary release, which is, you know, under the bail reform, the state set up a system where a judge, if a judge found that a defendant was likely to not appear, the judge could order him into non-monetary release, which means that the judge would set conditions on his release. It was essentially to replace bail. And if you look at the defendants who were put into non-monetary release, now judges found that they're at risk of flight, and you look at those defendants who had prior convictions or a pending case, those are the people that would have had bail set in 2019. Judges would have set bail on those defendants. The recidivism rate on those defendants charged with burglary in the third degree, which is commercial burglaries, was 70%. Grand larceny, 70%. Robbery in the third degree, 70%. Robbery in the second degree, 46%. Criminal contempt, 65%. Criminal possession of a controlled substance in the seventh degree, 47%. Petty larceny, 79%. 79% of the people put into the non-monetary release program got rearrested while their case was pending. Menacing, 46%. The bottom line is that bail reform, whatever you want to say about the old system, The criminal justice system in the past brought crime down 76% in 27 years. It brought down the population of Rikers Island by 60% during that time. And yet we're constantly told that the criminal justice system was broken and it had to be fixed. This is not a proper fix. It is endangering the people of the state of New York. And the statistics, if you look at them honestly, not looking for a way to justify your position, but look at them honestly, it shows that the bail reform laws and the people who have been released under them are committing the crimes that are causing the crime rise in New York City.
Okay, before I let you go, because we are out of time, but no, that's fine. But what would be the proposed fix? I mean, to talk like a lawyer for a minute, even if everything that you say is true, if the legislature in its judgment and the public, which put them there, has said, you know what, as awful as the outcome might be, a repeat shoplifter is better than somebody rotting in Rikers Island for $500,000 a year. What would be your answer to them?
Look, first you have to decide what is important for the city. Is it important to keep the streets safe? Is it important to protect people? And if you come down on that side, you have to say that we have to have a system that allows a judge to look at a defendant and look at his record, look at the crime he's charged with, look at the evidence against him, look at his background, and determine this individual is a danger if he's out on the street. And whatever you want to call it a dangerous standard or the risk of reoffending standard or whatever. I am remanding this defendant because he is a danger to society. Mm-hmm. And there's really, if you do that simply, it takes away all the arguments about poor people get kept in jail and rich people get out. It offended me as a prosecutor that Harvey Weinstein was outed, pending his trial.
Sure. I mean, that same standard, do you think would have applied to Harvey Weinstein?
Of course.
Yeah. Okay, very good.
All right.
Thanks a whole lot.
Thank you.
Okay. Okay, our next person is going to be, I think Alice Fontier is next, the Managing Director of the Neighborhood Defender Service of Harlem. Good morning, how are you? Yeah, exactly. How are you?
I'm okay. Thank you for
Good.
having me.
Yes.
Glad to be here.
What do we need to do?
So I'm trying to reduce my emotional response to what I just heard. In the last 17 months, 20 people have died on Rikers Island. 20 deaths in 17 months. That's pretrial custody. That's pretrial custody in New York City. The boat, the now defunct Tombs, Rikers Island, these facilities, over many years of dysfunction, have become nothing short of a torture chamber, where people are consigned to languish for months, for years, waiting for trial or death. And death comes faster. And many of those 20 people chose their own death rather than sit in pretrial custody in this city. So let's go back and talk about bail reform. The goal of bail reform is now and always has been to reduce the number of people who are held pretrial in this state. By that standard, bail reform has worked and is working. Every time we roll it back a little, it works slower, but it's working. About 10,000 fewer people across the state each year are held in custody pretrial, post-bail reform. 10,000 people a year. 10,000 people who are free to go home to their families, to go to work, to go to school, to seek treatment if that's what's needed. 10,000 people a year who are free to live. And I mean that literally, free to live. Those are the stories we should be hearing. The 30,000 success stories is what we should be talking about. Every single family who had their loved one at home should be on this stage talking about how their lives are stable, how they're succeeding, and how bail reform helped them. But we never hear those stories. We never do. Instead, what we hear are these public safety statistics, which are supposed to be honest. But let's talk honestly, please, let's talk honestly about the facts and the statistics. Prior to bail reform, 95% of people who were awaiting trial did not get rearrested. Post-bail reform, and each year post-bail reform, 96% of people who were awaiting trial did not get rearrested. It is just not true that bail reform had any impact on rearrest rates. It is a false statement. It is a false statement designed to scare you, to raise fear, and it is politics and nothing more. The discussion about bail reform has not been based on any facts, on any data. It is about fear and about scaring you. And most recently, the tropes are about gun violence and an increase in gun violence somehow being related to bail reform. There is just nothing true about it. The bail reform as enacted in 2019, as still in effect now, largely left gun cases untouched. If you are on the street with a loaded firearm, you are going to jail. It was true before bail reform, and it's true now. And what we have seen is that judges are reacting to bail reform and increases in gun violence by setting higher bail. So people who are arrested with a gun are held in custody on bail they cannot afford, and they stay there for months or years until they take a plea or go to trial. That is what is happening. So connecting gun violence to bail reform is false, it is misleading, it is designed to frighten you. It is designed to frighten the legislators. And it worked. I'm sorry, I want to just keep going for one moment.
Sure.
What we have seen is this fear-mongering and scare tactics work. Senator Gianaris is correct. We managed to have a supermajority of Democrats despite this, but people have paid the price. And people are not investing millions of dollars in these scare tactics and fear-mongering because it doesn't work. And in our political cycle, where every legislator is up for re-election every 2 years, it means that they are constantly campaigning. And so the New York Post headlines blaring about crime stats and claiming that it has something to do with bail, let's have an honest discussion. John Jay has put together an incredible group of people today. And what my hope is that the discussion today is honest. It is truthful. It is based on facts. If you are someone who opposes bail reform, if you think it was a terrible idea, I ask you to admit that what you want is for people to be incarcerated pre-trial, and you are not concerned about the deaths on Rikers Island, that you are not concerned that the people who are incarcerated are overwhelmingly Black and brown, and that a dangerousness standards doubles down on the racist impact. I want you to admit that and defend it with facts and not with fear. And that is what I hope for today, is that we have an honest discussion.
Let me just ask you real briefly, if we take as fact, let's put aside the gun crimes, things that I think there's broad consensus, nobody wants to see any of that. If some of the statistics we heard from Jim Quinn are true around, say, auto theft, around shoplifting, around repeat offenders on the misdemeanor side of the scale, and it has enervated the public, the voters, enough that they've gotten the attention of elected officials, including judges. Let's not forget judges are also elected, which is where the dangerous standard will start to sort of feel some of that same political pressure ultimately if it were enacted. What should be done about that?
So it is the crime stats that have gone up. As Senator Gianaris pointed out, across the country, crime has gone up. We talk about in New York bail reform as if that's the thing that did it. It is not true that on the day that bail reform was enacted, 2,000 people walked out of jails across the state and started committing crimes. 2,000 people walked out of Rikers. It's not true. But what is true is that in 2020, a pandemic started and our economy ground to a screeching halt, and people had lost jobs, were stuck into crowded conditions and homes getting sick and dying. Those things are true and may have an impact on crime rates.
Okay. All right. Thank you very much.
You're welcome.
All right.
Thank you.
I'm putting the lightning in the lightning round. Thank you very much.
Charlie Billups is next up, the chairperson of the Grand Council of Guardians. For those who don't know, the Guardians is an association of black law enforcement professionals, sort of the home I grew up in. Good to see you. Good to be seen. How you doing? Good, good. Very well, thanks. Okay, what have you, and I should also mention that, I mean, you know, Guardians have a different perspective on a lot of this stuff. You are an association of law enforcement officials, but there are a lot of law enforcement organizations that go in a different direction or reach different conclusions than you do.
Yeah, true.
So tell us about bail. Where are you?
Well, in the idea of the Guardians, the different fraternal groups, it's somewhat of a crossroads. It's like going both sides. Because keep in mind, our organization is community-based. We are here to represent the people too, also where we live at, in these same neighborhoods where we work at, from the different law enforcement agencies. But then on the other hand, we have another outlook of it too, also dealing with the rating crimes, as Mr. Quinn talked about earlier. But the key thing to all of this right here is that, I'll take it back to the bail reform, how I feel, is that the main part to all of this right here, when they created all of this, and not to knock what they did, but it could have been done better. That's probably the best way I would say it, because there was key mechanisms and key people that should have been part of the conversation when this legislation was being put about. Because the thing is now is that we want to see people go home. We want to see people, if they get locked up, depending on the crime now, which is key. We're not talking about the violent crimes. We're talking about the lesser ones, as Mr. Quinn talked about. Those are the ones we need to focus on the most. The saddest thing about that is now when people get locked up, and let's say, I'm taking it from the very beginning. When a cop or a police officer arrests someone, they take them to court. Right then and there at court, it should be some kind of mechanism or something in place where they can determine what the issue is and why the crime was committed, more versus just locking them up and putting them on Rikers. And it's beyond what it is for Rikers. It's about what treatments or what resources that are being allocated to the individual. I mean, whether it's dealing with mental issues or social issues. It could be a problem where a person is having mental problems. He should have been diagnosed the moment he came into court. And then they should have determined whether he goes to Rikers or to a hospital for treatment. Now, let's look at the other side of that, where you got people who are dealing with social issues, whether it's job, financially, housing, rent, whatever those items may be. Nobody never talks about those. Now, and then I'll flip back to the other side. Now, as a law enforcement, we mentioned parole earlier. I remember when the senator had mentioned about parole. It was a deep conversation I had with parole guardians. I have members in the state parole. And they felt that because of the new standard they're coming out now, is that with the parole violators, the way it's set up, it's like a 3-strike rule. I mean, you out on parole, and depending on what you was, if you committed a crime, depending on what the crime is, you don't go to jail. You literally go home. You get out, and then depending on what the second charge is, if you get arrested again while you're out on parole, is determined if you stay in for a short period of time, whether it's 5, 10, 15 days, and then it goes to the 3rd strike. So it's a lot of language that's being put in there, but it's not really defined the way it should be. And then I'll look on that on behalf of officers or police officers, which a lot of my members are. So the thing is now is that it's somewhat of a hurting feeling when we get a call from people where we live at in our neighborhoods saying that this particular person is constantly committing a crime. So the issue is now is that how do you deal with it? Most of the cops are not psychiatrists. They're not counselors and stuff like that. They do their job. But then after a while, it becomes hurting to see the repeat offenders constantly doing it. So you get that part to that too also. So now it leads back to where the conversation should be back at the courts to determine how can we fix this. I feel, from my own personal opinion, is that when this legislation was formed, they should have brought in right-minded law enforcement people to at least give an idea of what was necessary or the pieces that should have been mentioned or put in to fix things.
Were you all invited in to testify?
No, we weren't.
I see. Okay. And it sounds like what you're saying is that you want on the front end, really almost as soon as arraignment, for there to be a range of analysis and possible
True.
pretrial
True.
diversion.
True. That would
services?
determine. I mean, that would determine. That would determine the numbers on Rikers. That would determine the person if they need mental issues or they need mental help or whatever resources that can be allocated. The saddest thing about the legislation, they didn't put in any kind of resources for that.
Right, right. Well, I mean, would your recommendation then be that they do so? Because changes, this is a fluid situation, right?
It's a great need for it. It's a great need. I give you a good example. Right now in central booking, in most of the courts or the arraignments, when a person get arrested and if they injured, they're being seen by EMS, and then they are forward to go to the hospital if it's a real physical injury. Those same kind of resources should be put in place if a person have mental issues.
Got it. Addiction treatment and so forth.
True.
Yeah, got it. Okay, very interesting. Thanks very much.
My problem.
More food for thought.
My pleasure.
I am liking this lightning round. Kevin Sylvester is the chief of police of the Ossining Police Department. And having grown up in New Rochelle, I'm familiar with Ossining and the southern, close-in Westchester suburbs. Good to see you, Chief. Thanks for coming.
Thanks for having me.
Yes. Bring us your perspective on bail reform, some things that we either need to know, some things that need to change in the law, and how it's affecting your town.
Sure. So first, I just want to start and say I'm not here to argue one side or the other in this. I think that's the biggest problem we've had with the legislative process. The gentleman mentioned not being invited to the table, and that's something that the state chiefs has really been big on. New York State Association of Chiefs of Police is getting that invite and being able to be a part of this, not necessarily to have our way. I'm not a member of any association that spends money on elections or anything. We're simply a bunch of law enforcement professionals trying to make a difference. If I can offer one thing to the conversation, something we're advocating for is the removal of cash bail altogether. We would love to see a situation where the bench has the opportunity to make a decision, and if the remand has to happen based on the standards the legislature sets, then that's given. Because the reality of the situation is, I've been doing this for a number of years now, and what I watch is judges walk in and say, can you make this amount of bail? And sometimes they're setting bail. If you say, can you make $500 bail, and the person says, yeah, but this is somebody in poverty, that's very different than you or me walks in and says $500 bail, and we're career people, and that's not going to stop us from eating this week.
Right.
So it's not just about the people that we're putting, and with all due respect, Rikers Island isn't an issue for me necessarily for my agency, and a lot of what's been talked about is New York City. When I talk about criminal justice and the issues affecting my community, I'm in a majority minority community and surrounded by the ultra affluent. I live in my community. My kids go to public school. This is very, very, very personal to me. The people I arrest, I know by first name, and I see them in the grocery store on a daily basis. I want to see everybody go home. I want to see everybody successful. I didn't come here to debate statistics, but I will say I agree that there's a very small percentage of people reoffending. That's the ones we really need to focus on. If there's really people that we see, the biggest problem in my community is not gun violence, and I understand that's an issue in New York City and it needs to be addressed. I've got 2 or 3 people that I can tell you by first name. One of them was in my 7th grade class. We let them out, they're reoffending before the day's over. And they tell us, I'm going back out and doing it again. And unfortunately, they're at a place in life where they need treatment, they're not willing to get that help, and I'm not really sure what else we can do as a community. I completely agree we need pretrial services. Much of this problem will be solved by community building and not necessarily by whether somebody goes to jail or not. So, my passion is really not necessarily in the issue of who goes to jail. I've never celebrated arrests or numbers. I probably haven't made as many as most of my colleagues. But my successes have been in the kids that didn't end up in that arrest or made that first arrest and rebound from it.
Sure. Well, it's interesting because, and something I think everybody, Jim and everybody else would agree on, is that there's a relatively small universe of people that we're talking about. And you're saying, like in your case, you actually know them by name. I participated in some of the efforts that they were doing in Kings County DA's office about a decade ago, where they would bring people in. They would bring in people and be like, look, we know who you are. And we're not going to arrest you today or anything like that, but on this wall are our prosecutors, and on the other side of the room are social workers, teachers, therapists, addiction treatment. Just pick which side of the room you want to be on. I mean, is that compatible with this conversation about bail, do you think?
I really hate this idea of walls and sides and different things. I really try to preach to the kids in my community and kids, young adults, right? I feel like I got old enough
They're
to say
kids.
that
They're
now.
kids. Yeah.
They are kids. That was more a statement on my own age at this point. But the kids that I really love in my community are kids that are getting themselves into either in trouble or not productive or whatever it is. Some of them are just failure to launch, right? And they're not getting out of mom's house. And we're trying not to say the prosecutor's over there and the help is over here. It's, hey, we're all kind of here together. So one of the things we do in our community is block parties. Well, we'll bring in resources and trick people in with food and introduce you to things like that in an effort to avoid those situations. I mean, ultimately, yeah, the speedy trial thing is a huge deal. Nobody should be sitting in jail for a year waiting for anything. Nobody's for that. I don't want to see anybody go to jail. I'd prefer nobody goes. I think there are a very small percentage of people that are determined to get out and do it again for mental health reasons, for addiction issues, for whatever those things may be. That's the narrow group that needs to do it. In terms of how the legislation has gone, I think that it's overplayed at this point. I think that we've overcomplicated the wording in all of the statutes to a point where I don't know where to go from here. But I think that's what happens when you get a hotly debated topic, and it's going to be really difficult to find what's right.
If one of my colleagues in the media came to you and put a microphone in front of your mouth because there was a case in your jurisdiction where somebody who was out on bail and was a repeat offender did something terrible, what would you say?
It's tough. It really depends on the circumstance. So in law school, they told us the answer to everything is it depends. So there you go. It really depends. My policy in my department, I do all of our public information myself. It's something I'm very passionate about. I don't release mugshots ever. I think maybe one for a homicide was the only one I put out. I don't release names of anybody. I'll mention that you're how old and from what community, perhaps, in order to help people understand that it might have been somebody coming from somewhere else that did this, or that it's one of our own neighbors. It's something that irks my residents because they'd like to know who the people are. But in terms of your criminal history, the fact that you've offended in the past, unless that prior instance is related to the current one, we're not talking about that. And, that comes from a place of love because I was trying not to weave this one in. There was a kid that grew up in my community who became one of my best friends, and I sat in the hospital and held his hand while he died from violence in the street, and it was a situation he put himself in. As he began getting in trouble as a teenager and young adult, I looked at the situation and said, I don't want people to know who this is. I want him to have his chance. He will get past this. He's going to kick this habit. He's going to find his way. He's going to get a job. Everything's going to be okay. And for him, it wasn't. And, I still spent a lot of time with his friends, but it's really meaningful to me that we've got 25, maybe 30,000 residents. If you get arrested here and I stick your picture on Facebook and 12,000 people follow me, you're never coming back from that. You're never getting a job, primarily because in a low-income community, these folks don't have access to transportation. It's 2022, and I know kids that their family hasn't had a car in generations. And public transportation is not what it is in the city. It's tough.
Right.
So if I put your picture out there, I put your name out there, you may not get a chance to get another job. So to me, it's that, right? This is so much deeper than bail or no bail. I mean, I understand that's why we're here, and that is a really meaningful issue, but I think that people have to look at the totality of this issue and say, what else are we doing? So I didn't put you in the jail. What else am I doing during that time to try and help you? Are we sending out, Westchester starting mental health crisis teams now? We're going to have one embedded in our department responding on calls with the cops. Are we sending people for follow-up after somebody has an incident, arrested or not? Are we reaching out to the kids that we know are most likely? Are we talking to, do our schools talk to us? Are we talking to our schools about, I know right now my 8th grade class is very challenging, and in 3 years we're going to have a bit of a problem if we don't do something now. So what are we doing? We're investing in the 8th grade. Wow. That's where we're putting our time and energy. I think that this is community building, and that's really where this gets solved. I mean, we can talk about bail, and I think that with adjustments, eventually we'll find our way on this issue, but I think that if we don't look at the totality of this, we're gonna miss this altogether.
Okay, thanks very much, Chief Sylvester. I'm not the only one thinking, it's like, how do we get him into the NYPD? Maybe get him down here in the city or something. Thanks a whole lot. Latrice Walker is here with us, one of the mothers of bail reform, I would say. Great to see you.
Thank you, Harold. It's great to be here.
Okay. As we've been going through this lightning round process, we invite people and give you 5 minutes to introduce some ideas that you think we need to focus on, things we need to know, changes perhaps to either the process or the law itself.
So, Harold, I'll start with the end. Most recently, we made some changes to bail reform, which includes this statement about harm. But there's no place in the criminal law and the penal code that discusses harm. And so again, we're throwing in terms without any real definition. We have physical injury, we have serious physical injury, but there's nothing about harm. And then there's this conversation about theft of services. What really does that mean? Now, does it mean that jumping a turnstile becomes bail eligible and people should be incarcerated pre-trial because of that? And then there's a conversation about looking at all of these different factors of seriousness of the underlying allegations, which again are allegations. This was already considered in the 2020 iterations of the changes, where we could look at the history of a person's rap sheet, for instance. And so to a certain extent, some of it was window dressing. And I think it came on the backs of individuals who need the support of the state the most. Just recently, there was a defense attorney who had to defend someone for stealing toothpaste. And in his iteration at that time, he said, well, hey, I needed the toothpaste. And we did something that says, okay, well, we're going to exclude crimes of poverty. But what is that exactly? Because poverty permeates through every element of crime. And again, as most people know with me, the Constitution indicates that slavery was abolished except in the case of criminal punishment. And so when a person is subjected to a crime, they are returned back to slavery in the truest sense. And that's the conversation that we're talking about. This is a modern day civil rights issue. And when people recognize it as such, instead of talking about the fear mongering, then we're going to be able to address the real underlying issues. They need to put more money into cure violence, because we know that the safest communities have the most resources and not the most police officers. And quite frankly, I'm in search for truth and justice. And when people in law enforcement have these conversations, I want them to tell the truth, that there is no connection. Every serious study has indicated that there's no connection between bail reform and the rising crime, because crime has been rising all across the country due to this pandemic and people losing jobs, people not having access to mental health care or resources or their homes. These are the things. These are the things that are driving up crime in our community. And so I want them to stop making these determinations without any empirical evidence to support any of the data that they're talking about. And so
I've seen, I mean, we talked earlier with Senator Gianaris, and I've seen and talked with enough of you on and off camera to know that there's a certain amount of frustration that political facts come into existence, and then you kind of have to deal with them because that's the political reality, especially in the current election season. And this is really a nationwide phenomenon as well. To the extent that the pressure to make some kind of concessions, changes, rewording, tweaks, whatever anybody wants to call it, to the extent that that's in front of you, what's your inclination to push back against it, to do what legislators do, which is find a compromise? What do you think is going to happen?
So I have a zero tolerance on the implementation of a dangerousness standard. For that reason, I went on a 19-day hunger strike to make sure that we don't just take bail reform back to 2019, but take it to a place where it has never been before. Right now, they talk about these algorithms. What are these algorithms? The CJA asks a few questions. Where do you live? How long have you lived there? Where do you work? How long have you worked there? How many years of education have you completed? All of those questions go towards a person's propensity towards poverty, not dangerousness. And so again, we have to be concerned about the criminalization of poverty. And by extension, most people who are living in poverty are black and brown. And so maybe that's why there's a correlation between race and incarceration. Who knows? But either way, I will continue to fight back against that. One of the things that I will be doing is introducing legislation to define harm, to define what theft of services is, so that we can have a bill that our judges will continue to be able to understand. We gave them more tools in their toolbox than they had before, even though they were saying we need to give the judges discretion. They already had discretion, but they never had discretion to say, you need to go to a substance abuse counselor. You need to go to a housing counselor. You need to have support services for housing and eviction. And these are some of the tools that we gave them, but we have to put our money where our mouth is. And so we'll be calling on the governor as well to put the resources behind so that we can have our judges be able to lean on the community-based organizations that we know will help us in our ultimate goal of public safety.
It's startling to me to see that things like, harm or say harm to property, which is something I don't even
Yes,
remember.
how you harm a property? I don't know.
Well, I was going to say, I don't.
Sorry, property.
I missed that part in law school, right? But if it's there, it's going to generate some case law, and the definition will sort of evolve, and you all can put some shape to that as well. But
Right.
I guess the challenge is that takes time.
But the beauty in the way that our founding fathers set up this great country is that there's a separation of the judicial branch, the executive branch, and the legislative branch. And we must all work together, but we are checks and balances on one another. And I appreciate the judges leaning on the legislature to say, these are some of the things that we need to have. But when you go too far, again, we will continue to put forth legislation that will define this thing, that will also deal with public safety, but will also recognize that we can have public safety, but not at the consequence of our civil and human rights.
Okay. Thank you very much.
Thank you.
Last but not least in this lightning round, Akash Mehta is the editor-in-chief of New York Focus, and they, of course, have been covering this like all of the rest of us in the media. Here he is. Good to see you. How's it going?
It's going well, thank you.
Okay, let us know. Lay it on us. You got 5 minutes.
Great.
He knows what 5 minutes means.
Yeah, thank you so much for having me. So bail can, I'm telling you nothing new, bail can be extremely hard to cover. There's almost no subject that's more emotionally charged, and there's almost no subject where that receives so much attention, but where there is so much disagreement on basic facts and misinformation on basic facts. We've talked about a few of those, and I think the next panel is going to talk about a few more, including going deeper in the oftentimes counterintuitive relationship between pretrial detention and crime. We've talked about the legal purpose of bail and how that's been misunderstood. I hope future panels will talk about the often ignored requirement on judges to consider the defendant's ability to pay in setting bail, which they often don't. I want to touch on something else which can seem a little wonky, but I think has both major implications and I think has lessons for this conversation at large. And this is a lesser-known part of the 2019 reform law that had transformative potential but has largely not been implemented. And that is that the 2019 reform law, in addition to restricting the set of cases in which bail could be set, also in those cases in which cash bail is set, required judges to, in addition to setting cash bail and to setting, in addition to setting cash bail, they were supposed to set two other forms of bail. Traditionally, this is cash bail, insurance company bail bonds, and then a third form of bond, which is usually something called a partially secured bond. And these are bonds in which the family members or friends of the defendant acts essentially as the insurance company bail bondsman. And the family puts up a refundable deposit. Usually it's set at up to 10%. Judges usually set it at 10% of the PSB amount. And so the way this worked before bail reform, so before this was required in every case in which cash bail was set, is that, let's say cash bail was set at $10,000, the judge would also set the insurance company bond at a certain amount, and then the partially secured bond, when they set it, would also usually be set at the same amount as cash bail, so $10,000 again. And then the family member, the defendant, let's say they can't make a $10,000 cash bail, almost none of them can, but the family member might be able to scrounge up $1,000 to put as a deposit. And so when this was set before bail reform, the rate at which defendants could make bail increased by literally 5 to 6 times. And at the same time, the failure to appear rate stayed at pretty much the same. Mm-hmm. So people were returning to court just as much, but getting out far more often. Once bail reform went into practice, and this was required in every case in which cash bail was set, judges responded by jacking up the prices of this PSBs. And so now you have a typical case where if it's 10,000 cash, it'll be 60,000 PSB. And then the family might not be able to make the deposit. And in fact, I ran the numbers on this recently. In 1 out of 8 cases, the judge sets the partially secured bond at so high a rate that just the deposit is higher than the cash bail amount, which essentially means you're not
that's perverse, right?
You're not offering a PSB at all.
Right.
And so this is exploiting a loophole in the law to essentially not follow this part of the law. And that's largely, interestingly, that's largely because of, I think half of all those cases come from just 25 judges. At least I think that's the case in New York City. So for instance, Eugene Guarino here in Manhattan sets this deposit higher than cash bail, ignoring the intent of this law, exploiting this loophole in 94% of cases. And so this is an area where, and then at the same time, judges often, when families can scrounge up the amount for this deposit, judges often, and we've reported on this at New York Focus, judges often will reject the family member because they say they can't come up with the full amount of money. The legislature didn't authorize them to do that. It's a gray area. I'm not in the business of making recommendations to legislators, but I do think it's an important part of the law that has not been revisited, is not being implemented, and deserves some more scrutiny. I think the last thing I'll say on this is that defendants and their public defenders oftentimes do not know about this part of the law, even though if it was implemented fully, it could get them out at 5 times a higher rate. And so this is an area where I think we in the media have really failed in discussing this, in educating legislators who often don't know about this either, in educating judges, and in educating.
I am hearing about this for the first time, so I thank you for educating me. It's a reminder, by the way, that many judges are themselves elected officials. And have very different ways of interpreting the laws, including this set. So you said there are about 25 judges that are sort of using this differently than a lot of their colleagues.
who are most responsible. Yeah, and I do think across elements of this law, you see, we talked about it a little with the harm statute. You see, essentially what bail reform did was limited judicial discretion, and that's why you have that 10,000 figure of 10,000 fewer people incarcerated. And with the PSBs, we saw that there was offered a little bit of discretion, and some judges, certainly not all, used that discretion to essentially ignore this law.
Before I let you go, the challenge of trying to make this clear to your audience, how are you handling it when people sort of say, as they do, and it's an election season, so some of this is politically charged for a reason, where people say, XYZ happened and bail reform is to blame. And as far as you can tell, that's not necessarily true. How do you handle that? Because the sentiment and the political reality of it is true. The underlying statistics may be fudged, inaccurate, or frankly made up. But so you've got an element of maybe political truth
and statistical, doubt or question. How do you handle it?
I think there's a question of how do you respond to inaccurate statistics, and I think that's hard, and I think you just have to put it in context, and especially hard when there are, it is certainly true that there are incidents in which people are released from bail and commit crimes because after they're released from bail. I think one thing that journalists need to do more is put into context the larger number of cases in which people the ways in which pretrial detention can drive crime up as well. And and I think the next panel is going to talk about this, misdemeanors, which is largely what we're talking about. There's really robust data that shows that pretrial detention generally increases the rate of new crimes by 12%. That was based on a New York City study. And I think we need to both make that part of the conversation and then also highlight the stories. So we recently Sam Mellons, who writes for us, recently wrote a story about someone who left Rikers, was homeless, violated a protective order because he was bouncing around between his family members for a few weeks, didn't have a place to go, and so ended up at his former girlfriend's apartment, violated the protective order, was sent back to Rikers, and that is a case that illustrates how when you disrupt people's access to housing, access to employment, access to jobs, that also has to be part of this public safety conversation.
I've seen very little reporting along those lines, although a lot of the criminologists I've talked to have described exactly that. Maybe something that we do need to spend a little bit more time on. Thanks a whole lot.
Thank
Good
you.
to see you.
Thank you.
I think that brings us to the end of our lightning round. I will get off the stage. Thank you all very much. Okay, yeah, panelists. Mr. Quinn, Mr. Mehta, come on up. We have time for some questions, and there are some questions out there. Right, we have mics that will circulate. I thought I had run out of time, but we did not. We've got a good 15, 20 minutes here. If you have a question, you should signal. A microphone will be brought to you. Yep, Mr. Billups. I mean, I've got more questions. I'll ask them for you if you want, but put a hand up if you'd like to direct a question to any member of the panel.
You might as well fire away.
Yeah, really. Okay. Yeah, I'll get us started. I think I am most curious, Assemblywoman, about this whole question of making changes because something has to change. How would you characterize what just happened in the last session? Because there were changes made. The governor had insisted on them. And then right behind it, there were critics who said those changes were meaningless or those were symbolic, that they were only there for show.
Well, we watched circumstances where politics were more powerful than people. We saw a process that was hijacked with respect to changes which were proposed in the 99th hour as opposed to being in the governor's budget proposal initially or being in the 30-day amendments or at any other point, but instead they came 11 days prior to us having to finalize the budget. Many other things that we should have dealt with respect to healthcare, education, et cetera, were held up based on criminal justice reform. We were just saying that people needed to have access to discovery prior to the eve of trial, and that young people who are 15 and 16 years old just doesn't have the brain development, and the doctors and medical evidence shows that they should not be charged and or convicted as adults. And so it was a sad situation. We saw the fear mongering. Even though the police commissioner, the previous police commissioner, came up and himself testified at a hearing that there was no connection to people who were being rearrested for the shootings and bail reform. Despite the police commissioner's commentary, we still heard the fear mongering coming out of the police department, saying that there were serious connections. And so, again, we are still in search for truth and justice. This will continue to be a conversation that we will debate. But again, you know, I'm glad that we were able to make it through, but we are not done yet. Quite frankly, the day after the budget was completed, we had a codes committee meeting where there were Republicans who were putting repeal bail reform right back on the agenda and many other changes to bail reform right back on the agenda. And so we may have crossed that bridge on April 7th or 8th, but we still have a lot more work to do.
Got it. You know, Mr. Quinn, I want to ask you to, I guess, think about some of the politics of this, right? You gave a very, you know, sort of statistical, legal, prosecutors, based on your experience, analysis of what has happened in the months since the bail reforms were enacted. There are political people, there are politicians who are using some of that data, some of those arguments very differently, saying that, you know, this or that district attorney should be removed, you know, that the laws need to be changed wholesale, that a dangerousness standard needs to be enacted, although New York doesn't have much of a history of that. Do you worry about your analysis being used in ways that maybe goes beyond what you think the facts will support?
My analysis is based on facts. It's based on data that is available to everybody on the OCA website. Everybody can look at it, every state senator, every state assemblyman, everybody. What I'm concerned about is that the entire discussion about bail reform is not based on statistics. It's based on anecdotes, it's based on feelings, it's based on general principles, you know, that are on both sides, that are very difficult to debate. You know, and we're here talking about bail reform, but there are a whole series of things about the criminal justice system that have to be reformed. And you know, bail reform is just one part of the issue. That's why all my discussion points are geared toward bail reform. But there's also alternative sentencing reform. And you know, when I was in the DA's office in Queens, we had dozens of programs that we put people into. I'll give you one example of one of the effects of bail reform. When I was in Queens, we had a human trafficking court. Every defendant arrested for prostitution went into the human trafficking court. In that court, we had social workers, we had clinicians, we had psychologists who would talk to these people and try to get them out of prostitution. 400 cases in there. Once the police department stopped arresting people for prostitution, that court went down to 20 defendants. So it's not like prostitution stopped. It's that all those people who are getting treatment no longer get it. Another aspect of bail reform, you know, there's talk about how judges can mandate somebody go into treatment. Yeah, they can, but if it's a non-bailable offense, if they don't go into treatment, the judge can't do anything to him. He can't remand him. He can't put him in. He can set higher, you know, conditions. You know, you have to report, instead of reporting twice a week, you have to report once a week. But if he doesn't, well, then you say, okay, now you have to report every day. And he doesn't. He cannot put him in. The judges have lost all discretion and all authority in the courtroom as far as the defendant's actions while he's out on bail. And, you know, there are all sorts of issues. Now, I wish that, you know, we could discuss more of this in a more generic platform.
Well, it sounds like, among other things, you're saying that, you know, an arrest and an arraignment needs to be, should not, say in the case of sex trafficking, be the front door, right? I mean, if it takes an arrest to trigger all of this potentially good stuff that's out there, you know, we've got the wrong set of institutions dealing with a particular social problem.
But there was nothing to replace it. There was nothing there was nothing to compel them to go into treatment. There was a lot of the women in those programs, they didn't know where to go. A lot of them were foreigners. A lot of them were immigrants. A lot of them are battered women. Where do they go once they're out and they're no longer being brought into any kind of institution, any kind of institutional setting?
Sure.
And that's true with so many different things. The drug courts are losing people. The overdose rate in New York City has gone up. But we don't talk about that stuff. I mean, in New York City, because of the discovery reform, 80% of the misdemeanor cases in the Manhattan DA's office last year were dismissed. 80%. That's up from about 15 to 20% the year before. And it's the same thing in every DA's office in the city. They cannot comply with these things, and these cases are being dismissed.
My question is for Mr. Quinn. So I see a lot of your presentation was based on the fact that crime has increased because of bail reform. And I'm just curious as to what you think happened across the country, where states that did not enact a new bail reform, like what happened there? And a follow-up is, what impact do you think the economic devastation from the pandemic has had on the crime rate?
Okay, I never said that bail reform was the sole reason for crime going up in New York City. I said it's a substantial reason. New York City has always been an outlier with respect to crime. Crime in Chicago has been going up for years. Crime in other cities around the country has been going up for years. The numbers that I gave were numbers of the crime rate before COVID hit. They were the first 2.5 months of 2020, which the numbers that I gave ended on March 15th of 2020, which was before the city started closing down, before COVID became a factor. And in those 2.5 months is when crime in New York City went up 20%, just in those 2.5 months. Whereas in the year before, 2019, crime had gone down. And crime went up in every category for which defendants had been released under the new bail laws. Now, it wasn't 2,000 defendants were released on one day. Those 2,000 defendants were released between November and January of 2019. And in 2020 is when crime started going up. It's more than a coincidence. As a friend of mine once said, I believe in miracles, not coincidences. And you can't tell me that releasing 2,000 career criminals from Rikers Island in the space of 2 months had no effect on the crime rate in New York City. That just doesn't make any sense.
I definitely have a question.
Okay, yeah, I would, when you say crime rate, you mean the arrest rate, right? That's what you're talking about.
Sorry?
You're talking about the arrest rate in those months, right?
No, I'm talking about the crime rate.
Yeah, but then
The crime rate in the first 2.5 months
Right.
of 2020 went up.
Was there a question over here?
Thank you all for your thoughts today. I just wanted to ask maybe a point of clarification or just an expansion on something. We've heard a lot of talk about speedy trials, but we all know that most cases don't resolve through trial. So I'm wondering if any of you can speak to how bail reform has impacted plea dynamics and how negotiations take place for pleas.
Good question.
Thank you.
I'm happy to address it. It's a very good question, and bail, but it's answered both by bail and discovery, which has had the greatest impact on plea negotiations and how people are handling their cases. We have not seen an uptick but for the pandemic, in the length of time it takes to resolve a case in terms of negotiating a plea. Getting to trial throughout the pandemic has been basically impossible. They were shut down. But people are making decisions based on information. They are free to make these decisions not because they need to get out of jail, but because they are at home assessing the information that has been provided, the evidence in the case, and they are making informed decisions about whether they should take a plea or not. What I will say, though, is that the greatest impact of bail reform on pleas relates to misdemeanors. Because what would happen prior to bail reform is that a judge would either threaten or say they were about to set bail, and the person would plead guilty to the misdemeanor at arraignment, at the first appearance, with no information other than a complaint. It happened in one shift. If I was working arraignments, I would represent 10 to 15, 20 people in a day that would take a plea to a misdemeanor at arraignment in order to not go to jail. And so again, like when we talk about public safety as a whole, somebody who has been charged with a misdemeanor never was going to jail. but they were taking pleas to avoid it. And so you walk out with a criminal conviction, instead of just walking out with the ability to, assess services, determine whether or not you should take a plea or not. All of those things is ultimately how this has been impacted.
Can I also just add, too, that a lot of this is cultural, right? We've seen the movie with the Exonerated Five, where one of the young men, his father said, just talk to the police, and they're going to let you go home today. A lot of times there's a belief that if you take this plea, you're going to go home. And so people, of course, again, as you mentioned, want to be home. But there are also many prosecutors who utilize this time as a point of pressure to go on to individuals to say, well, you've been here already for 6 months. Don't you want to go home? If you take this plea, you can walk out the door today. And they'll walk out the door, right? Whether or not they are certain of their innocence or not. And then if they happen to be recycled back into the system, there are individuals who now want to look at that plea, whether it was for cause or not, that will now give them a harsher situation the second time around, even though fear and poverty and misunderstanding may have been the cause of the first and underlying plea. So it's very dangerous territory, we believe.
Okay, sir.
Yeah, thank you. This is actually a question for you, Mr. Lewis, and also for Mr. Mehta, which is, I think, as we see, and I think most of us can agree on, the vast majority of people who are released pre-trial go on to live their life, to be with their families, able to participate in society, and that it's really hard to cover that in the media. And it seems like the media covers much more the sensational, fear-mongering stories. So how do we do a better job of telling those stories so that the general public, who politicians react to, can understand the success of the bail reform?
Yeah, look, it is very frustrating and it is very challenging. I mean, the short answer, of course, because one version of that question is why are you guys always covering bad stuff and not good stuff? And the standard answer is, look, dozens of planes land without incident at JFK every day. Do you really want to hear about that? But when one crashes, you definitely want to hear about that. And that's just kind of the nature of the business. So it's a permanent kind of professional challenge. When it comes to this, though, we are understaffed. Local news is frankly understaffed. There was a time when there were courthouse reporters who were stationed in the courthouse all day, every day, got to know the cases, got to know the judges. It would be nothing, or I should say nothing, but it would be relatively easy to write up a story about a judge who at arraignment did something really interesting and creative. I happen to have a very good friend who's a neighbor who is a judge who did something like that, and I wrote about it because I thought it was really interesting. But that was just, I bumped into her on the street and she told me about it. I sentenced the guy to write an essay, and I knew the parents, and he didn't have any priors, and I know the neighborhood, and judges who do a good job like that, it's fantastic, and it goes on every day, utterly without notice, and it is our fault, I think, for not getting to it. I'm not sure what you would say, Akash, but we just don't. We are very, very shorthanded, and then there is, of course, that bias toward an audience that wants to hear about something that they absolutely need to know because it's a man bit a dog and not the other way around.
Well, the Post also in 2020 wrote a story that said that the New York City Police Department claimed that bail reform and recent jail releases had led to increase in shootings. But according to the Post's analysis, the NYPD's own statistics proved otherwise, that between January and late June of 2020, according to NYPD data reviewed by the Post, just one singular person released under the statewide bail reform laws had been charged with a shooting.
Yeah, no, I mean, that happens all the time, though. I mean, look, there are public and political figures who say things very earnestly. They look right in the camera. They practically swear on it, and it's completely wrong, right? Intentionally or not. I mean,
Errol, if I can just say something. Those 520 shootings, most of them, there was no arrest made at all. So it's not like 528.
But is that a problem with bail reform?
But it's not like 528 people were arrested for a shooting and only one of them had been on bail. And that statistic comes from a New York Post article that is not particularly an in-depth article of the statistics on shootings.
Now, I'm from Brownsville, And we have a huge problem with shootings, and we want to be safe. My brother was murdered at the age of 19, just steps away from our front door. So I get it. We need to do something about guns on our streets. But I believe that when we properly identify the problem, then that's when we can go at a solution. This scapegoating bail is not going to get us to the point where we need to be at with respect to shootings in our community. I'd love to talk to you more about it.
I would love to sit down and talk to you. And I'm not looking to scapegoat everything. What my statistics show that there is a finite group of people who are involved in the rise in crime in New York City, and it's those people who have to be dealt with. And the bail law, as it currently exists, doesn't do that. And when 70% of the people who are arrested for burglary in the third degree and released into the non-monetary release get rearrested, and that's being rearrested for a crime where there's only a 30% clearance rate. So 70% of the burglaries don't even get solved, but 70% of the people arrested for burglary in the third degree who go into that non-monetary release program get rearrested. And those are the people that nobody's looking to put everybody in jail on bail. Nobody's looking to take everybody and just throw them into jail because they can't, because we can do it. I don't know a single prosecutor who wants to do that. I don't know a single person, who wants to do something like that. But we have to look at this honestly. And we can't just sit here and say, well, your statistics are fear-mongering, or your statistics are, are this, or people are dying on Rikers Island. 45 people a year get murdered in New York City housing projects. Murdered, not suicides, not drug overdoses, but murdered. And we don't hear anything about that.
Yeah, good afternoon. My name is Roger. I'm formerly incarcerated, and I've heard, I just got here not too long ago, but I was hearing the issue about bail and discovery. Like, I'm a victim to that. Like, discovery has been law in most of this country for decades, and there has been no over court, none of that. So I don't know why y'all demonizing discovery and why y'all demonizing bail. Like New Jersey have bail reform. You know what I'm saying? And a lot of other countries have it, and it's good, is well intended, is good. I don't believe that if you commit a minor crime first, you're gonna go home and commit a major crime. That's not the case. You know what I'm saying? But especially about bail reform, what was happening before is that prosecutors was doing trial by ambush. They would come on the day of trial when all the juries already was picked, and they would give reams of paperwork to the defendant. How is that a fair trial where the lawyer cannot properly review the documents? He cannot go and do his own investigation to rebut what the prosecutor is saying? Like, how is that possible? And then you're going to complain about discovery as if discovery is something bad. That's really part, I always thought that was part of the 14th Amendment of the Constitution. You should have a right to defend yourself. And the only way to do that is to know the charges against you, to know what the police is saying, what the prosecutors is saying, what the witnesses is saying against you, and for you to be able to defend yourself. So my question to you is, why demonize these things that has mainly, like y'all have for decades targeted black and brown communities? The vast majority of people that y'all target are people that look like me. And last but not least, a former prosecutor last week, he came up to Albany and he stated that his colleagues, whenever they get a conviction, they celebrate inside of that district attorney's office, which is horrendous. Y'all prey on the poor and y'all abused us the same way police officers beat us up on the street and kill us like dogs.
You can answer or not if you want. We are at the end of our time, but I do want to hear about discovery reform. And you cited a statistic of a very large percentage of cases, I think in Manhattan, that couldn't meet the new speedy trial clock?
In Manhattan, it's 80%. I know that in Queens, it's about 75% of the misdemeanor cases. It's about 20% of the felony cases. It used to be about 5 or 6% of the cases would get dismissed in Supreme Court. And the reason is, when the discovery bill was first passed, DAs had 15 days to complete all the discovery. And they couldn't answer ready for trial until they had completed all the discovery. And if they didn't complete it within 15 days, there were sanctions that were going to be imposed against them. And the problem with that is that look, in reality, on misdemeanor cases, most defense attorneys know what the story is. Even on felony cases, they know what it is. I can't think of a single case when I was a prosecutor where I walked in and handed the defense attorney a pile of discovery material on the day that the case was going to start trial. And if I did, there's no judge in Queens County that wouldn't have given the defense attorney an adjournment to look at the material and excoriated me for doing that. And, you can have discovery reform that's reasonable, that gives DAs a reasonable amount of time to do it, that eliminates that time from the speedy trial clock, so that that is not counted against them in running their case to trial. The notion that prosecutors are out there just prosecuting people of color for the fun of it it's so shop worn. And you want to talk about fear mongering and just muddying up the debate. Do you know that in New York City, a black citizen is 28 times more likely to be shot than a white citizen? 28 times. 96% of the people shot in New York City are black or Hispanic. And 96% of the shooters are black or Hispanic. This is the reality that we live in. That's why there are more blacks and Hispanics on Rikers Island. It's not because of any inherent or systemic bias in the criminal justice system.
Let me ask you, Assemblywoman, and this will be the last word. Is discovery reform going to get a second look in Albany?
Well, we did make a few changes to discovery, and part and parcel in terms of how it happened was there was an issue that where the discovery clock was ticking, and prosecutors had to certify that they were ready for trial. But they had not delivered all of the evidence, and there were hearings after hearings after hearings that came to that determination. And after those hearings, if a judge felt like the prosecutor had not met its burden, then some of those cases were being dismissed on that basis. At this point in time now, with the changes that we've made, the judges are able to take a closer look at the underlying evidence which is necessary, and also to be able to determine if it's like smoking gun evidence. Is it something that's going to lead to a defendant being able to prove his innocence? And so there's sort of a balancing test that gets done. Prosecutors were at the table. Defense counsel were at the table, as well as advocates being at the table. And they all, from what I believe, walked away with a negotiation that they could all live with. And so we believe that we may be okay with respect to discovery reform for now. But again, I believe that as soon as we get back to business as usual, everything is going to be back on the table.
And are you concerned? Are you worried about that dismissal rate, the failure to sort of meet the speedy trial clock?
Look, we're lawyers, and we all learn that clocks are important in the law, and there's a reason for that, so that people can go on and continue to live their life if we're not meeting our burden. And it's always important to recognize that as Americans, we are innocent until proven guilty. And if a prosecutor is unable to make their case, that's their burden. And so, I believe in our system. I believe in legal jurisprudence. I love the law, and we all have to respect it and adhere to it, and not allow it to be bent in order to achieve some overreaching goal about a person's visceral response to public safety.
Okay, that is going to be.
Sorry, can I say one thing? About
real quick.
Of course. It'll be very fast. It is not true
that 70% of cases in Manhattan were dismissed because of speedy trial and discovery. A significant number of low-level offenses, misdemeanors, were dismissed in the time period that Mr. Quinn is discussing. But thousands of them were because marijuana possession is no longer unlawful. And then several hundred, probably more in the thousands, were declined to prosecute on consent of the prosecutor because they were outstanding desk appearance tickets during the pandemic when there was no means of having in-person appearances. And so sitting at a table with us, defenders in Manhattan, the prosecutors went through their list of outstanding cases and made the discretionary decision to dismiss those cases. It was not speedy trial. It was not discovery.
Okay. All right. Please join me in thanking our panel. Great discussion. Sure, we could take a picture. Although we've been videotaped here.
can you take your seats? For people watching, we don't see you, but we know you see us, and thank you so much for joining. All right, folks in the crowd live, please take a seat. All right. Folks talking, maybe move to the side. Thanks so much. Thanks so much. Okay, here we are. We're in our research-focused panel. We're going to be a little presentation heavy in this panel because we want to give everyone a chance to talk about some of the data on bail reform. We've got 2 panels in the afternoon that are going to be moderated discussions on implementation after lunch and on the relevance of racial disparities and of conditions in the jails to this conversation. But we're here, this is the research-focused panel. My name is Mike Rempel. I'm the director of the Data Collaborative for Justice at John Jay College. I'm going to introduce the panel. We have Sandra Smith, professor of criminal justice at Harvard Kennedy School. Aubrey, there you are, Aubrey. Aubrey Fox on the other end, executive director of the NYC Criminal Justice Agency. Olive Liu, who works with me. She's a senior research associate at the Data Collaborative for Justice. Jae-Yo Kim, associate director of research at the Vera Institute of Justice. And Jennifer Perrone on the end, associate research director at the CUNY Institute for State and Local Governance. Here's what we're doing. Sandra is going to kick us off because she has done research on bail reform nationally. So we're going to start by widening the lens. The other 4 speakers are going to then bring us back and share some of their key takeaways on the research in New York. We are going to make every effort to have time for Q&A. If you are sitting at home, you can participate in Q&A, but you're going to have to go to Twitter. Please tweet your question and use the hashtag NYBailConference, hashtag NYBailConference. Your question will be seen, and we will try to get to a few. If you're here in person, you don't have Twitter, there should maybe be index cards you can write on. If you have something to write on, someone will come around at the 45-minute mark, and we will try to collect your questions as well. Okay, I'm going to step back and do a minute of level setting, then I'm going to turn it over to Sandra. I know many of you watched the plenary. I just want to review New York's bail reform. What is New York's bail reform? What are we talking about? We're talking about 5 fundamental components that were put into the law. Number 1, bail reform is bail and pretrial detention are no longer permissible in most nonviolent cases. Number 2, supervised release must be available to judges as an option in every single case. But number 3, neither supervised release nor any other pretrial condition can be set unless someone poses a credible risk of flight to avoid prosecution. Number 4, even if there is a risk of flight, judges must use the least restrictive condition necessary for assuring court attendance. And number 5, judges, when they believe bail is the least restrictive condition, must still look at what people can afford before actually setting a bail amount. Okay, that's New York's reform, but as I said, we want to give a broader lens to the conversation, so I'm going to kick it over to Sandra on national research.
Thank you, Michael. Okay, there's a lot to manage over here. Let's see if I can do this right. Okay, so just to be clear, the research that I've done the research that I do, thank you, is primarily focused on the conditions of people's experiences in pretrial detention. So I study the conditions of confinement and also the impact that those conditions have on people. In order to understand that within the various contexts that I have studied the experiences of pretrial detention, I also have done this kind of landscape analysis with the assistance of an amazing research assistant that I have at Harvard, Isabella Jurgensen. And so I'm drawing from that, but also my work on people's experiences in pretrial to speak today, and look forward to the discussion later on about the conditions. So in 2016, several defendants filed a class action lawsuit against Harris County, Texas, for unconstitutional bail practices against people arrested for misdemeanor offenses. Specifically in O'Donnell et al. Versus Harris County, the plaintiff class accused the county of setting bail amounts so high that many were detained pretrial for no other reason than that they could not afford bail. To end litigation, the county agreed to reform its pretrial systems and practices to protect the due process and equal protection rights of individuals arrested for misdemeanor offenses. Among other things, the O'Donnell consent decree requires that most misdemeanor defendants be released immediately on their own recognizance, so without secured bail, that those ineligible for immediate release be granted a hearing and access to an attorney within 48 hours of arrest, and that when secured bail is imposed, not only should the amounts assessed be based on evidence of a defendant's ability to pay, but also that less restrictive conditions could not reasonably ensure that that person would show up to court for their hearings. The decree also established a role for an independent monitor to evaluate compliance, track the effects of new practices on relevant pretrial outcomes, and promote transparency by publishing regular reports on the progress of the decree. In March of 2021, 2 years after bail reforms were implemented, the independent monitor released a second of 2 reports. In it, they reported from analysis estimating the effect of bail reform measures and what those effects have on misdemeanor defendants' current and penal system outcomes. Specifically, since bail reform, while the average daily misdemeanor jail population has declined significantly, there have been no observed increases in recidivism rates among those released pretrial that would suggest a public safety threat. The report also addressed speculations about the effect that bail reform has had on spikes in violence. We've seen this across the country. The report says, as murders have gone up in Harris County, with this year's totals the highest in years, members of the public and public officials have understandably sought explanations. We have noted some public statements linking homicides to bail reform. However, we find no evidence that bail reform has led to an increase in homicides. And those who have asserted otherwise have not identified any data to support the assertion. Thus, the monitor's core findings were in line with the court's finding in O'Donnell that money bail does not meaningfully promote public safety or court appearance in court. There was a formal response by the Harris County District Attorney, Kim Ogg. It was swift and unequivocal. She criticized the monitor's recidivism-related findings and analysis. Based on her own office's analysis of the same data, she reports not only that bail reform led to substantial increases in recidivism rates, but also that increases in violent crimes were directly attributable to reform-related pretrial release practices. Speaking for prosecutors, for police, and for crime victims, she said, whose daily experiences were claimed to conflict with the monitor's recidivism findings, bail reform as presently practiced in some Harris County courts will continue to be a driving factor in the crime crisis gripping our community. Her message was clear. Harris County's bail reform experiment had failed. Money bail does meaningfully promote public safety and should be reinstated to promote the public, protect the public from further harm. So as a growing number, this I'm sure sounds very familiar to you, as a growing number of jurisdictions across the country have attempted to implement bail reforms, debates have intensified about the relationship between such reforms and crime, including and perhaps especially violent crime. Similar debates, for instance, have raged here in New York, where the backlash against bail reform has caused the state legislature to roll back key elements just 3 months after implementation. And now the governor has proposed further rollbacks to the law. So although largely driven by politics, these debates raise an important and timely set of questions. What role does pretrial detention and release play in producing or threatening public safety? Does pretrial release incentivize crime and drive up crime rates, including violent crime? Here you go, including violent crime, as many in law enforcement have claimed? Or, all things equal, is pretrial detention the greater risk to public safety? So here, we should probably think about how we're defining public safety. Typically, what we do is to refer to its protective function. What can we do to protect people from being harmed or from having their property taken or harmed as well? What I would argue is that we should take seriously an argument recently made by NYU law professor Brian Friedman. I think I've got the name right. Forgive me if I've misnamed him. Who argues that we need to broaden our understanding of what public safety is. And when we do that, we should include what it means to have people's basic needs met, right? And so when we think about the impact of pretrial detention, we're not only thinking about what impact it has on crime, that's incredibly important, but we should also think about what impact it has on the individuals who experience it and the communities that they go back to. So when we take this kind of holistic approach, we would come to a very different set of conclusions. But we should also define our terms in terms of bail reform. Here, when we think about bail reform, or when we thought about bail reform, Izzy and I, we thought about any policy change that was intended to reasonably, was intended to or could reasonably be expected to reduce the number of people detained pretrial. And of course, bail reform can do the opposite, but we were focused on making sense of these kinds of efforts in our landscape analysis. So what we find is that over the past, say, 20 plus years, a number of states, more than half the states in the country, have been engaged in some process of bail reform. In some cases, it's just, let's start talking about it. In other cases, it is much more substantial. It might look like what has happened here in New York or what's happened in New Jersey. So we see, so we see multiple, I'm gonna have to go off of my computer for a little while. We see multiple states engaging in efforts, and we also see an uptick over the last 6 to 7 years in states engaging in these efforts. Many of these state legislatures have engaged in these efforts after city and county level bail reform efforts have taken place. And so you see in Brooklyn and Queens efforts going on for over 13 or so years ago, but in the state we only see efforts over the past couple of years. So huge uptick in the number of states that are engaged in these processes. And you can see with this map of the US, the states that are engaged. I can't help but to do this, so let me go. So no reforms are found at all in these states where you see the lighter color bars. And that's relatively few states, all things considered. And they're kind of located primarily in the South and the Northern Plains. Some states are taking preliminary steps towards statewide reforms and so haven't done it yet, but are certainly engaged in the process. Here are the states with this lighter color that are focused, where efforts are largely rooted in what's happening in cities and counties, and so not so much statewide. Statewide reform efforts that have been implemented, but then subsequently limited or reversed. We know that that's happened in New York. It's also happened in California, and we have some moderate forms in a set of other states. But what this shows is a kind of engagement in most states, I would argue, across the country, but what that looks like differs significantly. The examples of the efforts that they're making, we could probably categorize, and I want to think about this a little bit more deeply, but in maybe 3 different categories, where they're changing presumptions and also establishing rights so as to protect individuals who have been brought into the system. So presumptions that people are innocent, presumptions that you will be released after your arrest and or released on non-monetary bail, that you have a right to counsel, as has happened in Harris County, that there's an expansion of procedural protections for you once you are brought into the system so that you can have due process, et cetera, and that those will be taken seriously. That also is a part of what has happened in Harris County. And that there's a removal of the presumption of detention for some crimes. We also see that a lot of efforts have been focused on essentially curtailing judges' discretion. Judges can't just do many of the things that they have tried to do in the past. Some of that is through the implementation of risk assessment tools. Sometimes that's in combination with judges' discretion, establishing guidelines for what judges can or must consider when imposing bail, limiting situations where judges can impose bail, the list goes on. And then in addition to that, there are efforts to really kind of focus on the needs that folks who are brought into the system have, expanding social services through pretrial services so that people have access, but also a serious consideration about the extent and nature of the use of bail, generally speaking. So I think it's a good time to start thinking about what these buckets are of reforms that we've been seeing, but they have made a huge difference to varying degrees in different contexts, and that is what I'd like to talk about at this point. So there were conversations earlier today which suggested that bail reform can be linked causally to pretty poor outcomes, not just in New York, but possibly other places. But apparently New York is also unique, so maybe there's something about this unique and exceptional context that makes it so that bail reform has had a particular effect here. What the overwhelming majority of evidence suggests is that bail reform has had no substantial effect on crime or violent crime in multiple contexts. One of the things we can look at, and this is of no surprise to us, is the extent to which bail reform has impacted unsecured release. You put in place bail reform, various kinds of measures. It tends to increase the rate at which people are released without monetary bail, without cash bail. That makes perfect sense. It also tends to reduce the size of the jail population. We see this happening in multiple contexts. I'm just giving you a set of examples. In New Jersey, a reduction of 35%, 26% in New York between 2019 and 2020. The statewide decrease has been about 31% and about a 33% decline in St. Mary's County, Maryland. In New Jersey, I should be very clear that New Jersey's reforms were wrapped into a whole set of reforms, not just bail reform. And so some of that decline is probably rooted in some of the other measures that New Jersey took. And so we should take that into consideration. It's not just, though, about the unsecured release and the size of the bail population. We also see the impact that bail reform has had on how long one spends in pretrial, generally speaking, the whole experience of it. So not just detention, but from the point at which they were arrested till the case has been adjudicated. We do see increases in the length of time that takes. But that makes sense, because if I'm not being encouraged to take a plea deal so that I can get out of detention, which has a set of harsh conditions of confinement that would make me, it would have a really negative effect on almost every aspect of my life. So I'm not going to do that because I'm out. I'm going to take the time, as someone said earlier, to assess my options. I'm going to take the time to participate in the advocacy of my own case. I'm going to take the time to figure things out before I come to a determination. That takes more time. So the length of pretrial detention, or not detention, the length of the pretrial period, we do see increase over a period of time. And this is a good thing, I think. The short period of time usually indicates that people are rushed into making decisions that in most cases don't work for them. But we also see an impact related on case outcomes. A significant decline in the percentage of people who are found guilty as a result of bail reform. Why is that? Well, because they're out, they're participating in their own cases, being able to assist in their counsel so that they can have strong cases put forward. And in the case of New York City, we also see a dramatic increase or significant increase in the percentage of cases that get dismissed. Time out to participate in your own case makes a huge difference. These are good things. And then we also see, this is the issue that is brought to us, the public, time and time again, dramatic increases in rates of crime and especially violent crime. We're hearing about the horrible deaths the numbers of deaths that are occurring in Black and Latino communities, which oddly doesn't seem to lead to investments in those communities, their institutions, community organizations, but does seem to warrant us investing so much more in these harsh conditions of confinement and other penal practices. What we see time and time again with every rigorous study that I have seen is that there's no statistically significant increase in the rate of new charges, generally speaking. And when we do see small increases, in most cases, those can be explained away by natural fluctuations or end up being meaningless differences. This is the case as well with regards to violent crimes. No evidence that bail reform is linked to increases in violent crimes. There has been an uptick. We should be taking that seriously instead of using bail reform as the reason for why this is happening. The other thing that we should also be talking about, and I didn't have much time to talk about here, is the positive impact that bail reform has had. So mostly what we're looking at is the impact on crime, right? The absence of the negative. Great. But what we're also finding is that in some contexts, bail reform is associated with dramatically increasing rates of employment among Black men, closing the gap that exists between Black and white men in terms of employment related to bail reform. This is a recent study that just came out of New Jersey related to their bail reform practices. So we're seeing improvements in employment as a result of this, which connects very well with prior research that shows that pretrial detention has a negative effect on employment in the short and long term. Negative effect on being able to bring in your own income in the short and long term, right? Which speaks to the issue of how we're thinking about public safety very broadly. Because if you give somebody a job that allows them that pays a living wage, you're very likely reducing the likelihood that they'll come into contact with the criminal legal system. And this brings us to the issue of racial disparities, which will be talked about a lot later. We don't see bail reform having a big impact on racial disparities, or not in the way that we would want to. In many contexts, it increases racial disparities, in part because even as you see overall individuals, their outcomes improving, it improves much more for whites than it does Blacks or Latinos, right? And so we need to figure out how to jigger these policies in such a way, or their implementation in such a way, that has a positive effect on Black and Latino folks as much as it does on whites. This is what's happening in Kentucky. This is what's happening in Maryland. My understanding is this is what's happening in New York too. But we have seen some decreases in Harris County, and so that is an important context to pay attention to. Declining rates or gaps, narrowing of the gap in people who are being released on bond. And so in the context where that is happening, it makes sense to study how it is that they're implementing and what the nature of that reform is, to understand how it could benefit Blacks and Latinos as much as it does whites. In terms of crafting effective and equitable practices or bail reforms, Isabella and I made a couple of recommendations in the paper we wrote on this topic, where we're suggesting that there's a presumption. There should be a presumption of unconditional pretrial release to occur within 24 hours of arrest. While unconditional release is in cases where it's not granted, it's important to require that these decisions on pretrial release be made within 48 hours. Why is this happening? And what can we do to get folks out as quickly as possible? This happens in the case of Harris County. Establish the right to an attorney at the bail hearing and throughout the process, where judges determine that release with no condition is insufficient. Require that the least restrictive conditions be met before applying cash bail. Pretrial release services must include providing text messaging to remind people of their court dates. Lots of evidence now supports the efficacy of this. It drives up people's appearance rates in lots of circumstances, and also provide wraparound services where needed. And then finally, include specific requirements for the collection, analysis, and dissemination of data. In most contexts across the country, the access to good quality data to make sense of what is happening, what kinds of factors impact what kinds of outcomes, is woefully inadequate. So for us to better understand what makes a difference, we need access to good quality data, and so each of these contexts should do the work to provide it. I will end there.
Well, I'll just start by saying thank you to John Jay and Ardell Ventures for inviting me today. And just a note about our panel moderator. Congratulations to Mike Rampell for his recent appointment to lead Data Collaborative for Justice. I couldn't help myself. So I'm going to try to do this a little more conversationally, but I will be showing you some pictures and some data from some pretrial dashboards that my agency, the Criminal Justice Agency, recently launched. And I think by way of context, what I want to say is this morning we heard, a pretty heated discussion at times with people with different points of view. But I think what stood out to me is a shared and sincere desire was for a trusted source of facts about what's going on with bail reform and our pretrial process of release. And I think that is absolutely a goal that my agency, by releasing these pretrial dashboards, of which there are 2 and a third coming, is trying to fill. And before I get into, I'm going to show you 4 pictures, basically, and tell you some stories based on the pictures about this process of what does it mean to actually create a trusted and shared source of data about bail reform. Just a quick note on my perspective and my role. So I have the great privilege of running the New York City Criminal Justice Agency. And one of the wonderful things about it is that we are both an agency known for research, but we're also an agency that provides pretrial services in New York City. So we have this dual role as both a researcher and a practitioner. And many of you may know this name. Jeremy Travis, our founding executive director, is the person who really encoded that combination of research and practice into our DNA, and we carry forward that today. So thank you, Jeremy, for that. I won't stop until everyone gets applause. Why did we do this work? I mentioned earlier that we wanted to try to provide a trusted source of information about pretrial release and pretrial conditions in New York City. But in some ways, the animating question for me was a really simple one. How many people at any given time are actually released pretrial in New York City? One of the things that I find really fascinating about sort of people in the know in criminal justice circles is that I bet most of you can get within 5 or 10% the question correctly: how many people are held in New York City jails right now? And we know the answer. Vera has a wonderful tool, the JailViz tool. Tells you there's 5,460 people yesterday held in New York City jails, of which 4,637 are held pretrial, right? Most people know that, I think, who are inside the system or knowledgeable of it. But what I realize is that no one really knows how many people are out awaiting the resolution of their case in New York City at any one time. That was the question I wanted to answer that started this journey of putting dashboards out. And as you'll see now, this is a live demonstration, right? You could actually go on the website right now and do what I'm doing. This is dangerous, right, if there's technical difficulties, but I'm willing to take the risk. So everything that I'm about to show you, you can do at home at nycja.org if you find our dashboards. So what does it tell you? In March 2022, a total of 40,323 people spent at least one day in the community awaiting their trial and pretrial release. And remember, that number of people in jail awaiting the resolution of their case was about 4,600. So obvious relationship between those two things. Judge arraigns a case, they can do one of two things. They can choose a release condition that either leads directly or indirectly to pretrial detention, or they can release someone to the community. So we wanted to bring a kind of human note to what does it mean to be in this community of people, not who are at Rikers or in jail, but who are actually been released in the community. And you'll see that in a sign, I think, of something that is quite healthy about our system. Ideally, you'd have as few as many people on pretrial release awaiting their trial. The number of people who, again, have spent at least one day in a given month on pretrial release has gone down significantly. In January 2019, you had over 57,000 people who meet that description. And in March 2022, you have about over 40,000. So that number has gone down. But one of the things that you can do with this data tool, which is actually quite powerful, is you can slice the data in a number of ways. And what we've seen, and I think people who are knowledgeable of the system will know this, is that essentially the bottom has fallen out of the system. There are far less people being released on a alleged misdemeanor charge than in the past. However, the number of people who are being released in New York City where the charge that led to their release is an alleged violent felony offense has actually gone up. So you have essentially, and this is sort of a meta theme of these dashboards, a changing pool of releases. It's not just fewer people, but a different profile of those people. So keep that in mind as we go through some of these slides. So, not slides, this is a live demonstration of the dashboard. Okay, so I wanted to point out something about the importance of pretrial practice in New York City. So I said earlier that there are about 4,600 people held in New York City jails awaiting the resolution of their case. Supervised release, which is one of the options that a judge has for releasing someone to the community, currently has, in March 2022, the most recent data that we have, over 6,000 people being supervised by supervised release. And Miriam Popper, who previously worked at MOCJ, who actually led the expansion of the program citywide, gets a lot of credit for this. We have a program called Supervised Release that is literally supervising more people while they're awaiting the conclusion of their case than are held in New York City jails awaiting the conclusion of their case. And I want to just pause on that for a second, and I'll return to it in one of the later things that I want to show you. I said earlier that I'm a practitioner and a researcher, right? So a lot of the debate about bail reform tends to take the form of, is it good or is it bad? That's not how a practitioner can see it. We don't have that luxury. The question that we face is, given the people that we have to responsibly help and serve and try to encourage better outcomes for, what are the challenges that we face? So we don't ask good or bad questions. We ask questions about continuous improvement, nuance, and being very honest about what are the challenges that we face and how do we respond to them. Now, when I say that, that does not mean that I have taken a side in the debate about whether bail reform is good or bad. It is that I think about it differently because I am a practitioner. And if I had one sort of hope for the conversation about bail reform is that we pivot away from kind of op-ed style, is it good or is it bad type analysis, towards it is what it is, for now, likely. How do we build a better system of pretrial release and pretrial infrastructure? Okay, so I said I was going to show you a couple more pictures. This one is an interesting lesson in what I call humility about how an agency like ours produces data and how that data is consumed. So this chart has gotten us, quite frankly, in a lot of trouble, and I'm going to explain why. So This chart tells you, of all the people in a given month released pre-trial, how often in that month are they rearrested? Our dashboards have gotten a lot of attention, a lot of media coverage, a lot of people have cited them positively and negatively, and this chart is the one that has gotten the most attention. It's the same thing that was cited in our earlier panel, when a panelist said, before bail reform, about 4% of people were rearrested during the entire pretrial period. Now it's 5%. Okay, that is both true and false. The data does show you that about 96% of people released in New York City in that month were not rearrested before bail reform, and now it's 95%. Those arrests are only counted in that month. It is not the entire pretrial period, okay? Small differences in any given month can add up to larger differences over the entire pretrial period. Now, I don't think anyone has meant badly in taking a data point that only pertains to 1 month and citing it as the entire pretrial period, but it should be said that that is an incorrect representation of the data. And in fact, and we will be following up with a dashboard in the future that will make this clear, we have actually seen increases in pretrial arrest rates while out on supervision over time. Very complicated reasons, very complicated story. Is this the be-all and end-all explanation for increases in crime? Of course not. But again, as a practitioner, we have to live in reality. And the reality is that the risk pool of the population that we are dealing with is very different. So I'm going to end here. I don't have much more time. I said earlier that supervised release has now taken on a much larger caseload of people. And I've also said that the risk pool of people being released pretrial has changed. Part of that is because there are fewer low-level crimes, alleged crimes that are being brought into the court system. But another issue is the simple question of how often do people come to court carrying a case with them? So you're arrested, you're arraigned in court, you have an open case already. So the question is there a change in the percentage of times that people who are being arraigned by a judge carry with them a pending case? And to skip over a lot of complicated criminology, having a pending case is itself a good measure of the baseline risk that you will be arrested again, right? Simple concept. So what I want to leave you with is this, I think, fascinating visual representation of the kind of challenges that supervised release is facing. Full disclosure, my agency runs the supervised release program in Queens. So January 2019, about 29% of people who were assigned to supervised release at arraignment by a judge had an open case that they brought with them. Today, that's about 50%. So supervised release is dealing with, in this rough and not totally precise way, but still important to remember, a riskier group of individuals. And so my concern about the nature of the debate about bail reform, is it good or is it bad, is where does that leave a practitioner who has to say, how do I improve the program? How do I continue to innovate? How do I engage in a process of trial and error when the nature of the people coming into my program are different? We're left on the sidelines, unfortunately, when the only choice we have is to say whether bail reform is good or bad. So I do want, and I hope this dashboard is used as a way for people to engage in themselves in a more problem-solving and thoughtful approach to a very complicated issue. And just to leave you with the last thought here, I said earlier that we're both a researcher and a practitioner. This is what people who do both, this is how people who do both of those things think. And it's a requirement, I think, for us to build a stronger pretrial infrastructure, which is what created the conditions for New York City to release more people than any other jurisdiction in the country before bail reform. That is the infrastructure and the confidence and the orientation that allowed us to get there even before bail reform. And I think if bail reform is going to succeed, we have to maintain that perspective and use data to inform practice. So, thank you.
Good morning, or afternoon almost. I'm going to sit because none of these are readily accessible. So I'm Olive, Senior Research Associate at the Data Collaborative for Justice. And earlier this morning, President Mason had mentioned that we just recently released our latest report looking at pretrial release outcomes in New York State pre and post bail reform. So today, I'd like to share with you some key findings from that report. Okay. So in this report, we looked at felonies, misdemeanors, and violations that were arraigned in 69 city and district courts throughout the state. So pretty great coverage between January 1st, 2019 and December 31st, 2020. So in order to kind of set the context for the rest of our analysis, we first looked at what was coming into the courts over these 2 years in terms of the total volume of arraignments. So what we found is, if you look at the statewide graph over there, there was a 38% decline in arraignments overall from 2019 to 2020. And New York City had experienced the greatest declines compared to upstate courts and suburban New York City, which includes Westchester, Nassau, and Suffolk counties. So substantial decline in arraignments overall. And with our data, we had the luxury of looking at arraignments monthly, and we found that there was a substantial drop, again, in arraignments in the first quarter of 2020, so from January to April. And this, I'm sure you've already figured out, coincides with the onset of COVID, the closure of courts, and also, of course, the original bail reforms going into effect in April. So that was the context. But our report really was focused on looking at changes to pretrial release outcomes. So what are judges deciding at the point of arraignment when a person who has been charged appears in court? Are they deciding to release that person pre-trial, whether by ROR, which is release on recognizance, or non-monetary conditions? Are they setting bail for these cases? Are they deciding to remand, or are they disposing these cases at arraignment? So this is really the crux of our report. And we looked at this by geography, by charge, and demographics, which I'll take you through as we go along. So here, kind of the overall finding is that statewide, there was a 10 percentage point increase in the proportion of cases being released at arraignment. So the top purple line there. This is at the state level. New York City had the highest rate of pretrial release, both pre and post reform. And this isn't surprising, I don't think, since New York City has had pretrial release services in place for a number of years. And compared to New York City, upstate courts and suburban New York City courts were more likely to set bail kind of across the board over the study period. So just a couple of kind of estimates that we made in our report. We wanted to estimate what would the outcomes look like had this increase not happened? So had this 10 percentage point increase not happened? So a counterfactual, if you will. And we estimate that more than 24,000 more cases would have faced bail or remand in 2020 without that increase. And considering that people are only able to pay post bail in 20% of the time where bail is set, we estimate that the reforms contributed to approximately 19,000 fewer cases that would have resulted in pretrial detention. So, looking at charge severity, we found that the increase in pretrial release was especially evident among felony cases, so increasing by, actually, I want to go back to the last slide, but I don't know how to do that. One last thing that I forgot to mention here is if we just pause on that purple line at the top for a second, you see clearly that the increase in pretrial release actually started as far back as January of 2019. So, and the increase was pretty consistent up to about April when, a lot of things happened. Okay, moving on. So pretrial release increased by 17 percentage points among felony cases, and a corresponding 17 percentage point drop in bail setting. So this is for felony cases throughout the state. And just diving a little deeper into felony cases for a moment, I want to draw your attention here to the orange bars. So these are representing the proportion of cases where bail was actually posted. So bail was set and the person was able to post bail or arraignment. So although we saw that 17 percentage point drop in bail setting for felonies, bail posting actually dropped as well over the study period. And what that means is that even though fewer cases were getting bail set, less people were able to pay bail. And this is especially evident if you look in the middle in suburban New York City, where the proportion of bail posting fell from about half of cases where bail was set in the first quarter of 2019 down to just less than a third by the end of 2020. And part of why that is, we hypothesize, or the data is showing us, is that even though we're finding that bail setting has declined overall and amongst felonies, bail amounts have increased over the study period, especially for felonies in suburban New York City and New York City. And just remember, in New York City, bail setting was actually much lower than the other parts of the state kind of throughout the study period. Okay, so we also looked at how outcomes vary by charge type, and just a couple of points to highlight here. One is that pretrial release for drug cases increased by 26 percentage points over the entire study period. And this was the greatest increase among all the other charge categories. And two, cases involving weapons charges, you'll see, had a much flatter trend in terms of pretrial release, and they were also much more likely to have bail set at arraignment compared to all the other charge categories, and this is pretty consistent over the 2 years. So if we just isolate the bail setting lines, there was actually a 4 percentage point increase in rate of bail setting for weapons cases. And then last but not least, we looked at variation of outcomes by demographics. Unfortunately, we only had 2019 race data for New York City courts, so we didn't have that for non-New York City courts. So we weren't able to do like a statewide pre-post analysis for demographics. But we were able to look at what was happening in 2020. So essentially, from these 3 points, what we found is that statewide in 2020, young Black men were least likely to be released pretrial and subsequently most likely to have bail set. And then when we did do the pre-post reform comparison for New York City, we found that release rates increased by 3 to 7 percentage points for most of our demographic groups. But despite this, disparities persisted in terms of who was getting released and who was still receiving bail. So we found that Black and Latinx people were less likely to be released compared to white people, and especially when it involved felony charges. So a lot of findings condensed in a few minutes, but the key takeaways that I want to leave you with today are, first, that pretrial release was increasing pre-reform, especially in New York City. Upstate and suburban New York City courts were more likely to set bail, and this was pretty consistent throughout the study period. Bail setting did decline, though, overall, particularly for felony cases, but bail amounts increase, and this is likely contributing to people's reduced ability to post bail. Bail setting remained high and even increased for weapons charges. And then finally, racial disparities persisted post-reform in terms of who was released and who was still receiving bail. Thank you. So I'll turn over to my colleague Jay Oak, who's going to talk about bail impact on jail population. So.
Good afternoon, everyone. My name is Jae Kim. I'm leading VERA's New York Bail Reform Evaluation Study. And today, we at VERA, we conduct multiple research projects to understand how this bail reform in New York State is impacting the lives of the people in New York State. We conduct court observations to understand how the judges are implementing the bail reform. And then also we interview system actors, including prosecutors, defense attorneys, and also pretrial supervision officers to understand their perceived impact of the bail reform. And then the other thing is that we actually pay attention to incarceration trends to understand how this bail reform actually impacts the number of the people who are incarcerated in jail in New York State. So Division of Criminal Justice Services, or we call DCJS, provide multiple monthly jail population trends. And then here on the trend, you can see that before in April 2019, about 21,000 people were incarcerated in jail statewide, and then majority of them were detained pre-trial. And then the jail population trend has overall downward trend, and then the largest decrease or substantial decrease happened in November 2019, which indicates that states and then counties started implementing the bail reform 2 months before the actual rollout of the bail reform. So in January 2020, about 15,000 people were incarcerated in jail. So about 6,000 less people are incarcerated in jail. And then obviously, as you all know, in March, COVID-19 pandemic hit. And then in July 2020, about 11,000 people were incarcerated in jail, statewide jails, which is only the half or 50% drop from the jail population in 2019. Unfortunately, this trend didn't persist. As you can see, in the latter half of 2020, the jail population started to go up. And we see the similar trends. In both New York City and non-New York City counties. And then one thing that I wanted to mention here is that about 2/3 of the New York State jail population is actually coming from the non-New York City counties. So even though a lot of media attentions and conversation about incarceration trends in New York City, actually the New York jail incarceration trend is mainly driven by the non-New York City counties, and I think this is something that we should pay attention to when we are talking about the impact of the bail reform statewide. We also look at the changes in jail population by regions, and New York City as a reference, so about 37% of the jail population decreased from 2019 through by the end of 2020. And then you can see that Hudson Valley regions and Long Island regions, showed the largest, even greater decrease in jail population. More than 40% population has decreased in 2020. So the DCJS data provides the good overall snapshot of the jail population statewide. But for us to be able to understand what actually has changed after the bail reform, we need more granular and individual level data. And as you all know, New York City actually has a pretty robust jail data and then also other types of the criminal justice data available through New York City Open Data Source. But we weren't, unfortunately, the rest of the counties, rest of the state, we do not have that data set. So what VERA did is actually we reached out to all 57 county sheriff's departments and asked them for the data. And we received the data from 49 county jails, which covers about 86% of the non-New York City jail population. And so including New York City jail data, it covers about 91% of the jail population. So understanding the full impact of the bail reform on jail incarceration takes time. And then in addition to that, a pandemic happened. So what we can do in the meantime is just exploring the immediate impact of the bail reform by comparing the incarceration trends in 2019 comparing it to the incarceration trends in early 2020. So the graph in front of you shows the average monthly admissions by chart severity. And then here, you can clearly see that more than 50% of the drop in jail monthly jail admissions in mainly misdemeanors and nonviolent felonies, but that drop is not as distinct and then not that much for the violent felony charges, which is understandable and expected given the bail reform legislation that was mainly targeted on the misdemeanors and non-felony charges. And we also see that the similar trends between non-New York City counties and New York City. We also looked at the likelihood of jail admissions after arrest, and then the finding is not surprising. We consistently see that more than 50% drop in the likelihood of jail admissions. But one thing that I wanted to address here is that depending on the regions of the arrests, so whether you are arrested in New York City versus whether you're arrested in counties outside of the New York City, your likelihood of pretrial detention after arrest varies substantially. So here, for nonviolent felony charges, for example, about slightly less than 50% of the nonviolent felony arrest resulted in pretrial admission in early 2020 in non-New York City counties. But compared to that, in New York City, only 11 or 12% of the nonviolent felony arrest results in pretrial detention or jail admission. So something that we have to pay attention to, these drastically different characteristics and the patterns in incarceration across New York. And then we're going to look at the changes in jail incarceration throughout the 2020, just to see the prolonged impact and effect of the bail reform, as well as impact of the COVID-19 pandemic. We just divided these 2-year time periods into five buckets or the 5 bars. And then when you just compare the black bar to the gray bar, this kind of shows that after the largest 50% decrease in jail population after the bail reform, there was another 50% decrease in jail population after the onset of the pandemic, and then you see that the admission kind of goes up in the latter half of the 2020, but it kind of never surfaced the level of early 2020 jail admissions. And this is the result for the non-New York City counties, and then the other is, and then we see the same trend in New York City as well. So last point that I wanted to make here is that, understanding, whether, exploring whether this bail reform actually has changed the racial disparities, the existing racial disparities in the system, and particularly in incarceration. Because one of the, consistent research findings in the criminal legal research is that Black and brown people are disproportionately more likely to be incarcerated in jails, and then we were curious to know, whether bail reform actually, contributed to the decrease in this existing racial disparities. And then, unfortunately, what we find is that overall, the fewer number of Black and brown people, and also fewer number of white people were incarcerated in jail after bail reform. Actually, the ratio of Black to non-Latinx white incarceration rate increased after bail reform. So in 2019, Black people were 5 times more likely to be incarcerated to jails compared to non-Latinx white people, and then this difference increased to 6 times by the end of the 2020, which is something that we should pay attention to as we are exploring the long-term impact of the bail reform and the pandemic. So just to summarize our research findings, the jail population decreased more than 30% from April 2019 to March 2020 in both non-New York City counties and New York City. And the likelihood of pretrial detention after arrest decreased by almost 50% for misdemeanors and nonviolent felonies. Still, more than 13,000 people are incarcerated in jails, mostly for pretrial detention, in December 2020. And also, when I checked the DCJS website, last month, about 15,000 people were incarcerated in jail statewide. And then lastly, the overall number of Black and non-Latinx incarceration decreased, but racial disparities persisted and have some evidence that it might have been widened. I want to end my presentation by introducing VERA's two jail dashboards, and one of them is something that Aubrey already introduced, so thanks, Aubrey. Then the second jail dashboard that I wanted to introduce is that, this jail visualization tool shows the number of the people in jail across New York State from 2018 to 2020, and it's updated every 6 months, and then it has more granular information about the people who are incarcerated in jails, including bails amount, and then length of stay, and then racial disparities, etc. So for those of you who are interested in looking deeper on this incarceration trends, please visit VERA's website to check out this jail dashboards. That's it for today. Thank you.
All right. Hi, everyone. I'm Jen Ferrone. I'm from the CUNY Institute for State and Local Governance. Thanks. And so some of my colleagues here presented data on outcomes since implementation of the legislation, and I'm here to talk about a process evaluation that ISLG is conducting around implementation of the reforms, and this is funded by Arnold Ventures. Oh, I went the wrong way. So to just share some important context just about this study before I dive into the findings, our goal here was to really document the process of implementing. This is a sweeping set of reforms, not only focused on bail, but as a number of the morning panelists talked about discovery, there were also many changes to appearance tickets, or called desk appearance tickets, here in New York City. So there were a lot, and of course pretrial service ramifications as well. So there was a lot going on. And ISLG chose to focus actually on desk appearance tickets and discovery in particular in our implementation efforts. But given our conversation here, we wanted to share what we've been hearing from stakeholders about pretrial services and bail in particular. So the goals of our evaluation was really to explore the ways in which New York counties and criminal legal system agencies across the state adopted the legislative requirements. And this is really, a lot about how they operationalize those in practice. As a lot of the morning panelists talked about, the legislation was often vague in certain respects. And so really, what does that mean on the ground for the stakeholders and practitioners that ultimately have to implement it? And with that, documenting the successes and the challenges that these agencies and individuals faced, and also to extract larger lessons learned from New York's experience, and really thinking about New York as a model for other jurisdictions, because as Sandra noted, this is taking effect in many states across the United States. Many states across the country. So in terms of our data, we participated in a lot of interviews in multiple New York counties, not just New York City, and really talked with various agencies from law enforcement to pretrial services to probation departments that ran pretrial services to public defenders and also individuals that were impacted by the criminal legal system as well. I do want to note that we did not talk to judges because the Office of Court Administration was not able to participate in the evaluation. So anything, talked about judges is really the perspective of the other stakeholders that we talked to. We also supplemented that with document and data reviews as we had available. So I was going to start here with some of the key findings around pretrial services in particular. And really this echoes a lot of what, Aubrey talked about in terms of pretrial services. And we're going to highlight a lot of the challenges, especially in the early days. This is an ongoing evaluation. So we are talking to stakeholders again about what's been happening, since the last time that we talked to them. But I do want to recognize that with all of the challenges that agencies have faced, they've done a tremendous amount of work implementing these changes. So I just wanted to note that before I dive right in with some of the negative things that we might have heard from people. So in terms of pretrial services, I think, a common theme across our process evaluation to date has been this kind of difference between New York City counties and counties outside of New York City. And this was very much exemplified when we were talking about pretrial service providers. This was an unfunded mandate. There were no additional funds available to counties in implementing this. And this was really felt by pretrial service providers, especially outside of the city, because a lot of them did have more limited infrastructures, did have more limited staffing structures, and so it was not as easy for them to implement some of the changes that were specified in the legislation. New York City, on the other hand, had already been engaged in this effort for a long time, as we heard. They had the resources available to them, and while they did experience a lot of challenges in kind of re-envisioning what their programs looked like, they didn't necessarily have the same challenges that those outside of the counties expressed in terms of their infrastructure, for example. Oops, keep going the other way. The second finding around pretrial service providers was really that there were a lot of uncertain expectations, and they felt that there was limited guidance provided to them by the state. Some of these expectations they felt were unrealistic, just given, again, their more limited infrastructure, the fact that there was not a lot of funding available to them to implement these changes. They did recognize NIAPSA as coordinating a lot of these efforts for them, though NIAPSA is not a state agency and it doesn't have any regulatory authority over pretrial service agencies. So while they felt that coordination provided by NIAPSA was helpful, they would have liked more and they craved more from the state itself. A common theme also coming out of our interviews was a lot of provider uncertainty about what to expect in terms of their populations, especially outside of the city. I think the city expected an influx of clients into their services, but providers in other counties across the state didn't know how the judges would necessarily interpret key aspects of the legislation and thought maybe there would be a lot of release on your own recognizance and not many referrals to supervised release, for example. And so it was very hard for them to tell exactly what they should plan for and what kind of client, what volume of clients they should expect in this instance. I have a lot going on here. So finally, in terms of pretrial providers, and Aubrey talked a lot about this, there was, adjusting to working with a different clientele. So there was this idea of an evolving target population, especially in the city, clients with more extensive criminal histories, clients that had greater needs, particularly in terms of mental health and addiction, and also clients charged with more violent offenses. And so this required really a new staffing structure. There was a big hiring effort in the city, and different staffing, different specialized qualifications. I also wanted to note here that there were concerns around net widening with respect to supervised release, and this was related a lot to those that were issued desk appearance tickets. Some providers expressed that they were seeing individuals with desk appearance tickets in their programs, which they hadn't seen before. And so this was a concern just given, are the resources being allocated appropriately for that population? So I did want to make that point as well. So in terms of bail and pretrial detention findings, and I'll go quick, I know I only have a few minutes, and I think, again, we heard this throughout the morning, and, Aubrey said it also, but participants largely subscribe to the spirit of the legislation. So the stakeholders that we interviewed in terms of law enforcement, prosecution, pretrial service providers, defense attorneys, they all subscribe to the goals and objectives of the legislation. They understood, what the legislation was meant to do. Though some of those stakeholders did feel that the pendulum may have swung too far in limiting discretion. And again, we heard that, I think, throughout the morning. That said, I did want to highlight a lot of the positive, aspects of bail reform and what public defenders and those impacted by the system told us when discussing the bail reform provisions in terms of it really leveling the playing field. And this is not something, again, that we hear a lot in the stories around bail reform, so I did want to highlight it here. Not only does it remove the economic barriers to release, but it also reduces the collateral consequences that individuals face that are coming through the system. They're able to be in the community. They're able to stay with their families, remain in, their ties to their employment and their community at large. They also have better case outcomes, as was discussed, so less harsh sentences. And also, there was a lot of discussion around plea negotiations as well. It removes the leverage in terms of that prosecutors have when someone is in detention during the plea negotiation process. And together with the discovery provisions, really allows an individual to think about the plea deal before they actually take it. And I'll talk about reducing racial and economic disparities in just a second. And then on the other hand, law enforcement and prosecutors definitely shared with us the perceived negative impact on community safety. Of course, this is a very, important issue and something that we're faced with every day, and what we're hearing in terms of the current trends. People felt that bail reform took the tools away from them in terms of being able to consider other things, and especially when it comes to those who they felt were cycling through the system multiple times. And, we see this reflected, I think we see those concerns reflected in some of the amendments to the reforms. But of course, it's a nuanced conversation and there's a lot to unpack there. So finally, with respect to bail reform, and I don't think this is a surprise, there were challenges securing buy-in, for the reforms across stakeholders. And I think, what we heard from law enforcement and prosecution in particular is that there was really, no victim's perspective in the way that the legislation was drafted and perhaps passed, and no voice at the drafting table for law enforcement and prosecutors. And so they definitely expressed that to us in our interviews. Also, I think any agency outside of the city really felt like a lot of the legislation was New York City centric. So a lot of the examples that were used in the legislation to ground the legislation were not necessarily applicable in an out-of-city context. And one example is just some of the logistical concerns around town and village courts, which often don't meet regularly. And so some of the timeline, implications weren't able to be addressed in those courts because they didn't meet regularly. That's just one example. And then just other implementation issues that we heard about was around the ambiguous statute language, which I talked about before, but certainly permeated throughout all provisions of the legislation. Issues with the charge eligibility, I think I heard it referred to as the bail bucket. So what is in that bail bucket versus out of the bail bucket on both sides? There were concerns perhaps it was too expansive, perhaps it was too restrictive. And there's also a lot of unintended consequences, that we might have to consider as well. And we've been hearing about some of, how would judges interpret certain pieces of the legislation in the courtroom. And then, finally, just this need for a culture shift. A lot of the agencies we talked to, talked about preparing for bail reform throughout 2019 so that they were ready on January 1st, 2020, though not all counties were able to prepare in that way. But, in order to make implementation a success, that culture shift really does need to happen. So finally, just wanted to end on, a quick note around eliminating racial and ethnic disparities. I think my colleagues kind of have already covered this on the stage, but something that did come out of our conversations with stakeholders was that this is definitely a recognized goal of the legislation. However, there really were they weren't necessarily intentional around disparities in the way that they plan for implementation of the legislation. And so we're not really seeing those impacts on the ground. As Jay Oak mentioned, we're actually seeing disparities increase at this time. So even though, some well-intentioned reforms, even though reforms are sometimes well-intentioned, they may actually exacerbate disparities. And I would urge stakeholders to consider ways that they might intentionally focus on disparities. And I think a lot of the charge-based decisions are probably driving some of that as well, because we know certain communities and charging practices are, centered on certain communities or disproportionately impact certain communities. And then finally, COVID was a whirlwind. Doing a process evaluation 2 months into our interviews, COVID happened. It shut down everything. And of course, it compounded implementation challenges. Courts just weren't in session. Timelines weren't in effect. So in order to get people to reflect on how things actually would have changed was difficult because it just wasn't the regular state of affairs at that time. So we're learning more now in our more recent conversations. So I'll end there. Thanks so much.
Okay, thank you so much, Jennifer. So I'm gonna keep everyone for about 4 minutes or 5 minutes, which I think gets to about our planned session length. Okay, first I'm just gonna say people are watching at home, and so planning this, I said, come on, if I got on Twitter 3 years ago, everybody is on, they're going to tweet questions. It's going to be awesome. We don't have questions on Twitter. So someone here is going to have to ask a question in a minute. But I'm going to give you a minute to decide you are going to raise your hand and ask a question by stalling for time. I want to digest a little bit of what I've heard first. I think we heard from Sandra about the research nationally, which mirrored the debate that we heard in the plenary session earlier. Yet, at the end of the day, what I heard was there's not evidence of a relationship between bail reform and crime. But then I think we also heard from Aubrey that it's a little more complicated. That doesn't mean nobody is rearrested, because there are rearrests. There were rearrests before bail reform and after bail reform. I want to cut to a few additional takeaways from what we heard next from Olive, Jay Oak, and Jennifer. Number one, bail reform achieved one of its goals, which is to increase pretrial release. I think we heard that clearly. But then we heard about some of the goals that don't appear to have quite been achieved. We heard that bail posting of people who face bail has not improved. In other words, even though I started at the outset with having to take ability to pay into account being a core element of bail reform, it doesn't appear that we are there yet. And then we heard from Jay Oak that while the use of bail, while jail populations pre-trial have not gotten back up to where they were in 2019, her data shows that there was somewhat of a reversal, and there was somewhat higher bail setting towards the end of 2020 than at the beginning. And then finally, we heard from a number of speakers that although reducing racial disparities was a critical goal of bail reform, it doesn't appear to have been consistently realized nationally. I think that's a point, Sandra, that you had observed. And then we had seen this in New York. And then finally, Jennifer indicated that in her process interviews, it appeared as though people weren't focused on it or weren't sure how to achieve it. So I want to just sort of flag those as conclusions reached and issues raised here. And then I want someone in the audience here to ask a question. So who's going to do it? Who have I got? Oh, great. Someone's got a mic. Okay. And then after that, I've got to give Miriam a question. Miriam, you're going to go next, and then it's a wrap.
Hi, so I have a question about data on and making assessments about the different kinds of release conditions. Do we have any data on that? If we don't, what do we need to get it? And basically, I'm asking because I'm a defender in Queens. How do I argue to a judge, or how do I and the DA argue over what the least restrictive means truly is, other than a judge's gut feeling about what to do?
Well, if you want data, we got it. So I would say go to the dashboard. I didn't show you as much of the New York City arrests filed with the court dashboard, which looks at, in any given month, the total number of cases heard by the court and the release conditions for that court. But specifically for your question, I mean, we provide not just supervised release in Queens, but we, as you know, we conduct a release assessment, which provides information to the court about the likelihood of return to court. And that release assessment relates to the recommendations of the intensity of supervised release, if that is so chosen. So there are, in fact, tools in court that I know you well know can be used, that some judges are more receptive than others. But I think there is an argument that can be made about the value of someone who has, say, a perfect score on a release assessment. If they're released, they're going overwhelmingly likely to return for all their court dates.
So I'll just speak to the non-New York City data. We do have that data. The data that we have allows us to kind of distinguish the different types of non-monetary conditions. We didn't do it for this report because if you look at the report, it's very long. But just to plug our work, our forthcoming kind of update on the first 2 years post-reform will dive deeper into the different conditions of release. So, yeah.
Just to add what Olive just said, Bureau Institute of Justice also conducted analyzed the pretrial supervision data. We received the data from 5 counties outside of the New York, so Albany, Broome, Erie, Tompkins, and actually it's 4 Ulster counties. So like we received the data from those 4 county probation departments, and then and also we conducted core observations, and then we see that the judges are setting these conditions of release. But like what we see from counties outside of New York City is very much very much different from what we see in New York City context. So for example, there is not much of the variation in terms of the different conditions that's imposed by the judges. And then the second is that, I think this is something that Jen kind of touched on it, there are concerns about net widening of the use of the pretrial supervision services, but actually the data shows that actually that's not the case, because the judges that are judges who were typically setting pretrial release were prior to bail reform were setting conditions of release on the charges that are no longer eligible for bail. So actually it's just a mandatory release, and then the judges stopped kind of utilizing this setting pretrial supervision services in that sense. So yeah, so that's the findings, and then we also have the report coming up in a month or 2, so yeah, stay tuned.
I'll try to be quick. In the Harris County context, and this is a slightly different kind of response to your question, judges actually needed training around how to think about the different restrictions, and they were also provided on a fairly regular basis, like it is a pilot study, fairly regular basis, the impact of different kinds of restrictions, so that they would come to feel comfortable doing the least restrictive because they understood that it wasn't producing harms. And so so what was required above and beyond just saying do the least, judges actually need feedback about what that looks like and under what conditions, and also constant feedback about what the decisions are doing with regards to the people that their rulings impact. And I think that has to be an important part of this conversation because it matters.
Can I just add one more, the last thing related to that? So when we conducted court observations in Erie and Broome County, and then we actually saw that how the judges are setting bail and like what kind of arguments are made or not made, and then what kind of arguments are made by the prosecutors and the defense attorneys. And then our research finding shows that actually 85% of the cases where bail was set, there's no discussion and then arguments about consideration about person's financial ability to pay, and also judges typically don't explain what the risk restrictive means for this particular case or for particular defendants, and then typically their decision is mainly based on the charge severities and then also the other safety concerns or dangerousness. I think it's a kind of hard touchy topic to mention about it, but we already know that that's what's happening in the courtrooms, and then that's what the general practice has been like, by the judges.
Okay, all right, so I totally lied. We had another hand there. I want to get to that. Let's have this quick question here, a quick answer, a quick question over there, a quick answer, and then we're done. But just to pile on, I'm going to ask another question that maybe no one will have time to ask, but I'm just going to ask it. And Jay Oak, it's based on your comment that you just articulated, and Olive on the research you presented. How, I'm not saying anyone should answer it, but it's a question. For researchers watching or for us on this panel, how do we, Jay Oak, talk about your finding that I think you said 85% in 85% of cases observed when bail was set, there was no discussion of ability to pay? Do we say courts are disregarding the law? Do we say something neutral, like maybe they considered it, but they didn't talk about it? And just how do we, as researchers, communicate this type of finding that appears to be contrary to an element of the law? Okay, I'm leaving that hanging, and I'm getting a question over here.
Yeah, I mean, I don't know if it's going to be an easy answer, but I know it was thrown out earlier, at least some statistics about like black on black crime being the reason why the system disproportionately targets black and brown people and why we find them in our jails. And so my question is really, and I've seen some of the research saying that the disparity still exists, and that in particular for felonies, white defendants are getting out on lesser bail or no bail compared to black and brown people. So as researchers, I'd like to know, how do you combat this black on black phenomenon, that's the reason why we have disparities in our system?
So some disparities are associated with higher rates of crime in Black and Latino communities. But almost, if we were to examine every stage of criminal case processing, there's evidence to indicate that bias also drives what happens in terms of creating these disparities. So it's not just about the fact that these communities are, and we should ask questions like when it's reported that folks from some communities are more likely to be rearrested after having an experience with the criminal legal system. I think we should be asking ourselves why that is the case. Some communities are over-policed and underprotected. So of course, if there's a higher concentration of police in my communities that research shows is above and beyond the rates of crime that exist in those communities, then you should expect that there's going to be higher rates of arrest. And being arrested doesn't mean you committed a crime. Is an accusation. And part of what we're supposed to be here to talk about is the presumption of innocence and how you're supposed to deal with people who are presumed to be innocent. In a context where we know that there are serious issues with how law enforcement behaves, misconduct throughout the process, and that impacts disproportionately people of color and people from low income and poor communities. So I think all of those factors should be taken into consideration. When we think about higher rates of crime in some communities, I think we should also be thinking about other factors that drive it. Social dislocation, economic dislocation, where we're funneling tons of resources into law enforcement. We're not investing in those communities with regards to healthcare, with regards to education, with regards to parks and recreation, which we know dramatically reduces rates of violence and other kinds of crime. We're not investing in housing so that people are housing stable, in food, right? So if we were to shift our thinking about what is driving these factors and take seriously the role that bias does play in each stage of the process, I think that we can come up with different solutions.
Okay, we got to get everything for once. Yeah, we have the creator of New York City Supervised Release Program here. She raised her hand. Okay, Miriam, make a comment. Anything you've got, ask a question. Let's get a quick answer.
Okay, I'll make this very quick. So, Professor Smith, thank you so much for your work. I think, especially right now, really taking the conversation around bail reform away from anecdotes and away from sensational press has never been more important. My question on your data, in terms of, each of those states, their reforms happen in a slightly different time and, over time. And with New York, obviously, the big question, it happened at a time when it's just so hard to have an experiment because so many factors were thrown up into the air, including the time between hearings, the people being able to get to court and to have their hearings, and police enforcement changed during that time. I mean, so many things happened, and I'm curious if there's a way to pull apart the effects and be able to say, with crime and with hearing times, with trial length.
I think, thank you so much for the question, and I'd be interested in others' response to the question as well. I think it really is hard to pull out the effect of COVID. COVID just disrupted everything, so how do you address the impact? With regards to the question of bail reform, one of the important points I think both Olive and Jill mentioned in their talks was that jail populations were declining significantly in New York well before bail reform and COVID, right? And we saw with those declines, declining rates of crime as well, right? It declined and then it leveled off. There was a point, I think probably 2019 or so, where we start to see upticks of something. But even if we focused on the New York context and went before COVID, we see dramatically declining rates of jail detention associated with, I'm not saying causal, associated with also declining rates of crime. It wasn't driving it up. Right? And we see other contexts. Look across the river, to New Jersey that implemented reforms in 2014, or at least they started to, right? In multiple reforms, including bail reform, we saw dramatically declining rates of jail populations not associated with. So it is the case that reforms happen across the country in multiple contexts much earlier, but most of those reforms have taken place since 2015 or so. Right? And before COVID. And if you look in those contexts, we're seeing very similar patterns. And I think that, so if we were all over the place, I think we'd have a question about, okay, what's really happening here? But generally speaking, the patterns are all in very similar directions, even in including impact on racial disparities. So I take that very seriously. And the final thing I want to say is, not only has the evidence shown with these rigorous studies done by folks like my colleague at Harvard, Will Dobby and his colleagues, showing that pretrial detention, not only does bail reform, this is what I want to say. I've shared that most of the studies are showing that pretrial bail reform has the impact of, it does not drive up crime. This is what I wanted to say. Pretrial detention does. You increase the likelihood that someone will have future criminal legal system involvement if they have been detained, both at case disposition and 3 years after. So we know that detention does produce these poor outcomes that we're concerned about. And we're not finding evidence that bail reform, which reduces jail populations, does the same. That to me it's pretty, we should always look at nuance. I'm a sociologist, we get accused of too much nuance. But what we're seeing in terms of these patterns seems to be very clear to me.
Okay, thank you so much, Sandra. Thank you everyone for bearing with us. We're going to get back on schedule. Oh, yeah, I got announcements. We're going to get back on schedule at 1:20. It's going to be more of a moderated discussion. So if you're home, you've got to tweet questions or, get through to us and we will ask your questions. We're doing moderated discussion, lots of questions at 1:20. For people here, there is lunch. Go to the Moot Courtroom on the 6th floor, room 668. If you are a John Jay student and want to talk more over lunch, go to the faculty dining hall and there will be a moderated discussion for you. Thank you all for bearing with us, and we'll see you in a bit.
Good afternoon and welcome back to our bail reform conference here at John Jay. We are so grateful for all of you who are here in person in this space with us. We're also grateful to all the folks who are at home and are returning from the lunch break to continue this very important conversation. At this point, I'm going to ask our panelists for this upcoming panel to come join me on stage, please. And we'll take a seat. So thank you again so much, and I hope you have been engaged and really learning a lot throughout the first part of this day. So on this panel, this is the Community and Courts Bail Implementation Panel. What we have are among our esteemed panelists are practitioners and folks who are watching what's happening on the ground. So we've learned a lot about what the legislative intent was in preparing the statute and writing that statute, this intent to lean on decarceration, reduce the number of people who are experiencing jails and prisons here in New York State, address wealth-based disparities, as well as begin to mitigate those racial and ethnic disparities that we see throughout our criminal justice system. And we know that intent, of course, gets reduced to text, and how that process happens can be often cumbersome, right? There are some compromises that are made. There's language that is used in order to codify these intentions. We also learned from the research perspective, what are some of the outcomes we have seen throughout New York State in terms of the changes in the jail population, the use of bail, the amounts of bail. And what we are hoping to turn to now is, what does all this look like at the stage of implementation, right? What are the folks who are spending their time in court, in arraignments, surrounding arraignments, watching from a community perspective? What does this mean in practice? And what are some of the challenges that have been experienced on the ground? So I'm very grateful to the panelists who are joining us this afternoon, and thankful for all of you who have returned after lunch break. So for what I also want to remind the audience, those who are watching remotely, those of you who are here, we're taking questions in a few ways. We have a Twitter account. We're using Twitter with the hashtag NYBailConference. So if you feel like tweeting a question, please do. I have colleagues who will assist me in getting those questions. And we also obviously have this space, and we will be taking questions directly from the audience. So if anybody, we'll start with some discussion. We'll turn it over to all of you for some questions. And just one note that DA Soares may need to leave a bit early as our schedule is kind of running into each other, but we are really thankful for his time as well as the time of all the panelists here. So I'm gonna go, I would like to introduce everyone. I'm gonna give a brief introduction starting from my left to my right, so you all know who they are before they start speaking, okay? So I should say, I don't believe I introduced myself. My name is Crystal Rodriguez. I'm the Policy Director at the Data Collaborative for Justice here at John Jay. And immediately to my left is Martha Bailey. Martha is the Executive Director of the Wayne County Pretrial Services. We have Sarita Daftery, who's Co-Director of Freedom Agenda. Youngmi Lee, who is Legal Director of the Criminal Defense Practice at Brooklyn Defender Services. And we have Awina Martinez, who is the former project director of the Staten Island Justice Center of the Center for Court Innovation, and the Honorable David Soares, the Albany County District Attorney. So I would like to ask of you all just a general question to sort of give people a picture of what all these numbers and legislative text translates into on the ground, right? So, and I'd like to start with DA Soares, if that's okay. Considering the goals of the law and what we've been learning about and discussing throughout the day, could you share from each of your perspectives, what about implementation has gone well, or what are some things you have observed as deficits or challenges to implementing this bail statute?
Okay, interesting question. So the only way that I could relate the experience in what I think is a relatable way is when I'm an immigrant and you come to this country, you have your first Christmas, and you get this box, it's Matchbox cars, box is beautiful, you open up all the toys and you realize batteries are not included and there's some assembly required. And so when you get such transformational policy, well-intended as I'm sure they were, there are no directions that come with it, and in this instance, neither was there any funding. And I think oftentimes, as it happens in Albany, whenever we have major policy shifts, those policies are often developed with a New York City-centric perspective. In other words, I understand the George Washington Bridge, there's a wall, and the rest of us live north of the wall. If you're a Game of Thrones fan, I think you might understand. And I say that just because the ecology of our criminal justice system in upstate New York is much different than it is here in the city. So, to give you an example, just in my jurisdiction of 300,000 people, we have the most diverse of communities. We have an inner city, we have river towns, we have more rural hill towns, and we have bedroom communities, all of which have a court system in each of those communities. In Albany County, as I'm sure in other upstate communities, the organization that is primarily responsible for pretrial services is probation. Unlike certain communities here in the city that have not-for-profits that are responsible for pretrial services. I think what is interesting, and something that we'll probably get to, is determining whether there is a difference in pretrial services when those services are offered by an institution that is connected with the criminal justice system, as opposed to one that is in community and community-based. I think that's a relevant issue to study. As I said, batteries not included and some assembly required. These transformative programs did not come with funding. Upstate communities that also experience a 2% tax cap are also challenged in, I think, providing the kind of services that perhaps others are experiencing here in New York City. It would also be interesting to see whether there is a correlation between outcomes based upon funding. In New York, in Albany, New York, what we're experiencing now in the courts is as a rate of return. If you're talking about our city court, which is open every day, and people have access to that courthouse every day, even for arraignments on the weekends, we're seeing a rate of return of about 50%. In our local courts, we're seeing, in our town and village courts, we're seeing a return rate of about 25 to 30%. And what does that mean? Giving you an example of a community in my jurisdiction, Colony. In Colony, you have 2 courts and 3 judges, and they rotate, right? So their policy in Colony is 3 strikes, and then you'll get a failure to appear a warrant, right? When you're on a rotating schedule, those 3 strikes take 9 weeks to achieve. So we're not seeing individuals back for months at a time. And then if they're not returning on that 9th week, you're on that same rotation. Now, what does that mean? Well, that means for individuals who are presenting not only with a criminal charge, but also presenting with some other need, for example, treatment, which they can get connected to, they're they're not receiving, they're not getting access to that treatment, which is an issue. And I'm interested in hearing how other communities are wrestling with those issues. I was told with very threatening eyes on a Zoom call that this was not going to be a discussion about opinions as to whether bail reform was a good thing or a bad thing, so I'm sticking to my script under the threat of harm. But I would leave you with this. I would leave you with this. It's not just enough that there's advocacy for change in criminal justice policy. There has to be advocacy to make sure that there is support if you want those policies to succeed. And I think one of the challenges that we're experiencing north of the wall is these programs succeed. And I think a lot of it has to do with just the woeful funding for an investment towards success. I agree with people who say that people whose needs are being met are not out there committing harm to other people. And I think right now we have the same condition pre-existing bail reform where people's needs are not being met. And so we have to figure out how to address that. Thank you.
Martha, I'd like to turn to you to focus on that general question around the deficits or challenges or maybe things that have been going well in implementation. But with the additional focus of zeroing in on something DA Soares just shared regarding the support needed for policies to succeed. What is not just the financial support that those policies need, but what are the specific ways those resources would be directed in order to address whatever challenges or deficits you might share?
So I'm from a county where there's around 90,000 people. We are a very rural county where we are a completely community-based agency, a nonprofit. We are not part of probation. Our relationships within the criminal justice system is very important with all the stakeholders there. Our relationships with the human services agencies is essential. And then our relationships with the individuals that are getting placed on release is, it helps our success, quite frankly. I was here earlier and there was a sheriff who spoke on he knows the people that he's arresting. We know the people that are getting placed on release, and there's a trust that all of those people place on us. Along with that, we were expected to do a lot more with the same amount of funding, and that it proved to be a huge challenge. We have very little transportation. That's a huge challenge, is trying to figure out how are people even going to get to court. When it was virtual, how are they even going to attend court virtually if they don't have access to the internet or access to a cell phone? Those are things that we had to face on a very limited budget. We use technology a lot, but one of our biggest strengths, I think, is how to make it a human interaction with the people that we're helping. We're able to give them access to services that could, in reality, be life-changing for them. Does that answer your question?
Yes, that was very helpful. So some of the things that I'm hearing is that the relationships is what allowed you to sort of build in the implementation, right? Like you were able to connect people to services because you had these pre-existing connections with community service providers. I would like to turn to Awina, who is former director of Santa Elena Justice Center, oversaw supervised release here in New York City. And what I would like to ask you is, what are some of the challenges you saw, and how did you overcome them as it relates to this service provision, right? This ability to connect people directly to the services they might need. And I'm going to tackle on another question. What are the services you think are most needed, most prevalent in the folks who you're seeing coming through your program?
Yeah, so first and foremost, we talk about data and numbers and the intent of the law, and behind every number is a person, with needs, with their own story, who's tied to community, with family. And so, a really big obvious answer to that is funding and resources. So the Staten Island Justice Center and the Center for Court Innovation had been operating supervised release programming since 2016. It was operating on a smaller scale. There were eligibility requirements. So we had 4 or 5 years of experience under our belt servicing the Staten Island community. We always said that supervised release, the whole point is to get people back to court, but it's so much more. It can be so much more. And so when the bail reform legislation happened, our resources increased. We received more funding to hire more social workers and case managers. At the time, 2019, we had a very small team of 4 or 5 people who were working with our clients every day, providing them with resource allocation, even something simple as, I have a case manager who I can call and just talk to. That human-centered approach, that human touch was really important for someone who was going through a very difficult time in their lives. And so with the expansion in bail reform, our funding increased. And so we were allowed to increase.
She's hating on you over there.
This is the goal, right? The goal is to increase resources across the state of New York, because we went from a team of 4, 5, 6 people to over 30 in a matter of 3 years. And that allowed people to have smaller caseloads, more attention paid. They're able to catch any specific needs that someone is coming to us with. So I would say that the biggest answer to that is really us having the ability to hire more staff so that we could have more of this human-centered approach, and if someone's need is just, I'm going to call once a month because that's what my supervision level requires and it's all I need, that's okay. But like I said, it was return to court, but it can be so much more. So providing resources, if someone needed diapers or formula for their baby, we provided that. When the court shut down due to the pandemic, and we had to go to video court. We were able to provide phones, smartphones, so resources really went a long way. And I would really say that you would think a pandemic would affect compliance. Our compliance got better during that remote period.
Could I ask a follow-up question, Awina? Speaking of your caseloads, right? How did you expect caseloads to change given what was written into the statute? And then what did you actually witness and observe in terms of the caseload? Any characteristics of the folks who were coming through the program?
Yes, so prior to bail reform, there was an eligibility cutoff. If you rated high risk on an assessment, you were not eligible for supervised release. So with the expansion of charges, there was no eligibility criteria. We were hoping and we were anticipating seeing more felony level charges coming in through supervised release so that misdemeanor level offenses could be ROR'd, and we would have more of the resources and time to really work with those folks coming in through the system. And so we did see an uptick in felony releases at the tail end of 2019 when we did launch the new version of supervised release. But that slowly kind of trickled down. I think the excitement or the judicial kind of pressure to release people out of Rikers, this supervised release program is here, I will utilize it now. So that did attribute to an increase in felony releases to us. However, throughout the year, the past 2 years, we've kind of seen more of what we used to get. It's just kind of like 60%, 40% misdemeanor majority caseload. So a lot of our folks that were coming in on misdemeanor offenses, and it continues to be that kind of breakdown.
Mm-hmm. And just following up on that, I'd like to turn to Young Mi. Awina notes this change or this shift in the folks who are being sent to the supervised release program. And so from your experience, why might that be? What is contributing to that? And, how might that be an implementation challenge for this bail statute?
Sure. So Brooklyn was an outlier jurisdiction in all of New York City since supervised release occurred in 2016. So, and this was pre-bail reform. And we were the outlier because we had many more misdemeanor cases on supervised release than on felony cases. And so it seemed that with judges, even though cases were eligible for supervised release, they would rather set money bail on the felonies. Whereas on the misdemeanors, they were more likely to do supervised release. And so there was a real concern that people who should have just gotten straight release without any conditions were getting supervised release anyway. And so we were very concerned about that over-programming, over-supervision of people who are presumed innocent. So Brooklyn was like that for years, and then we had bail reform. And the hope was, because pretrial services in New York City, we call it supervised release. Pretrial services is the generic name. Supervised release is the name of the program in New York City. And so every case, no matter how violent the felony, is eligible for pretrial services. And if judges are applying the least restrictive standard, which is the new standard under the bail reform laws, you would expect to see an increase in the number of cases, whether it's a felony or a misdemeanor, getting supervised release. And we're not really seeing that difference. And I think part of the problem is that when we're talking about whether bail reform is a success or not, what's really important to keep in mind is that for decades, we all, and I'm as a defense attorney, we all caused a lot of harm with the bail laws, not just on individuals' lives, that person with the 30 misdemeanor convictions who kept pleading guilty just to get out of jail because bail was set on a petty larceny, but also on whole communities. And so the expectation that we got this amazing bail reform, and it is amazing, it was really transformational throughout the country. The expectation that we would have overnight success it's really unrealistic. And so what happened was we had the fear-mongering, and I'm sure it was all discussed this morning. And even before we could try to measure a little bit of success, we had rollbacks, right? So in 2020, even before implementation could take place, the legislature, the governor, they scaled back some of the bail reform without evidence, without data. And then unfortunately, the pandemic hit, and those who are without money, who need the services the most, were hit the hardest by the pandemic. And even pretrial services, supervised release, they had to go into a virtual supervision, which we all know when it comes to the one-on-one counseling and the face-to-face encounters, for people who really need services, that is not going to be as effective. So we have the pandemic, the people who are hit the hardest by the pandemic, their lives are even more upturned. And then again, we're trying to measure the success of bail reform, given these harsh conditions that are happening across the country, not just in New York State, but across the country. And we're still trying to measure success. And then we get to 2022, where we're scaling back bail reform again. And again, it was so clear, so very clear, that there was no data to back up what was happening in terms of whether bail reform was working, whether it was really affecting public safety, and the conversation just turned south again based on a nationwide epidemic. And so when we're talking about implementation and whether judges, and I have to say, there are plenty of judges in Brooklyn who are using all the tools that are within the bail reform statutes. So we have judges who are really taking seriously the partially secured bond option. We even have a couple of judges who will, and I would love to see this happen more, the unsecured bond for those bail eligible cases where judges feel that bail should be used as an incentive to bring someone back to court, right? Because that's what bail is about. or utilizing maybe pretrial services more. And I think part of the problem with pretrial services and why it might not be, why it's not being utilized more, especially on the qualifying offenses, where instead of bail, judges should be using pretrial services, is that maybe there's a misunderstanding about pretrial services, which in New York City is pretty robust. We have supervised release. There's an intimate partner violence component to it. They do voluntary referrals. People don't realize that some people who need services but don't want a court mandate and don't want to be forced into treatment are availing themselves of the voluntary referral services. And going and doing services quietly on their own. And we have actually had lawyers who will say, oh, you know, my client's doing pretrial services, they're doing well, they're doing their weekly check-ins, or if they're on the least level of supervision, their monthly check-ins. But guess what? They're also doing a program on their own. And now I'm going to use that to get a plea disposition on the case for those who want to plead guilty. And so there's no coercion, there's no use of bail to force people into pleading guilty so that they build up a record of having 30 convictions on really low-level offenses. And I think when you look at these individual cases, that's how you mark success. Overall, the big picture, when you're looking at data, I think it's going to take a while to measure true success if you're looking at large numbers. But in terms of individual lives, those who don't go to Rikers, many of them are doing really well.
DA, sir, should I give you?
Well, yeah, because I think I couldn't disagree with you more on some of the things that you said. I think we can all be in agreement here and talk about the need for additional services. I think this idea that we're not seeing an increase in crime because of what's happened with bail is absurd. Now, I don't practice law in Kings County. I practice law in Albany County. And when you talk about numbers, I mean, I don't understand what you're talking about when we have people who are released that otherwise would not have been released, reoffending. But I don't want to get into the debates of whether or not there's reason to roll back or not. I think we should be joining together and calling for our leadership to call for research and studies and testimonies and allow for every jurisdiction to come forward and present their information and then be able to assess whether or not something is working. Because when you say we don't have numbers and there's no evidence, well, I have evidence in my office. I have evidence in my office of people who are committing atrocious crimes, being released and doing more harm. And it's concentrated in one community. And so the question then becomes, how long do we have to ask black and brown communities to continue enduring the suffering of violence because we want to establish that reform and equity is a good thing? I'm not going to get into the merits of whether it's a good or bad thing, because I said that I wouldn't do that and distract the conversation from the desperate need for resources so that everyone is operating at a Staten Island level. But I think it's incumbent upon us to ask the leaders who pass the legislation to in this next term to come to Albany with the idea and the thought and plan to have a greater discussion.
And could I, sorry, I just wanted to bring Sarita Daftari into the conversation. I know that you are doing work that is connected to individuals who are most directly impacted by the bail reform law, court practices, judicial decision-making. From your perspective, what are some maybe pitfalls of how implementation's been going? What are some strengths, if there's any that you've observed, of how implementation has been going?
Thank you, and it's hard not to jump into that, but I'll try to respond to what you said. And I'm the co-director of Freedom Agenda. We're a membership group, so our members are folks who have been incarcerated on Rikers, whose loved ones have been or are incarcerated now. And so I would say that a lot of what we're seeing is actually
certainly what we see as the deficits and challenges in terms of the people who are still there and all of the ways that judges are still using their ample discretion to incarcerate. What we are seeing is that unaffordable bail is still being set. And that seems really obvious. That's maybe not like a news flash to anybody, but maybe we should pause a second and on what that is. So people are still being held in jail in New York City, a jail that has been called by a federal monitor and its own oversight board a deadly, dangerous place, and where 20 people have died in the past year and a half. People are still there rather than home awaiting their trial while they are presumed innocent because they didn't have enough money. So if that was happening one time, that would be too much. It is happening thousands of times over, and that's the situation we're in. So that's what we're seeing. What we're seeing through the lived experience of our members includes, I feel like every piece of what we've talked about today in terms of the ways in which the intent of the law is being skirted. So let me give a couple of examples. One of our members who her son has been on Rikers for the past 2.5 years, struggles with mental illness, had his bail set at $75,000 cash and $250,000 partially secured bond, was not able to pay either, and has been so distressed in the environment in Rikers Island where his mental health has deteriorated that he's not made it to his past several court dates. Of course, this is Rikers Island, so nobody really knows if corrections failed to transport him or if he refused because he was having a mental health episode. But so his time there is being dragged out even further. Another example that I would say is the use of the way in which people are still blocked from treatment courts. And treatment courts are already not the ideal, right? Like, you don't want people to have to get arrested to go get services. But if people have been identified in the process of an arrest and come into the court system with a clear need for services and for treatment, you want to be able to divert them. But still, we see, because the current statute allows prosecutors to act as the gatekeeper, we still see some prosecutors slamming the door on people who need treatment. And so we have a member who has a case right now. The judge in that case actually has said that he's very open to an alternative, very open to treatment. There's a clear need. They did an evaluation. It seems like there's a clear need for treatment, an intensive treatment for her son. But the prosecutor just won't consent to the case moving to treatment court. And so he remains on Rikers, exposed to more and more violence every day. And I think the people have some sense of the environment on Rikers, but it's an environment that requires violence in a sense. Like, people need to be prepared to defend themselves. And so the way in which that perpetuates violence is completely counter to public safety. And certainly that's what we're hearing from our members. We're also seeing that we've been looking a lot at the way that judges are implementing bail reform, basically because we want to know, we want to know how this is being implemented, but also because judges are going to continue to have some discretion. I mean, like, the whole bail reform fight has been about like how much discretion they have over which cases, and in certain ways, but we're not near a system where judges have no discretion. So we are interested in seeing how are judges using that discretion, and we started looking into it more in probably around the summer of 2020, when, in response to concerns about the spread of COVID in jails, there was like a wave of willingness for release. And what happened was that, people who were serving short sentences were released. People with being held for accused of parole violations were released. And then we were sort of looking at like what's next and what's left, and it was all pretrial detention, and it was clear that in that case, it was all judges, like the people that were going to make the difference in whether a person was going to get out or at that point, and be able to be, in a safer setting, not in a congregate setting during COVID, was all judges, and we wanted to at least engage in that conversation about
what is influencing judges, because I think we sort of felt like the common knowledge is that judges are like immune to public pressure. They're supposed to be these like removed figures. But what seemed more the case was that they were actually responding to the wrong pressure, that they were, sort of acting out of a desire not to be named in the New York Post, rather than really thinking about how am I applying a law that requires me to use the least restrictive conditions, that requires that I at least consider ability to pay, which you can't do if you're not assessing ability to pay, and neither of those are happening. And then, that restricts me to looking at a person's likelihood of return to court. And what we see is not that. It's that repeatedly, bail amounts and decisions about release, they're really based on the charge. And so when they are based on the charge, that's a stand-in for dangerousness. So it's not, we don't have a legal statute of dangerousness, but we have judges, sort of informally, and I would say, outside of the law, using dangerousness all the time. And if we were serious about wanting safety, there isn't data to back that up. People accused of the most serious crimes are in some ways like the least likely to be rearrested when they're out pending that case. And we have ample evidence before us in many, many stories, but even within our membership, of people who are wrongfully convicted. So, I think it's something for us all to think about. And, it's like, as a society, can we accept the idea that the accusation of a very serious charge or very serious harm, is that enough for all the protections of the presumption of innocence to go out the window? Because it feels like, and what our members have experienced is like, that's the case. You are charged with murder, and therefore we cannot possibly release you pending your trial. So you have to try to prove your innocence while you're stuck on Rikers, and then you get convicted and exonerated 25 years later, having lost those 25 years. So I guess to wrap up, I'll just say I had the experience a few years ago of going to South Africa, and while there visiting a prison with someone who had been incarcerated at that prison, and we had the oddest conversation where we realized like we couldn't, our ways of talking about bail were really dissonant, because they were sort of treated bail as a thing you pay. They were talking about it in a positive way, as sort of like, well, like I was so scared the judge wouldn't set bail, and we were like, what? And what they meant was that they were scared. They were scared of remand being, sort of this other possibility, but that bail was like a thing you pay. And I think that, we in the U.S. and certainly in New York, and I can't speak for elsewhere, but have an experience where people are talking about, clearly our collective experience about bail when we talk about it is a thing you don't pay, a thing that holds you in. And there's been some debate today about whether or not people should be held in or not. But the idea that bail is remand is sort of like the default that we're operating from, and so I think that continues to be a deficit in the implementation.
And you highlighted a few different things, and I think there's something to say about the use of jails and what people experience while there. And it was pretty clear that the legislative intent was to create alternatives, right? To say mandatory, most cases, people charged with virtually most nonviolent felonies and misdemeanors would be subject to a release, with the understanding that instead of jail, you could use alternatives to incarceration, where it steps in some of these pretrial services that we're talking about. Another thing that was included in the statute, at least upon when it was revisited in 2020, was this use of mandatory programming, right? It became something that courts could explicitly order for the folks who appear before them, the accused individuals. They had this option to say, while you are released, waiting for your trial, you can participate, I'm ordering you to participate in some sort of program that meets some sort of need, right, of that individual. And what I would like to ask is, how, there seems to be consensus amongst the folks here, right? We talked about the human interaction. We talked about, supervised release and so much more, right? And linking people to these things. How have you, and I'm sort of giving this to anyone who feels comfortable responding, is how have you seen that particular part of the statute used? And then maybe share, what about that has been going well or not?
So one thing that's clear, just looking at the Rikers population, and I'm sorry that I can't speak for the rest of the state, the Rikers population has a minimum of 60% of the population has a diagnosed mental illness. And I'm not talking about people who have never been diagnosed. So we are mass incarcerating people who have a mental illness, who have clearly fallen through the cracks. And unfortunately, many of them are dying at Rikers Island. So the last death, which was less than a week ago, was a suicide. And so I do think the legislature, especially with the 2022 amendments, recognized that there is mental illness that is issues that are being unaddressed in the criminal system, and I can't call it the criminal justice system, but in the criminal system. And so just with the one amendment to CPL 510, there was a reminder to judges. And one of the most important reminders is, as a condition of release, a judge can send someone to a treatment court or to a court for judicial diversion, which is under Article 216 of the Criminal Procedure Law. And that's right now, it's for substance use disorders. Hopefully, it will expand into, some people have a mental illness and they don't have the substance use component also. But it's a recognition that people who are mentally ill, the fallback and the default should not be jail. But what's very clear for those who have a serious mental illness diagnosis also is that many of them don't have supportive housing or they've lost it. And so there are issues with resources. And I'm not saying that it's easy to treat someone with a mental illness, and this is just for someone who doesn't even have a criminal case pending. But when you add on the criminal case that's pending, and you send them to a place like Rikers Island, even on a misdemeanor, they're going to come out worse. So many people decompensate when they're at Rikers Island. So if eventually the case gets dismissed because of 30-30 or because the complainant's uncooperative or they get an acquittal, they come out and they're far worse. They've decompensated. I mean, I was just looking at a file this morning. This man has been requesting a mental health visit and DOC is not producing them, right? They are cut off from their psychiatric medication, even though Correctional Health Services has acknowledged that there's a psychiatric illness and that this person needs psychiatric medication, and he's not being produced. So when we're talking about why are we sending people to Rikers Island on charges where they might eventually get an acquittal, or it's a misdemeanor, they might eventually get a 3-month jail sentence because it's a misdemeanor and the DA sees that that's the value of the case. And so what happens then is we just continue with the cycle. We continue with the cycle. And with the 2022 reforms, there's another reminder to judges. You can have pretrial services assist with if someone has to go to the hospital under the mental hygiene law 943 for an observation and evaluation, you can use pretrial services to assist with that. But it's a real recognition that this is a problem and that courts should really, at a minimum, pause before they just default and send someone to jail.
Good. Martha, do you?
So for us, we've had that aspect of as part of our supervision as a mental health counseling or substance abuse counseling, and that we monitor that. We make sure that they get involved in the program. A lot of it is scary for the individual to even make that phone call. We assist in making that. But the judges have been utilizing that in Wayne County for over 20 years. And they acknowledge that there are other barriers that affect a person's life. And if they can get that help, then they very much are open to using that. Right now, it's probably 10% of our cases have that as part of it. The other ones that are certainly the release with the lowest conditions, if we are in talking to that person, even they feel that those issues need to be addressed, we certainly help them do that. And it really affects the success of their case, but the success of their life, really.
One of the things that I truly enjoy, I really enjoy listening to the success stories of people who otherwise would have not experienced success in their lives, but for like your program and the program that you're talking about in Wayne County. And I remember during a lot of the debates and discussions about pretrial services and how, there was a statistic that was presented during the discussions at the Capitol about how 80+% of the people, if provided with good pretrial services, will return to court. And there is no disputing that. I believe that. I believe if there's someone who's on that phone, who's attending to the needs of people, whether those needs be direct needs or other familial needs, I do believe that you're going to get cooperation. I do believe that you're going to get positive outcomes. But I think if we're really serious about pushing this state forward and having, the best systems in the country, then we just have to stop rewarding our elected officials with the simple passage of things when they're not funding those things. Because you might have a robust system in New York City, but that's not the case in 57 other counties, which is why 57 other counties have to struggle to come into compliance and do the best that they can. Can it be better? Absolutely, yes. I've been living at the bottom of the hill from the state capitol for over 20 years. And it's one unfunded mandate after another, forcing local municipalities to struggle to comply with those unfunded mandates. But if we're serious about change, about reform, then it's not just, hey, here's the signing of the piece of legislation. And by the way, signing a piece of legislation without also writing a check, it's called palm card reform. They can talk about it in their next campaign for re-election, but they're not really serious about it. Because if they were serious about it, they'd invest in people.
I just want to remind folks that we're in a few minutes. I'm going to open it up for Q&A. So if anyone wants to tweet a question or just wants to think through what you would like to ask, just giving a few minutes warning. Sarita, did you want to comment?
Yeah, I mean, I think that what you touched on in terms of the need to fund the services that are required, whether they're attached to a law or because they've been needed for for decades. Absolutely, and where I think where some disingenuousness from some of the most vocal opposition is exposed is that it's the same people who were sort of most ready to pounce on bail reform as the boogeyman have been trying to defund social services for the last and succeeded for the last several decades. So so there's that is true, and it is also questionable then why the response to saying bail reform, there were things needed in addition to bail reform, why that would then go to weaken bail reform or put more things back in the bail eligible bucket rather than invest in services. Because I think if all the energy had been let's invest in services, that would have been a very different discussion. We would have come out with a budget that left bail reform intact and funneled a respectable amount of money into services that could possibly compete with what we have invested in law enforcement over the last many, many years. And just to give, an example of this, I think that in New York City, and we recognize that New York City is not the only city in the state and is an outlier in certain ways, but it serves as an example that New York City's jail population has been declining with, some ticks up and down around COVID that were non-typical, but has been declining for 25 years, is 75% of what it was 25 years ago. And we left all of that money in corrections. They did not lose a dollar. And so, yes, are people still struggling? And there's a gap in services? Yes, because nobody's had the political will to say, we don't need all those correction officers. And so instead, what would have been really positive would be that people were struggling and we weren't seeing it because we could just hide them in jail. Now people are still struggling and we're seeing it more on the streets because it's harder to hide them in jail. And so the response then needs to be, how do we get that money back? It's not that we don't have money. In New York City, certainly, I will speak for the city that I live in, we have money. It is about the willingness to shift it from where it is not needed to where it's needed.
Okay, I would like to open it up, give an opportunity for either people here in the room with us to ask questions, if anyone has a question on their mind for one or all of our panelists. And for those who are maybe watching remotely, feel free to use the Twitter handle NY Bail Conference if you'd like to ask your question that way. Otherwise, I'll keep asking questions because I do have a few. I will say, I wonder, there's this conversation around resources, right? And I'm hearing an infrastructure that is supportive of social services, right? So this is where those dollars would go. Are there any other hard, concrete, as specific as you can get, examples of where such dollars would go? I also heard from Aweena's earlier comment about just sheer number of people to supervise the larger number of people who are now on supervision awaiting their trial. So any other concrete examples that you all can share? Sorry, if you.
Oh, I don't want to. I'll go after Youngmi because I just spoke.
I think housing is incredibly important because I think when judges see on someone's CJA form that the person doesn't have stable housing, the fallback is jail. And that is just completely, it's illogical to me, but that's what a lot of judges do. I think supportive housing for those with the mental illness, we really need resources there. I mean, supportive housing is incredibly important because I think once you have a physically safe place to live, right? Because I represented I represented a young man who had agoraphobia, and so and just like being in a crowded setting. So I think stable housing is important, and then obviously, the mental health services, more job opportunities, but these are all very difficult for people who've been incarcerated, whether it's intermittent or not, who don't have the stability in their lives anyway. Unfortunately, as a public defender, and I was in private practice, but as a public defender, what we see the most is people who have lengthy criminal conviction records. And I've had that discussion. I see a couple of public defenders here. I've had that discussion pre-bail reform on misdemeanor cases where someone will say, I want to fight this case, but bail is set. They can't even make $750 bail, and they say it's better for me to plead guilty, to take the 30 days rather than wait a year to go to trial on a misdemeanor. And that's how you keep building up, right, that record. And so that's the harm that I think is going to take a long time to undo, because you have this one individual who's taken out of his or her community, right? And all of a sudden a child loses a parent, right? Or a mother loses a son who's helping with medical assistance or whatever it is. And that one person can have such an impact within that community. And this is what happened pre-bail reform. And then you build up, pretty much a damaged record. And this is what we as defenders and as advocates have been talking about in terms of why bail reform was so necessary and why mass decarceration really has to end. Because it's the one person, but the impact is huge.
Sarita, did you, oh, sorry, I was going to go back to Sarita to give her an opportunity.
I just want to quickly just double down on the supportive housing, increasing options, especially in a borough like Staten Island where the options are very limited, and also accessible mental health services, efficient, quick mental health services. Just from a pretrial services perspective or experience, we'll get someone on, released to us, and then, they have a high level of mental health diagnoses or present a certain way in our office. At times it's been violent, and then we find out that, a day later they're arrested in another jurisdiction, in another borough, and then 3 days later they're arrested again. So it goes back to the earlier comment around, what is needed for people who exhibit these behaviors and have this illness, having access so that the person is prevented from, being rearrested. That person obviously needed help and they needed quick access to help, but kept getting arrested and is in Rikers right now on remand. And I do know that person does have severe mental health issues that are likely going untreated and not taken care of.
If I can ask the question, and I'm just curious because I find this aspect of the conversation fascinating. In New York City, when people are arrested on, it could be like disorderly conduct offenses or petty offenses, they're receiving desk appearance tickets, right? Is that?
Many of them are, as long as they fit the statutory criteria, so.
So when, are they connected to services upon arraignment when they're, because your pretrial services, are they being connected then and there?
Well, pretrial services can't be ordered
Yes.
until a judge orders it
Yep.
as a condition of release. And so we're back to the 20-day arraignment period on appearance tickets. The Brooklyn DA has a pre-arraignment diversion program. And so if people want to avoid getting their case even docketed after the arrest, they can sign up for a program so that they don't even have a docketed case, and then the case is over, as long as they do whatever it is that's required of them. But if they do come through arraignments on an appearance ticket, just because it's an appearance ticket eligible offense, meaning it's most likely a misdemeanor, it's supervised release is not utilized because it would just be too much and overkill for that type of person who probably has never been arrested before.
I wanted to give an opportunity, because we have a few minutes left, I believe we have an audience member who does have a question.
Yes, good afternoon. This question is for Josh Soros. I know that you stated that you are not going to speak about the issue as to is bail reform good or bad, but I have heard you outside of the settings complaining that bail reform is creating more crime in your community. Now, all the data that we've seen before you spoke here, and all the data that the leaderships in the Senate and the leadership in the Assembly who was reluctant to roll back bail reform is contrary to everything that you stated about bail reform, like it creates more crime. You know what I'm saying? So my question to you, like, do you like to have everybody who you accuse of a crime to be in jail because it's easier for you to prosecute them, because normally when they're in your custody, it's harder for them to defend themselves. Study shows that when somebody is out of jail fighting fighting a trial, they have more chances of succeeding than to being in jail. And that's why you have individuals who sometimes you are labeled as career criminals when they're not career criminals. Like the council stated that there's people that simply take the 30 days or they simply take the year because they don't want to spend years. And let me tell you, I was in Rikers Island back in the 1990s where people was getting stabbed in their neck and in the eye and losing arms, and it was terrible. It's not good to be in those type of positions, especially for individuals that got a misdemeanor. So, like, what's the purpose of you wanting individuals to stay in prison when the vast majority of them do not pose a real risk? Like, all of those people is not killers. They don't kill people. They don't have I understand that certain really serious cases may require for them to stay in jail until the outcome, even though I don't believe in the system that you all got in place. But what's the purpose? And the next thing, what are you doing about wrongful conviction? I never hear any district attorney complain. Every month we see a wrongful conviction in the news, in the New York Times, in New York State. And none of y'all complain and say, this is wrong. Prosecutors should not be behaving like that. They should not be withholding exculpatory evidence. Y'all don't complain about that. All y'all complain about is incarcerating individuals, and I want to know why.
The name's David Soares, but if George Soares was my father, I probably wouldn't be here. So the reason I stated, and I intentionally stated that I wasn't here to engage in discussions as to whether bail is a good thing or bail is a bad thing, because that wasn't the point of us being here today. I was not on that panel. The point of us being here now is to discuss the complexity of implementation of bail reform and what's the temperature out there, what is necessary, what's good and what's bad. That was the context of the discussion. So that's why I'm here, because I could give you 100 reasons why this process is harmful, right? I can give you 100 reasons. You're going to give me some studies that the Senate and the Assembly conducted to tell me why I'm wrong. But you're going to tell me why I'm wrong when I'm going to work every day and I walk through the same doors, I take the same elevator to the 4th floor, and I'm meeting with my staff in the morning, and here's a person who's committed a violent crime the week before, and he's been out on bail, and he's back again that morning because of another crime. And you're sitting here looking at me, putting your hand up like that, telling me, what? If he's out on bail, why does it have anything to do with? Because the biggest misconception about bail reform is this idea that, well, he had bail set. Except that the finer point that you seem to miss is that bail is set to an amount that they can afford. So if you're telling me that bail in Albany County is been set traditionally as it had been, I'm going to ask you how much time you spent in Albany County. And by the way, the other thing about discussions on this subject matter, which makes it a little difficult, I don't practice law in Kings County. I don't practice law in Manhattan. I practice in Albany County. So when there are generalized statements about the experiences of people in Rikers Island, that's not the experience in Albany County. That's not the experience in Washington County. And so I think we have to be responsible and say that when something isn't working, I can tell you what's working in my community, and I can tell you what's not working in my community. Here's my point, okay? And I've said this publicly. Did we need to change our system? Did our system need to evolve? Yeah, our system needed to evolve, okay? Over 20 years ago, when I first ran, I was running against people who believed that anyone who was doing drugs should be locked up and sent to prison for 20, 25 years. You know, the criminal justice policies of ideologues in 2004 was harmful for 75 blocks in Albany County, because those are the people that were being arrested every single day, sent to prison, and disproportionately punished. And they look like me, they look like you. That's why I decided to get involved. So my criticisms of the current state of affairs with these reforms, okay? These reforms with people who are taking shots at people on a Sunday, when that individual is back out on the street on Tuesday, guess what? You've gone from one person taking shots to people taking shots in the same community. So we've had an increase in the number of gun violence incidents.
So if I could just
Hold on, I want to respond. I want to respond, okay? So now when I see the pendulum swinging and I see policies that are presenting greater instances of violence in my community, guess what? I'm going to talk about that. The one searing question that I've had in my head when I'm listening to different people speak, and by the way, I respect everyone's perspective, okay? I respect everyone's perspective. You speak of people in Rikers Island, and the question that always comes to my mind is, what did they do to get there? Was someone harmed? And why aren't we talking about that person being harmed, right? So, listen. Public
I just
safety.
want to make one. So one thing that
I didn't say that. What I'm saying is, no, what I'm saying is, when people are talking about all of the, and I believe that there are atrocities at Rikers Island, I believe that there's harmful things that occur in corrections. That's not just limited to the city, that's everywhere, right? And so I'm one of those prosecutors that I think real carefully about the decision to send someone to prison. I have more off-ramps from the criminal justice system in my office than any other office in this state. And I'm proud of that because I've been building that capacity for over 20 years, okay? But here's the thing. What I cannot accept is this idea that, oh, okay, we're going to change bail. We're also going to change discovery. So now that someone who's harmed me, who lives 2 blocks down the road from me, is going to have access to my information within weeks of arraignment. Is that sensible policy to you?
So I really appreciate.
Most of the time they know each other. And so what you want to do, you want to keep the system so that the prosecutor could do trial by ambush and give the defendant.
No, what I want to do is make sure that
we really
the person-
appreciate the conversation
No.
that is taking place. We know we are talking about a story that affects real humans, right? This is just not a text on a statute somewhere written up in Albany. These are people coming through the system who are directly impacted. And that's why it's so important that these conversations be based on evidence, be based on data, and that policies be generated based on what we know. And so I want to thank our panelists for offering their perspective. I want to thank our audience for being very participatory. And I'd like to, I don't think we're taking a break at this point. Okay, we're going to take a 5-minute break. We really mean 5 minutes. We have a great panel coming up in just 5 minutes on racial disparities and bail reform, the thing that has been threaded throughout our conversation today, but is going to get clear focus in this panel in 5 minutes. See you all soon.
over, come on. Grab a cup of tea, coffee, a snack, come on over. Wow, that worked better than I thought. Hi, everyone. Great to see you all. We're about to get started on our final panel. Give us 30 seconds just to make sure folks take their seat. Should I go ahead and start? Good. Great. Hi, everybody. This has been such a lively, good, tough conversation. I actually really enjoyed the interactions and the disagreements because I know that this topic, bail reform, has such a tremendous amount of emotion and feeling behind it, as well as what we've covered today, which is the policy, the politics, the data, the research, the impact, implementation, and more. So great to see everyone here. I'm Insha Rahman. I'm the Vice President of Advocacy and Partnerships at the Vera Institute of Justice, and I have the distinct honor of getting to moderate our last panel for the day. And over the course of the day, you've heard a lot about the sort of politics of bail reform, about the law itself, about implementation and its successes and challenges. You've heard a lot of research and statistics. And a lot of the conversation recently around bail reform in the politics and the policy arena has really been centered on this issue of bail reform and public safety. And that's a really important conversation, but I think what often happens in having that particular conversation, which has been sort of all the way up when it comes to volume, is that we miss talking about some of the other really important reasons for why we needed bail reform in the first place, and its impact a little over 2 years in. And one of those important drivers of bail reform that we have to go back to and make sure we never take our eye off of it is the issue of racial justice. And the fact that before we did bail reform in New York, there were gross racial disparities in our pretrial system and who ended up incarcerated pretrial. And the truth is, and as we're going to get into in this panel, we haven't fixed that particular problem when it comes to bail reform. And so what we're going to talk about with this terrific panel is to get into not only some of the numbers, but the stories, and as well as touch on, as we have earlier today, the policies and the politics. And so you've heard already today many important and incontrovertible facts about the impact of bail reform. There are close to 30% fewer people behind bars as a result of bail reform. That's on any given day over 8,000 New Yorkers who are free to go home to their families, to their communities, to their jobs, and not suffer the harms of pretrial detention. And when we talk about the harms of pretrial detention, at the risk of going back to more statistics, and I really want us to get into sort of the stories and the granular realities, but let's just say a few statistics about pretrial detention. For one, we know that there are dangers to it. That is just what the research tells us. The likelihood of suicide is 3 times higher in jails than in the general population. We know that just the fact of spending any time incarcerated at all makes it more likely that somebody is less likely to come back to court or to be rearrested during the pretrial period. And we also know, just on a granular level, when we get to names like Kalief Browder, Layleen Polanco, and many others, that if they hadn't been incarcerated, perhaps they'd be alive and here with us today. So these are all topics that we're going to touch upon, and really through the lens of racial justice. And so, you know, when I say there's been many important and good impacts of pretrial reform, like the far fewer number of people behind bars, one thing that hasn't changed is the racial composition of who is incarcerated. So before bail reform in New York, the jail population was about 58% Black. After bail reform, it's 60% today. And what we also know is, you know, the overall population in New York State of over 19 million people, only close to 16% of the overall population is Black. So that's how, from the numbers, how prevalent racial disparities are when it comes to our pretrial system. And so let's turn to this panelist and get into the conversation. I just wanted to set out a little bit of the framing about why we're focusing on racial justice, on racial disparities, as we're having this particular conversation about bail reform and pretrial justice. And so to my left, I have the Honorable Russ Emerjan, who is a town and village court justice in the town of Hillsdale, which is in Columbia County, upstate. And I'm really excited for us to have the upstate perspective on this panel. I think it's a really important, vital perspective to have. And then we have Katie Schaefer, who is the Director of Organizing and Advocacy at the Center for Community Alternatives, and then Assemblymember Farah Souffrant Forrest, who's representing parts of Brooklyn up in Albany. And then last but not least, Stan Herman, the Executive Director of New York County Defender Services. And so we're going to dispense with the sort of traditional presentation type format and really have a conversation here today. And so one thing I'm going to do, as esteemed as our panelists all are with their titles, we're just going to use first names. And we're going to encourage our panelists to talk to one another. If somebody makes a point you want to pick up on, go for it. And if anybody is taking a little bit too long with their words, I will lovingly jump in and help move us along. And so we will go until 3:40 with the panel itself. Please jump in and think of questions. There are index cards around, or save your questions. And at 3:40, we will transition to opening it up to all of you. So with that, let's get started. So Katie, I want to have you kick us off and talk about what happens when we use bail and impose pretrial detention, which is somebody is in jail. And so often the concept of jail is abstract for those of us who have never spent time there or never spent time visiting somebody we love or we know or that we represent there. And, you know, at the risk again of sort of going back to statistics, I've already said some of the harms that we know of jail and pretrial detention. And at CCA, what you all do is not only work on policy and advocacy around bail and pretrial justice, but you're working to keep thousands of New Yorkers out of jail every year here in New York City, in Syracuse, in Rochester. And really, your organization's mission is that incarceration is deeply harmful and we need to keep people out of it. So why? What is it about incarceration itself that is so harmful and that we need to put front and center in this conversation about bail reform?
So let's talk a little bit about what it means when somebody is incarcerated pretrial. So at a constitutional level, it means that we've sort of fundamentally violated their presumption of innocence, that arraignments last 30 seconds or a minute, there is no finding of guilt, and this person is then behind bars, either on bail they cannot afford, or in cases where they've been remanded. And there is sort of fundamentally a sort of violation of one of our fundamental protections. Secondly, people don't exist in a vacuum. People have families, people have children, people have jobs, people have houses or apartments, people have a whole constellation, a whole world. And if you think about your own life for a minute, you think about your job, your family, your kids, your world, what would it mean if you were disappeared from your life for a day, for 3 days, for a week, for 2 weeks, for a year, for 3 years? Who picks your kid up at school? What happens to your financial aid when you can't attend class? What happens to your dog? What happens to your elderly parents that you take care of? So there's a whole universe of people who are impacted by your removal from your life and your placement in a cage. Then there is the consequences for the outcomes of your case. That one of the things that happens when people are incarcerated pre-trial is that there is a fundamental perversion of our access to justice. In New York State, 98% of cases are resolved through guilty plea. 98%. And so when we think about your constitutional right to a trial, in practice, that is not real in New York State. And there is a sort of a system of laws that have led us to that statistic. But pretrial incarceration is a very meaningful part of that.
that when somebody is incarcerated pre-trial, the pressures to plead guilty, whether or not you have done the harm you're accused of, are very strong. So one of our members, I'll give an example of his experience. He's from Long Island. He was in New York City as a teenager. He was pulled over in a car with a group of other teenagers, and drugs were found in the car. They weren't his drugs, but all of them got arrested, this group of teenagers in this car. Bail was set at $4,000. He didn't have it. His single mom, raising other kids as well, didn't have it. And he spent 3 months on Rikers Island. After 3 months, the prosecutor came to see him and said, if you take this guilty plea, we'll give you time served and you can go home tomorrow. And he said, but I didn't do anything. And the prosecutor looked at this child and said, you can spend the next 1.5 years in here telling people how you didn't do anything. And so what does he do? He takes that guilty plea, he goes home, and now he has a felony record. So this child, just beginning his life, is now going to have a harder time accessing housing, accessing a job, accessing education. And that is the coercive power of pretrial incarceration. You know, Kalief Browder's name has been invoked here already. Kalief did something unusual. It's not that his case was unusual. It's not that somebody accused of something who was sitting in jail because they couldn't afford it was unusual. What was unusual about Kalief Browder's case was that he refused to take that guilty plea, that he was willing to sit in jail for 3 years, refusing to take that guilty plea. That is an unusual amount of fortitude, and one that deeply cost him when he took his life a few years later. So that is the way that a system in which people are incarcerated pre-trial perverts a system of justice, perverts the outcomes of their cases, as well as having an incredibly detrimental impact on the people in their lives.
Katie, I actually wonder if after bail reform, that case you described of the member who took a plea on charges that involved drugs wouldn't have had bail set, because that would now be an ineligible charge for bail. And the trajectory of his case and his life might be very different today. So Farah, I saw you both raise your hand, and then also you have spent time visiting Rikers Island. So getting concrete again about jail. I think there's a microphone for everybody. We don't even have to share.
Plentiful microphones.
Lots of microphones. So please take that microphone and tell us about the visit to Rikers Island, how this connection between bail reform and the growing crisis at Rikers, how is it connected? And specifically, do you think there's a connection between the backlash to bail reform and just how bad the crisis at Rikers is getting? And it is worse today measurably than it was before bail reform happened. We know that from statistics from, Rikers is under federal consent decree. The Monitor released a report just a couple of weeks ago that found that violence was at the highest rates it has been since the consent decree went into effect over 5 years ago. So we know that it is in crisis. And I'm curious what you would say about the connection between the backlash to bail reform and the growing crisis in our jails, and Rikers is not alone in that way.
So while Katie was talking, the statistics of what you had mentioned, 60% of bodies behind bars are Black and brown bodies, right? But then it's only 16% of the population. So what that makes me think of is when I left New York City to go visit my brother in France. First time in a European country, and I'm walking through Paris, and I'm like, oh my God, there are so many beautiful Black men. Now, but listen to what I'm saying. I, being a Black woman with a bachelor's degree, walking through New York City, Brooklyn, I've never felt like, not only am I just looking, but I'm looking and seeing what's eligible for me, what's there, the diversity, what's the pickings that I could have. And so when you see that, whoa, wow, that was like, oh, shoot. So that's what 60% looks like behind jails, because they're not in the community. That's a fact. A best friend, a potential boyfriend, a potential friend, the uncle, they're not in the community. They're not there. They're just gone. They're disappeared, as Katie said. And so when we talk about bail reform, the need for bail reform, and we understand that locking up Black bodies behind prison jail bars is simply because they cannot afford to be out in the street, then you see that, okay, not only are we talking about housing, healthcare, and all of the issues that we have, we're talking about people unable to maintain, criminalizing poverty, basically. And so now I'm like, okay, so bail reform is very important for us to maintain, and how do we do that as a legislature? How do we prepare for that? And I have to say, the members, my colleagues, were prepared. You know, we were thinking that we know that 2019, 2020, 21, the backlash is there. There's the conversation, so we're ready to hold the line. But then when the executive put out her budget, we were like, oh, okay, bail reform is not there. I mean, rollback on bail reform is not there, so we're gonna relax. Until what, 13 days before it was due? We were very upset because this is not what was promised to us. This was not up for discussion. I want everybody to understand, 13 days before, that means we read through the whole yellow book, the first book, we wrote another book, whatever, to write out the budget, and none of this for bail reform was up for even discussion until 13 days before the budget. And now we were scrambling to make up messaging to respond. And that was very upsetting.
Yeah. Well, and what we have seen, and we've suffered now 2 rounds of amendments and rollbacks to bail reform in 2020, and then again, as you were saying, Farah, just in this budget session in March into April. But yet, bail reform is still in effect. There are a significant thousands fewer people behind bars today. And what we're seeing is that it's still under attack, right? The headlines have not gone away. Do you want to jump in and say more?
The bail reform is still there, but there is little chips at the armor, right? And there's this one part that we kept on talking amongst ourselves, which is the dangerousness standard. The idea that you could look at someone and based on their where they live, where they eat, and then predetermine whether or not they were a risk to the community. And when we look at who the New York Post often pegs as like who's dangerous, and remember, judges, juries, prosecutors are all human. They're reading the same stories too. They're going to see that, okay, well, Black man from Whitman houses, 22-year-old, didn't finish high school. Oop, boop, that's dangerous. That person then is not eligible as everyone else.
Yeah. And we can talk a little bit about the dangerousness conversation because I think it is complex and difficult to get around. And one thing I do want to say is people have a right to feel safe. And the public safety conversation is a really important one because if public safety doesn't feel real, then support for reforms erode. I mean, that is what we are seeing loud and clear. But what the point that you were raising, Katie and Farah, is we have to think about public safety broadly, including the safety of people who are behind bars. And that has completely been missing from this conversation about public safety that we've seen in the past couple of years. The outrage about sort of the rise in crime and what link, if any, does it have to bail reform? The numbers show us really not any. But certainly that's not where the politics and the rhetoric is. And so, Stan, I want to turn to you because, Farah, you talked about the New York Post, and we can't ignore the role of media in shaping our perceptions of safety and whether bail reform is working or not. And so a lot has been said already today about, public safety, any correlation to bail reform. But what I think hasn't really been talked about yet that I'd love for you to touch on is public safety, bail reform, and race, because we've seen, based on the race of the person who's accused, the coverage and the outrage around bail reform has looked different in the press. And I'd love for you to speak to a couple of examples of that, and why is that in that way, and also what does it do? What's the impact of the sort of disparate coverage when it comes to bail cases, people accused of a crime, and then our, perception of public safety?
So if it's okay, I'm going to stand up because I think we're going to have some slides. And by the way, the assembly member and I did not coordinate this. So it was a perfect transition. I'm serious about that. And so, what I really want to talk about is the racialized politics around bail reform. And I was thinking about, how best to portray it, and I got all kinds of data, and my data team was working, overtime to get me the data, and they're going to be disappointed that I went in another direction. And so what I did was I wanted to take two very prominent cases that were in the media in the last several months, and really, illustrate this, really in black and white, and how the discussion, the perception, the media coverage around bail reform plays out, and particularly in New York City. And so this young man here, his name is Cameron Williams. Cameron is an aspiring rapper, and more than aspiring, he's actually got a signed contract at the age of 16. His handle is C Blue from the Bronx. I am not familiar with C Blue. I did want to go on YouTube and see his video that apparently got like 2 million views or something, and I'll do that. But for purposes of this discussion, C Blue was standing on a corner hanging out with the fellas in the Bronx when he was approached by police officers. The police officers claimed that they were acting unruly and suspicious and all of these things. And he got what I would say was manhandled and searched. Mr. Williams did have a loaded weapon in his pocket. Nobody knew that when he was stopped. And during this kind of back and forth, the gun accidentally went off, striking Mr. Williams in his leg and also striking the police officer. And so those are the facts of his case. On the other side of the spectrum, we have Lauren Pazienza, somebody that the media has described as a socialite, apparently comes from a family of means in Long Island. This young woman is accused of pushing an 87-year-old senior citizen in Chelsea to her death. I don't know the facts, and I'm not here to condemn anybody, but from what I read, she walked across the street, went up to this 87-year-old senior citizen, called her a bitch, pushed her to the ground. The senior citizen struck her head on the sidewalk, got a cerebral hematoma, and died. And there was a lot of coverage around her. Apparently, she was a beloved singing coach and just an incredible woman whose life was cut short. So, on the one hand, right, manslaughter, right, pushing a senior citizen to the ground. And on the other hand, we have Mr. Williams possessing a weapon in the Bronx. And so the portrayal of Mr. Williams, right, was what you would expect, right? Fox, the New York Post, New York City teen charged with shooting NYPD cop walking free on bond, right? He was not charged with attempted murder. He was not charged. He was actually charged with a reckless assault because everybody agreed that it was an accidental discharge of the weapon. Now, the judge in that case said, I believe it was $250,000 bail and bond in that case. And, Mr. Williams, right, because he's not just your average 16-year-old, right, he's a rising rap star with a signed contract. And so what everybody was shocked about is that this young black teen, unlike most, was able to post bail, right? This was a bail-eligible case. It was bail-eligible before January 1st, 2020, and it's bail-eligible today. $250,000, right? I'm not making $250,000 bail, if that's set on me. But the response was pretty typical. If anybody wants to know why we have a crisis of violence in this city, look no further than this disgraceful release, said Pat Lynch, the president of NYPD's PBA. Then he takes a shot at the judge. Shame on Judge Dennis Boyle for allowing this to happen. Now, Judge Boyle followed the law. Judge Boyle, in his infinite wisdom, thought that $250,000 for these facts was appropriate. The mayor went on to say that this is further proof that our current bail system is failing us. Well, no, Mr. Mayor. This bail determination could have happened 5 years ago as it did today. So this has nothing to do with bail reform whatsoever. Now, let's go to a portrayal of Ms. Pazienza. You know, fatal New York City shoving suspect, Lauren Pazienza makes bail. That was the New York Post. So in that case, right, this individual, according to the prosecutor, I'm not saying I agree with it, fled the scene and hid for several days. According to the prosecutor, took her cell phone, stashed it at her aunt's house, went to Long Island in Port Jefferson, New York, and hid in her mother's and father's home. When the police caught up and they went to the home, the father said, I don't know what you're talking about, she's not here. 3 days later, she gets a lawyer, she turns herself in to the police, and she's taken for her arraignment. The judge, in that case, again, in their infinite wisdom, this case was bail eligible before, bail eligible today, set $1 million bond or $500,000 cash. It's a lot of money. And so Ms. Pazienza's mother, about 2 days later, goes into Rikers Island, breaks out the checkbook, and writes a check for a cool $500,000. Pazienza gets out, and she goes home. So now let's see, you know, the reaction from the police commissioner and the mayor and the PBA and the outrage over the bail determination that led a white woman who pushed the senior citizen to her death. And let's see what the reaction was. Crickets. I had my team search. I mean, I was like, they must have said something. Something. Nothing. No outrage over the bail determination. No calling for that judge's resignation for setting $500,000 bail. They said nothing. Right? And so at the end of the day, we could get into all the statistics and everything we're talking about here and all day today, but it's one system, it's one bail law, and it's two realities. And so what the original bail reform was about was trying to create a more equitable system. A system where somebody isn't held in on bail because they can't make $500 bail, while somebody charged with a manslaughter, well-to-do, can write a check for $500 million and fight her case from her home. Now, I'll wrap it up real quick, but just a kind of a quick check on what's happened. Surprisingly, Ms. Pazienza shows up for her Supreme Court arraignment with her lawyer, and she got remanded by the judge, which is kind of striking, citing that she's a flight risk, despite the fact that she showed up to court knowing she was charged with manslaughter. My guess is the lawyers are going to appeal that, and my bet is bail is going to be reinstated. Mr. Williams' case was dismissed. Yeah, the guy who we should be deemed dangerousness and locked up was dismissed. Why? Because the judge found that the officers lied about how they approached them, why they approached them, and all the circumstances. Right? And so the reaction from the PBA and the mayor wasn't to condone, because when an officer lies, that's called perjury, right? But they didn't condone it. As a matter of fact, they doubled down and said, well, we shouldn't be so harsh on the officer. Right? And so Mr. Williams' case dismissed, right? Because everything that happened was caught on body cam. So the judge looked at the footage, looked at what the officer said, and said, well, officer, you're lying. And his case was dismissed, and we'll see what happens with Ms. Pazienza's case.
Thanks, Stan. It is a very black and white, stark sort of depiction of the media coverage, for sure. Russ, I want to take us upstate, because we can't actually let this conversation be entirely driven by New York City, and race and racial disparities are very real in upstate New York as well. And I think one thing that a lot of people in this room might not know is how arraignment practices work in upstate New York, because in especially the town and village courts, it looks different than if you've sat in court in Brooklyn or Manhattan or even Albany or Binghamton. So Russ, could you start by saying a little bit about what arraignments look like before bail reform, and then say 3 things that have changed in your bail practice as a result of the law?
Yeah, is this working? Yeah. Town and village courts, there are about 1,300 of them across New York State. There you go, thank you. Town and village courts are small local courts, sometimes called magistrates' courts. Across New York, there are 1,300 of them. In Columbia County, where I'm from, I'm forgetting the exact number, but there are about, I think there are 26. And the judges who serve those courts, by the state constitution, villages, which are sometimes larger than towns, get one judge, whereas towns, which are sometimes smaller than villages, get two. Judges are elected. A good number of the judges in upstate New York are non-attorneys. There's a large controversy about whether non-attorneys should be judges or not, and that's a different conference. I'm a non-attorney, judge. I started my career in criminal justice about 40 years ago as a social worker working for legal aid in the Bronx. And my one venture, my one connection to Rikers Island is that I had to go to Rikers Island from the Bronx to visit a client. And what I remember most is not the client, not the conditions, but the fact that it took all day to go to Rikers and back, which was very inefficient, a waste of resources and such. And also there were all sorts of other problems. So I'm familiar with courts that have large minority, so-called minority, populations. In upstate New York, not including, I'm excluding the cities now. In the outlying areas, by and large, courts there are populated by mostly people who are of white background. When you see if a black person, for instance, comes into my courtroom, I notice because it's an unusual thing. Many years ago, I was living in Portland, Maine, and I had a friend who was black help me unload my apartment because I was moving actually to Albany, and we're in the van packing things up, and we both look out the back of the truck, and coming down the street is another black man, and my friend does a double take because in Portland, which was a largely white city, seeing a black man was very unusual. So in Columbia County, where again, all the judges actually are white. There's been one black judge in the county, but he retired a number of years ago. In the city, the chief of police is black. All the prosecution staff, the district attorney and the assistant district attorneys, they're all white. The public defender's office is populated by all white attorneys. Probation department, as far as I know, is all white. In terms of courts, before what we're calling bail reform occurred in 2019, 2020, the typical thing would be police officers would bring defendants into the courtroom for an arraignment. When I first started, I've been on the bench for about 20 years. When I first started, the police officers actually served as prosecutors. That number of years later, that was changed, and police were no longer allowed to serve as prosecutors. So the prosecution office took over that duty.
And Russ, if I could jump in, what you meant by that is, so at arraignment,
at arraignment.
literally be that the judge would ask, like, what are the charges? It would be whatever the police officer, decided upon arrest, and they would request a bail amount as well. Sometimes having talked with the DA's office, but sometimes
Well,
not.
yeah, it's actually a little worse than that, in the sense of the police would come in and they'd have their arrest reports and some background information, scant background information. And sometimes actually the officer bringing the person into court wasn't actually the arresting officer, but it's simply a transporting officer. They would come in, sometimes you would ask them, the police never had recommendations about bail. You'd ask if they'd been in contact with the prosecution, whether they had recommendations. Occasionally, the answer would be yes. Many times, for more serious sounding offenses, at least in Columbia County, the prosecution would say 20,000, 30,000, so on and so forth. And they were basically extremely arbitrary, numbers. At the time, defense attorneys weren't present. A number of things happened in ensuing years. We now, and this is, around the time of bail reform, a bunch of things happened. Some separate reforms, as well as, of course, the pandemic. And they affected different offices differently. The public defender's office got state money to hire a nighttime defense counsel, independent nighttime counsel, to come to arraignments. And so judges, so this is now sort of after bail reform, or about the same time. Judges would get a call, after hours, late in the evening, early in the morning, and say, from the police, saying, we have someone for you to arraign. You'd ask a couple of questions about it. Then you call up the designated defense counsel, and you'd arrange to have him come to the court at the same time that the police and the defendant, were there. And then there'd be a conversation. Again, the police officers didn't just give you the paperwork. The defense counsel would talk quickly to his defendant, and the prosecution wasn't present. They're never, at least in Columbia County, and it may be different for different counties. They just simply aren't there. There's no recommendation one way or the other for bail. So in essence, it's entirely up to the judge.
So now, after bail reform, you have a prosecutor actually evaluating the case. You have defense counsel there.
The defense counsel are there both at the arraignment and when they next come to court.
Yep.
Prosecutors are there when they next come to court, but they're not there during their arraignment.
Got it. And so when we look at the numbers when it comes to bail reform and upstate New York, I mean, one of the, I think, really staggering statistics is before bail reform in upstate New York, the jail population was 80% people held on misdemeanor and violation-only charges, because bail could be set on any kind of offense, including very low-level offenses. And that has changed dramatically after bail reform, but the jail population in terms of race and racial disparities hasn't changed.
That's right.
And so, Russ, I'll stay with you for one more second, which is to talk about the issue of town and village courts. By and large, we don't have much data on what's actually happening in terms of bail practices there. We do in upstate New York city courts, which are the big courts in Binghamton, Albany, Buffalo, but you go right outside of Buffalo City Court and, 15 minutes away, it becomes quite rural. Those are the towns and villages. We don't have information there. So as a judge, if you could just say a little bit about, what impact does it have to not know, what is actually happening with your bail decisions or your colleagues' bail decisions? And I would also love to hear, how is the sort of the controversy around bail reform played out in Columbia County versus what we've seen here in New York City?
Yeah, well, give me that last part.
Sure. So two things. One is, you don't have information about what happens sort of with your cases or your colleagues' decisions in the way that we do for city courts. Why is that a problem, is basically the question. Then I'll get to the second one once you answer that.
Good. Well, it is and it isn't a problem. I mean, my background is, I've been involved with criminal justice issues for a number of decades, and so I'm familiar with the historical debates about pretrial justice, going back, considerable amount of time. And so, I'm also familiar with a lot of the pretrial literature and so on and so forth. So I tend to know what a lot of those issues are from the literature. But also, the court system itself does a good and a wobbly sort of thing. On the good side, they urge justices to treat everybody fairly and decently, respectfully. They urge judges to seek out the least restrictive alternative. They urge, even before bail reform, to take a look at, to consider a person's ability to pay bail. Then there's just a larger question. Well, they urge those things, but they don't. The court system with town and village justices doesn't do a sufficient amount, I think, in going more deeply into what each of those means and how that applies to the practice of the individual judges. As I was saying earlier, there's diversity in the judges in terms of being a lawyer or a non-lawyer. Judges don't communicate with each other very much, but from what I've heard from other judges, I don't necessarily see any disparity between leniency and toughness or punitiveness in terms of being a lawyer or a non-lawyer judge.
And so in terms of the public conversation around bail reform, 2 years in, we've seen what it looks like in New York City, where there are advocates, elected officials who are strongly in favor of it, protecting the law, and folks who are strongly opposed to it. And it's a everyday conversation, especially leading up to things like the budget and making changes to the law. What's that conversation like in the local news, sort of in the local community in Columbia County or other parts of upstate New York? Does it look like the New York City conversation, or is it different?
Different.
How so?
Well, I've been a judge in Hillsdale for 20 years, and for one term, I was the judge at the neighboring village of Philmont. Never, in my experience, has there been a reporter in the court. So, and actually, before becoming a judge, I was actually a reporter for a local newspaper for a certain amount of time. But the local papers don't have resources, and they don't have staff, and I'm not even sure they have the inclination to go into courts. So you don't see them in courts. So there's no coverage. The only coverage of any criminal justice wise is when the district attorney's office issues news releases about so and so was arrested for such and such offense and was released on bail or sent to Columbia County Jail on $500 bail or whatever it is. I'm not even sure the press releases are that detailed. And that's it. That's pretty much it.
Yeah.
And there's no follow through. There's really no controversy, no public outrage, no public support for that matter.
Yeah. So, I mean, I spent a fair amount of time in upstate New York, given my job, and it's the same, where I don't see that same sort of outcry in the way that it is just part of everyday conversation where you go here in New York City. And it goes to, Stan, the point you're making about media coverage and whether this conversation is sort of alive in the media and in the headlines or not. So we'll switch to Q&A in just a minute, but I want to end with asking each of you a question about solutions. And one of the things we have seen since bail reform went into effect and that it has been blamed for this very real increase in crime, especially shootings and homicides since 2020. But the real question is, are we blaming the right cause? And if we are blaming the wrong cause, are we missing the right solutions? We have seen, like I said, 2 rounds of rollbacks to bail reform in 2020, again here in 2022. And in that time, shootings and other kinds of violence haven't abated, which really begs the question of, are we searching for the right solutions when it comes to public safety? We haven't, as a field, had a conversation about the right solutions to address racial disparities since bail reform went into effect. And so that's my last tough question for each of you. Sort of lightning round, 1 minute if you can. If you could pick one solution you would push in your role to address racial disparities in bail reform, one fix to the bail law, one policy change, one practice change, what would it be? Stan, you look like you're done.
1 minute's going to be tough, but
I will
one
try.
of the things, and the prosecutor who was on the last panel, I think he was trying to get at this, is that, there's a gap in services. So a homeless person comes to arraignments in Manhattan, right? He has to be ROR'd if he's charged with a petty offense, like a petty larceny. He stole something from CVS because he was hungry. We give that individual a piece of paper, and we say, see you in 30 days. And by the way, if you're on supervised release, we'll see you tomorrow for an appointment. So that person walks out the door, and guess what? He's homeless. No services. Nobody there to help him. And so what we need, in my opinion, like why isn't homeless services embedded in arraignments? So you can immediately, right, provide services and try to help that individual. Why don't we have mental illness ACT teams in arraignments? So when we know that that person is odd, right, but it's a mandatory release, why don't we have the ACT teams there to actually help with those individuals? Instead, we say, here's a piece of paper, see you next time, and then we're all shocked and dismayed when the person gets rearrested again.
Yeah.
So I think it's an investment issue and a policy issue, and I think the city should, meet people where they are. And unfortunately, homeless people, mentally ill people, we find them in the criminal legal system.
Yeah. Okay, so that was actually close to a minute, Stan. Nice work. And I will flag that in the budget that did just get passed, I believe the dollar amount is over $600 million was set aside for mental health services, other kinds of supportive services. And now the big question is it actually going to be implemented in the ways that you're talking about? So who wants to go next?
Just to piggyback on what Stan said, really using that moment where we get people into a place where we're discussing the issues that allowed to get them to this place, and then seeing what we can do moving forward. Because really, when we talk about public safety, it's an issue with what we have in the community. And so if you look at the best communities, the safest communities, are communities that are most resourced. And so one of the things that we cannot ignore is the trauma of what poverty does to us as people in the community. And so when we catch this person, when I say catch, I mean they're here, they're there, and we're like, okay, so what is going on in your life? And how do we make it better for you so that we don't keep having you revolving in and out of the system? And so treatment, not jail. We're saying that, you know what? We know that trauma brings about mental health, brings about issues. Thank you for putting on your mask. Thank you. But now we're going to create a service pretrial where, you're going to go to see a therapist. You're going to get back on your medication while you're waiting for us to discuss the crime that got you in here. And so this is shuttling. This is what I wish that $600 million would go to. Pretrial mental health services.
Yep.
That's my
Just
bill.
real quick. So Assemblymember Forrest is the Assembly sponsor of this bill pending up in Albany. Senator Ramos from Queens is the Senate sponsor, and we really are trying to get it passed. So reach out to your local electeds. Treatment, not jails.
And just one more thing. I'm only saying this because as a nurse, I'm a nurse before an Assembly member.
Yep.
And I just, again, it's like you keep opening a wound. You're not allowing it to clean out and heal. Yep. What are we doing by just picking up the homeless man and then throwing him back into the state of homelessness? That's nothing.
Okay, so two things. First, piggybacking off of you all, I actually think we need to go farther than just talking about services, right? There is and has been an intentional disinvestment from Black and Brown communities that is rooted in deep systemic racism. And so we don't just want homeless services in arraignments, although certainly that's a piece of it. People need housing, actual long-term stable housing, not a bed in a night in a shelter.
And so I think we need to be talking bigger and grander in terms of how do we actually reinvest? How do we make sure that people have access to safe and stable housing, to jobs, to healthcare, et cetera, in a much bigger way? We have systemically denied people that, and so we have to do that systemic reinvestment. The second thing is I think there's real work to do around judicial accountability. We have had in the last handful of years a very real conversation about prosecutorial accountability, and that has led to campaigns, electoral campaigns of quote unquote progressive prosecutors. It has led to far greater attention on prosecutors' offices. Now, we can debate whether or not that's worked. There's some people who have been here who have claimed to be progressive prosecutors, and that's debatable. But at least there has been a conversation about the power that prosecutors wield in this system. There has been an insufficient conversation about judges, and that in cases that are bail eligible, where judges can set bail, we see racial disparities in bail setting. And we saw that prior to bail reform, and the outcomes were worse prior to bail reform because we saw those racial disparities in bail setting on really low-level cases, and now we see it in a smaller number of cases. But I think there is a real question about who sits on the bench. Judges are overwhelmingly disproportionately white. They are overwhelmingly disproportionately from prosecutorial backgrounds. And we see that at every level of the court system. And that, I think, is a real piece of the conversation we need to have. Sorry, that was more than a minute.
I was just about to cut you off, but you knew exactly when to land.
I saw you move out of the corner of my eye.
Katie and I have worked together long enough earlier. We know when to roll it up. I will also say this as part of the data, and I keep going back to the data because I think it is really helpful to look at the numbers and then give them color and texture and put real people and experiences to them. But in New York State, we actually do have for city courts a significant amount of data by judge on pretrial practices, and that's quite unprecedented. We don't have it, though, for the town and village courts. And then, Russ, you have the last word. What is the one solution you would push for to address racial disparities?
Well, I'll give three.
You only get one.
Well,
He's got 1 minute, but he can do 3 solutions.
well, the solutions are resources, resources, resources.
You did well. Good. You can keep going.
I mean, I've been here all day, and I've been extremely impressed by the people who've been presenting, and they've said this over and over and over again, during the course of the day, and most of those people were talking about New York City, and the advantage of being in New York City is that you have a lot of resources. That doesn't mean you don't need more or services redirected, but in upstate New York, for the most part, there aren't the financial, fiscal resources. There's also not the training resources for prosecutors, defense attorneys, judges, probation officers, any of those professions. And there's no discussion, no training for issues like, what's the least restrictive alternative?
Yep.
What do you do when you're trying to assess whether somebody can afford bail, and so on and so forth. So again, resources.
Yeah, and I'd say across the spectrum, doesn't really matter where you sit on the sort of is bail reform working or not. I think most folks can get behind putting more resources into the system. So let's turn it over to you all. What questions, comments do folks in the audience and folks virtually, you can tweet, I believe, a question or a comment in. And if you don't mind, just say who you are so we know who we're speaking to and speaking to the microphone.
Okay. Hey, my name is Stephen. I graduated John Jay here last May, and I'm currently working in the DA's office in an entry-level position. So I have a question for either of the panelists. So I agree with, I've acknowledged the facts, and I agree with the terms of bail reform. I think it's something beneficial for the state and for the country. However, over the winter, while I was at work, I'm walking towards my office, and I overhear a woman pleading to the desk officer of why her spouse was released without bail regarding a domestic incident. So my question is, what is your opinion with bail reform regarding domestic violence incidents? And I know that in Rikers Island, there's a lot of risks going into Rikers. It poses many risks. But who is more at risk? The one potentially going into Rikers or the mother and her kids at home?
So I just want to say that domestic violence charges are bail eligible, right? So it wasn't that the judge.
Stan, grab a microphone so folks.
Domestic violence
hear us.
charges, even misdemeanors, are bail eligible. So that judge decided not to set bail for whatever reasons. But it wasn't that the judge could not set bail.
Can I add to that? So I think that collectively, we have been failing survivors of gender-based and familially-based harm for a very long time. And some of this goes to the sort of moment in the 1970s, as the sort of like second wave feminist moment that turned to police and the carceral system as a solution to intimate partner violence. And that was led predominantly by white middle-class women who saw that as sort of the solution to this kind of harm. And we have watched it fail for huge numbers of people, but particularly for people from marginalized communities, for queer and trans people who are survivors of familial-based and intimate partner violence harm, for Black and brown people, for anybody in which police come into a situation and there is not the assumption that they should be there helping you. So we had a member who is a Black woman whose husband is a white man who had called the police many times to try to get help in intimate partner violence. The one time they showed up, her white husband told the police that she was the aggressor. She was arrested, bail was set, and she spent 2 years in the Westchester County Jail pre-trial and ultimately took a guilty plea. And so I think rather than sort of doubling down on a system that just hasn't worked for survivors, we need a collective rethinking of what it will actually mean to keep survivors safe. And some of it people have really been asking for, right? There is insufficient housing resources for folks looking to get out of abusive relationships. And the housing resources that do exist are often short-term. They can be hard places to bring kids. They can be sort of collective housing in ways that I think people often find pretty hard. If we gave survivors more of the resources, housing resources, financial resources, other kinds of resources, that is something that people have been asking for and that we have been failing to give people. And so I think your question is a really important one, and I think we need to have a much bigger and broader conversation about how we support survivors of intimate partner violence.
In upstate New York, after bail reform, when a police officer arrests somebody, if there's a request from the victim of an order of protection, the defendant is brought to court right away. I should have mentioned this earlier, but arraignments happen, within hours of arrest. But the police do bring order of protection cases to the court right away, and then there's a question of what to do with that. And in Columbia County, at least, there's like almost all of these defendants are male. Anger issues are involved, etc. There's no place to refer them to or send them to. So again, it's resources.
Yeah.
No one knows how to talk, because conflict is, you have to learn how to do conflict resolution, even on the part of the victim or the assaulter, right? Yeah. But the idea that people need to have conversations. I've dealt with domestic violence victims, and yes, police come in, pick them up, or drop them off, whatever, but no one tells you how to talk. Because he's still the mother of he's still the father of your children. She's still the mother of your aunties, uncle, everybody's involved. The neighbor's involved too. So no one's talking about how to move forward with this. Yes, a harm has been done, but we have to move on and heal. And how do we do that? No one knows. Nobody's talking, nobody's investing in these conversations.
I mean, what we're hearing very clearly is the best investment in public safety and accountability is a third way of support and resources that we just don't have on offer right now. So thank you for that great question, Steve. I have, so I will get to you in just 1 second. We have one question from the Twitterverse. It's somebody, Mr. Spite Miller from Noble, the New York chapter, and Noble is the National Organization of Black Law Enforcement. And this is Mr. Miller's question. How can local law enforcement organizations provide knowledge-based support to the judicial system and lawmakers? So what role is there for local law enforcement to do education around bail and criminal justice reform?
From what perspective?
Well, answer that question how you'd like. I'd actually be curious, Russ, because you raised the issue of sort of training and information. Are there things that you would want to know from local law enforcement, or is there a role for law enforcement to play in your sort of building your knowledge or education?
Well, there are problems there because that, and this may blend in with the mental health debate too. That puts the police officer in the role of social worker, and they're just not qualified for that. Also, local police officers tend to know everybody, and so there's an inherent problem of them dealing with people that they actually know, and even with the simple situation of you go to the house, you find out what's happening, you arrest somebody, even that's problematic. Personally problematic for the officers involved, because they feel frankly a little helpless themselves.
Yeah, I mean, that's a really helpful perspective. That as a judge, no, there's a degree of impartiality that's needed in terms of vis-a-vis local law enforcement.
Yeah. The other thing is that, going back to the arraignment session in court, when order of protection requests that come in, there's a defense attorney there, but typically they don't follow through with any ideas about references or referrals or the like, and the police don't have any referral ideas either, and so.
Yeah. Katie, you look like you're going to say something. I would love to jump in on this question because I think it's a really important one too. No, go for it.
So I think one of the really harmful ways we've seen police, and more specifically police unions, engage in this conversation is that they leverage their relationship with local press to push fear-mongering stories solely from a police perspective ahead of any actual fact gathering on the case. This is also a problem of local news who print these articles exclusively from the police perspective. And so in the case that Stan was talking about of Sea Blue, we had the Post, the Daily News, all of these outlets writing stories from the police perspective about how this teenager had shot a police officer. All of those stories turned out to be wildly untrue, right? This young man was tackled by a police officer and a gun that was in his pocket went off and went through his leg. But by the time the correction comes through, that initial false story is already everywhere. It has already shaped the narrative. And so I think part of it is that we really need law enforcement to not be pushing for press stories sort of at the moment of arrest, to not be pushing for press reports that include only their opinion, to not be pushing for press reports in which they are acting as if there has been fact-finding in a case when there hasn't been. And I actually think that would be the most helpful thing that police officers could do in this conversation.
To pick up on your point, Katie, I think one thing that we should expect of law enforcement as folks who are stewards of not only public safety, but of public confidence in our justice systems is to report accurately. That feels like a basic expectation that I think law enforcement agencies like Noble that are concerned about being on the right side of justice, I think there is a role for you all to play in calling out and naming when we see law enforcement deliberately, manipulate facts or weaponize cases or incidents in inappropriate ways. And we have seen some law enforcement folks actually step up and do exactly that. And when we do, we actually get to have a real conversation about public safety, not one that is weaponized and sort of on the offense or on the defense. So I think there's an important role there.
I think part of what's hard about this is that often that honest conversation requires an admittance of police misconduct. That in the case of Sea Blue, what comes out is that the police officers wrongfully approached this teenager, that they put hands on him in an inappropriate way, and then they lied about it in court. And so it requires, and I think this is one of the reasons that we have not seen law enforcement, frankly, truth tell about this, is that it requires you to say that the police officers in the case conducted a wrongful or illegal search, that they did harm in doing so, and then often that they lied about it. And I think we're gonna need people to step up and be willing to say that, but I think that is sort of a key part of the problem.
Thanks for that, Katie. And then there was a question over here.
Yeah, so it's not as much of a question, more as just to bring light to like the other side of the perspective, right? I think you mentioned at the DA's office you had a woman coming in wondering why he was released on bail, right? And I think on the other end, I'm a public defender from the Bronx. We have CW's, the complaining witness, right? Oftentimes it is one woman. Calling our phones nonstop, saying the prosecutor's not listening to us. The prosecutor thinks they know my family better than I know my family. I need resources. I need him back in the house so that we can go to couples counseling so that we can properly raise our children together, right? And I think that I've even had a woman come to the courthouse asking to speak to the judge. I want to speak to him since the prosecutor doesn't want to speak to me, right? And so I think that, like you said, the powers really being taken out of the victim's hand, whether it's a man or a woman, right? And I think that people are making assumptions of what's best for this family when we really should be giving them the voice, right? And letting them speak. Because I think in some circumstances, everyone is a victim in that family, the children, the alleged perpetrator, and the victim. And so just to give a little bit of context, because I think both situations do occur.
And if you want to look at that in the context of racial disparities, when I was in private practice and I had that white, educated Wall Street person charged with domestic violence, first thing I did is I put him in private counseling sessions, right? And then I spoke to the DA, he's getting help. And the approach was completely different than if I was representing an indigent person, right? Charged with the same exact facts. So even the way the prosecutors handle those cases is very different through a racial lens.
Any last questions before we close this out? Thank you. Oh, do you have something to say, Farah? Want to jump in?
I find that sometimes people are like, oh, I was called a criminal justice reformist, and I'm like, that's really weird for me because I'm just bringing in the perspective of how we do things in nursing, in care, right? That is very much evidence-based. I mean, patients die. We kill patients, doctors, nurses, PAs. Patients die, patients lose a limb. But at some point, we have to have honest conversations with each other. We have to look at the chart, review it, second by second, and we have to be transparent with each other. This interdisciplinary kind of conversation. And what comes out of it is not you messed up, but rather we need to do better. And how can we keep that up? And so I want people to feel like they should be a part of, that someone says, I would like training, or I want to give training. I don't balk at that, but rather see it as an opportunity for us to have conversations. So I'm just saying, this is very strange for me to be in this space where, no evidence is coming up saying this is how the numbers are. So to even begin the conversation. So this is why I think it's so important for us to seek out how to quantify what bail reform is, and then be able to say, okay, here's where we're messing up, and here's how we're getting better. But it boggles my brain, and I have to be. That was a real moment for me. But even on this stage, how like these conversations happen and no real numbers, no real people are then linking up with these numbers and really trying to find a solution to move ahead.
So, in short, my mother's a retired nurse for 40 years, so I'm all with the nurses. Nurses, we can learn a lot from nurses.
Well, I mean, I think that's a really nice segue to give a big shout out to the Data Collaborative for Justice and John Jay for hosting this conversation because it is about finding the evidence and looking and not making assumptions or going back to our political positions, but actually having an honest, real conversation about what drives justice, what drives public safety, what drives racial justice too. So one more quick round of applause for our wonderful panelists, for Stan and Farah, Katie and Wes. And with that, Erica, I'm gonna turn it over to you. Oh, there you are.
Good afternoon, everybody. I'm Erica Bond. I'm the Vice President of Justice Initiatives here at John Jay College. A couple of announcements and remarks before we hear from our last speaker of the day, Jeremy Travis, who we're really thrilled to have here to give us closing remarks and wrap up this really informative day that we've had together to talk about New York State bail reform. I want to thank you all for joining us today, both here and at home. I really appreciate all the time, the attention, and the dialogue that we've had here today. I'd also like to note one thing, which is that somebody left their laptop or some device. It's at Public Safety, so if you're missing your device, please go pick it up. We don't want to keep it. And the other thing I just want to add as a parting thought is that there was a lot of dialogue today about the role of the media in New York State bail reform and the public dialogue about it. And this is not the end of this very important conversation. We do want to keep this dialogue going, and we do want to address that very important issue. And so please be on the lookout. We will be sending out an announcement about an upcoming panel. This will be fully online, a webinar that will address that very topic. Right now it's scheduled for May 24th, and if you go back to the website where you RSVP'd, there'll be additional details there. So please come back and join us because that is an important component of this conversation. So when President Mason created the Future of Public Safety Initiative and my position, she really had a vision to expand John Jay's role as a convener and a leader on the most important public safety issues that are affecting our communities. And I think today is a great example of how we're meeting that mission and how we are collaborating across the college in order to meet that mission. So with that, I really do want to thank Mike Rimpel and the rest of the team at the Data Collaborative for Justice for putting this conference together. They've just done a wonderful job. I also want to thank John Jay's really fabulous Director of External Affairs, Mindy Bockstein, who is joining us online, and thank her team, including Jennifer Lorenzo, who's been in touch with so many of the speakers and the panelists today and really helped us pull this together. I also want to thank our colleagues at the Institute for Innovation and Prosecution, in particular Shauna K. Salmon, who helped us today as well. So this really was an effort all across the college to pull this together. So thank you to this great team who gathered us all today. And then finally, I want to thank Jeremy Travis and Arnold Ventures for this, for the support that they've given for this event. Jeremy is the Executive Vice President of Criminal Justice at Arnold Ventures, one of the largest funders of criminal justice reform initiatives and research in the country. And importantly, before Arnold Ventures, Jeremy was John Jay's president for 13 years. Among his many accomplishments as president of John Jay, he founded the Data Collaborative for Justice with Dr. Preeti Chauhan, who's joined us here today as well. and many of the other research projects and centers at John Jay that ground so many important criminal justice programs and policies locally and nationally. And I really can't think of anybody better to conclude today's events. So I'm going to invite Jeremy to please come up and give us his concluding remarks. Thank you all.
Good afternoon, everybody. Time for that wake-up moment at the end of a long day. Everyone just stand up, stretch for a second, because we've got some things to talk about before we leave. Come, a little energy. Where is it? There we go. See, it feels better. Okay. You can sit down. So, as Erica mentioned, I'm here wearing many hats. First of all, I love this college. Always glad to be home. I love being a guest of President Mason. Carol is here. Carol and I have collaborated on all sorts of schemes and dreams over our time together, and this is another one. So it's good to be in your home, President Mason. It's also nice to be here to celebrate the Data Collaborative for Justice and to be here with Preeti Chauhan, my colleague who helped launch that effort, and to see this event hosted by our baby, right? So here it is. It's pretty cool. And it was really odd for me to hear Aubrey Fox remind everyone that I was the first director of CJA many years ago. So there are many connections here. But I want to just take a moment to reflect on the journey that you all, I wasn't here for all of the day, but have traveled today, not by summarizing, that's sort of like, how can you summarize a day like today? But to offer some themes for reflection as we end this time together. So it's so interesting to me, so why we're having this conversation and why we're having it now and why we're having it the way we are. This is not a new conversation. This goes back, centuries. You want to sort of really think about this as a sort of historical challenge that free societies face, which is when is the state entitled to deprive somebody of liberty, on what basis, and then in what conditions should they be held while they're awaiting trial? This is not a new question. It's been around for a long time. It's not a new question in New York City. So I started my career at Vera a long time ago. Why was Vera called into the pretrial business that led to the creation of CJA? Because there was a riot in the Tombs. There was a riot in the Queens House of Detention. Conditions of confinement were so awful. The crowding was so overwhelming that the people incarcerated decided to take the risk to express their frustration and their demands by seizing the Tombs. It was not a pretty sight for the city. So we need to remember that there was a time when this issue was hot in a different sort of way than it is now. And then remember another time in the late 80s when the pretrial population in New York City, I think I have this number right, went to 22,000 people. So I was in City Hall at the time. We were trying to figure out how to respond to the violence associated with the crack epidemic. There were lots of arrests underway. System was grinding to a halt, and lots of people in pretrial detention. I remember that the corrections commissioner at the time took a flight upstate New York to try to find jails at the Canadian border to house people on pretrial detention in New York City, 22,000 people. So that's not to say that we should celebrate where we are today, but just to remind ourselves that this is an issue of long standing. And the city has, I think much to its credit, been grappling with, and the state, because it's a bail law passed by our state representatives, grappling with this issue for a long time. And today should be a celebration of that long-term successful trajectory. Vinny Schiraldi's not here anymore, but he published a paper once that said that the pretrial detention rate in New York City is the same as European cities. I mean, that's remarkable that we have come to that point. It's not a celebration. It's certainly not a celebration of Rikers Island, but it's a recognition that this issue has been with us for a while. So today I work at this place called Arnold Ventures, and we're proud to be celebrating the work that's happening here, some of which we're funding. I want to make sure that everybody knows my colleagues, Zeke Edwards here, Becky Silber is here, and Deba, who's at John Jay, name I've forgotten, and Raz, right, who just joined us. My colleagues here working, what are they working on? Nationally, they're working on pretrial justice issues, including bail reform. So one reason that it's important to have this conversation here today is because New York City is important, not just because, sorry, it's the center of the universe, but because all bail discussions, and they will tell you around the country, ask us what's happening in New York. So I'm glad this is being taped and sort of broadcast, because this discussion right now, just to make you feel really important, you are doing work on behalf of the country. Because if we can get this righter than we have it right now, lots of people are going to be looking to New York and saying, okay, New York went through this time, it was sort of funky, all this debate and discussion back and forth, the politics of bail reform, but if we're coming out of this okay, meaning that we've sort of figured lots of things out and we sort of helped change the narrative, this is important nationally. So with that sort of longer view in mind, I want to just ask ourselves, why do we think, so I've been doing this a long time, this continues to fascinate. This is important, to people who are in the field. It's obviously important to families that are affected, people in detention as we speak, people who have been in and out of Rikers. It's important in so many levels, but it's also just important to think about this against many different lenses. So I want to suggest 4. Just remember that our 2 journalist colleagues today, Akash Mehta, said that in his view, it's a fascinating observation, that the bail reform debate in New York has got more sizzle to it than anything else. So he's a journalist, he covers the city. And he says because criminal justice is interesting, but within that, the bail reform is so complicated and so fraught that it catches the external politics. It refracts the external politics. It is a way of talking about big issues. So I just want to take his suggestion that we sort of look at it as being important, as bigger than itself. As fascinating as it is on its own terms, it's important because for bigger reasons. So, Errol Lewis, who, like, God, is this guy wonderful? We're so blessed to have Errol Lewis in our world. Had this wonderful, like 3 or 4 times this morning, he said, he was interviewing people, but he was just making a personal observation. This comparison between the political truth and what he called the statistical doubts. That's where we sit. We sit between a political truth and statistical doubts about what should be done next. So 4 lenses to think about the conversation we've had today. The first one is obviously political. I'm not going to comment on sort of people's positioning, but just let's count the number of people who have entered this discussion, right? This is so big. We got the mayor. We heard his references often today to his positioning on bail reform. We saw some of the press coverage. We have the PBA, we have the law enforcement, we have judges, so this is a political issue of the first order, and it's not done having a tweak to the old reform. There was a tweak to the old reform in the budget process. This is not over. Anybody with a crystal ball would say this is coming up again in the primary, coming up again in the fall in New York. So this discussion will still be with us. And just remember that this is a fraught issue within both parties, and we're seeing how it plays out. But it's also a national issue. So as I said, Zeke and his colleagues, when they go around and talk about bail reform around the country, people say what's happening in New York. Not bail reform, but law and order, crime, is a national issue. So we have this tension between the very real, tragically real, I don't like the word, as my colleagues know, uptick. It's not an uptick in violence when you lose another, thousands of people last year. This is a serious spike in violence in America. So that very real reality is being used to oppose reform. We can talk about, we can debate, we can point out till the proverbial cows come home. What time do the cows come home, by the way? Are the cows about to come home now? When the cows come home, we can debate this, whether the spike in violence is or is not related to bail reform. We can put up evidence, as happened a lot on this stage today, but remember Errol's exhortation to distinguish between political truths and statistical doubt. So the political truth is there's a debate underway, a fierce debate, and this is the time to protect and advance at the same time bail reform on terms that challenge that political reality of the debate, but also acknowledge it, just the way INCHA did. It was really brilliant. INCHA's just great. Brilliant acknowledgement of the importance of that people have a right to be safe. You can't take away that issue. You can't, I have no patience with people who minimize violence. I have no patience with members of the movement who say we can't talk about it, because otherwise we buy into that narrative. If we don't talk about it, we're doing a disservice to those people who are losing their loved ones. We do a disservice to those communities that are suffering. We need to talk about it, but distinguish it from the realities of the bail issue. That's the tough part. I'll come to the question of evidence in a second. So the political environment is very much present today. We see it playing out nationally in the debates about what to do about violence that the administration, the Biden administration is wrestling with. But let's put another backdrop against this discussion. This discussion is occurring, hard to believe, a few short years after the murder of George Floyd, a few short years after protests on the street, a few short years after the Black Lives Matter sort of chant and insistence was much more visible than it is now. We also can't distinguish this discussion from the call for racial justice. This last panel reminded us of that. Navigating that is also very difficult. So what's the narrative? We need your real help with narratives here around that issue. And finally, we can't distinguish the bail reform debates from the justice reform movement. So I think it was Katie who mentioned the progressive prosecutors. So Chesa Boudin is fighting for his life. George Gascon, probably not far behind. Alvin Bragg got hammered for having a memo that said he was going to do what he said he was going to do on the campaign, and then he actually did it. What a terrible thing for an elected official. So this is a larger issue of the justice reform movement, and within that, we have bail reform. So we also need to sort of be able to talk about these issues both separately and relatedly, so that the movement, the larger movement, doesn't suffer. So here's one just mind exercise for you. I mentioned the crack epidemic. That led to lots of very repressive sentencing policies. That we're paying the price for those now. How interesting I find it, and I hope that by saying this it doesn't come true, that the debate now about how to get tougher on crime is not focusing on longer sentences or more sentences. It's really centered on bail reform and progressive prosecutors. Let's keep it there and sort of push back. Tennessee just did something terrible, which was to say 100% truth in sentencing for criminal sentences rather than whatever it was before. Maybe there's some other examples of where the old tough on crime debates, which led to longer sentences or reductions in discretion, played out that way. We're hoping that doesn't happen. So the second filter that I want to suggest that we saw here play out after the political filter and sort of recognizing this as a political moment was this great discussion about values. So we data geek types don't always like to talk about values, right? So what the numbers show, evidence, I'll talk about that in a second. Is it statistically significant or not? Is it up, is it down? Does it work? What's the dosage? We love that stuff, can do that all day. But let's separate all that from a discussion about values, because implied in the discussions we heard today were deep questions about our values. By our values, I mean our democracy's values, the American experiment's values. And I loved hearing the discussion that we had today about the Constitution. Let's remember the Constitution. Let's remember the values, lots of problems with the Constitution, but the values implied in that Constitution. Let's remember due process. Let's remember the presumption of innocence. Let's remember the prohibition against, guess what, excessive bail. Let's remember the guarantee of a speedy trial. So the language that we can use that I think helps us find common ground with others is the language of defending our Constitution. Just think about it. Work it through in your discussions. There's a language here that can bring lots of people to the table, I hope. It happened today. But the values are more than constitutional values, I think, that are important here. There's the value of autonomy, of liberty, of the ability to find yourself. There's wonderful discussions today about, Susan Sandra Smith has this great, she's working on a book, I can't wait for it, but this great way of talking about the harms of pretrial detention. And our team just published an updated version of what's the title of it? The hidden costs of detention? Hidden costs. There's really great social science evidence about how detention is harmful, but also can be criminogenic, right? So we can talk about that, and it's counterintuitive for lots of people. But let's talk about it in very human terms, about what it means to keep your job, what it means to stay with your family, what it means. So one of our panelists, I forget which one, maybe an assembly member, what was her name, Walker, who said there are no families on this stage. It's the families who should be here. It's the people who should be here. So that value, the way to express that in terms of values is the importance of your ability as a human being to find your own way, to realize your own potential, and the importance of society to respect your dignity, which applies both to people while they're incarcerated and to people while they're not incarcerated, if they're under state supervision. So if we talk about what it means as a human to have that respect from your government in ways that you are treated, even in your most difficult circumstances, then we've found another values-based place that might provide some common ground. The final value that I would just highlight that come up again and again and again is the value of safety. So there's this great discussion, Sandra Smith mentioned this and others mentioned as well, but what do we mean by safety? So the measurement issue here is often rearrest rates. Sometimes people talk about recidivism. Sometimes people go bigger and talk about crime. Good measures, they're not meaningless, but they're not as meaningful as we would like measures to be. And the important way to think about the value that we're trying to advance here, that came up again and again and again, is community well-being, community health. What does it mean for community to work? What does it mean for people to trust each other? So it's not saying that the other values are less important. They're really important, and they're part of the debate. But every once in a while, you can sort of jump the debate up another notch to the level of values. So safety can be redefined. So let's think about a third lens on the discussion, which is this question of evidence. So this is the heresy I'm about to speak. So the cameras are on. That's okay. I don't mind. We worship at the altar of evidence-based policies to our detriment. As much as we should care about evidence, we have to be very careful about idolizing evidence. So I've lived my life promoting evidence and data and transparency. I'll come to that in a second. But let's be really careful about making the discussion only about evidence. So we have a debate where people say on the stage and that the discussion about the impact of bail reform on public safety is not consistent with the evidence. That is true. Thank goodness it's true. Sandra said it's true nationally. Mike put out a report that said it's true locally. The New York Post said it's true, even when criticizing the PBA data, or the police department data. All true. But if you only stop there and say the evidence belies that assertion, we lose the argument. Because, remember Errol, politics, the political truth is bigger than the evidence. So the challenge, I think, for all of us is how to wrap the evidence into a discussion about things that are not evidence, right? How to say it's something bigger, different, better, however we want to go. But as much as I love evidence, and happy to be here with Preeti and see Mike Rempel taking over the Data Collaborative for Justice, that's all we did. And we were very careful all the time, every report that Preeti published, just to talk about the data, just the facts, just to stimulate discussion. But we always knew that if we did that well and objectively, that it would and it did lead to a bigger discussion about what's the right thing to do. What is justice beyond what is statistically true? So evidence is great, but let's just be careful about making that the only framing for the discussion. But the evidence is that we have available to us, I think we have more tools than we usually use. The hidden cost of detention is an important one. We need to, that report is out. You can go to the Arnold website, you can find it, get it circulated, get a lot of attention. But it's a way of recognizing the human cost of being in detention, which is that you could lose your job, you could lose your family, you could lose connectivity, you could lose connection to health care. And we could document all those things, but the important thing is that that fact, even a short time of detention, can have significant consequences for your life. So the way to talk about the evidence is just not there's a cost and here's the cost, but to talk about it in personal and human terms. I love data. I love data because if properly presented and captured and honestly discussed, data is the tool of democracy because it's a way of holding our government accountable for what they do in our names. So another initiative we have underway at Arnold is to work with prosecutors to make their data publicly available. I mean, it's just unspeakably inconsistent with our democracy that we have people who wield state power to deprive people of liberty, either by charging them or recommending bail or sentences, who don't hold their operations open to public interrogation. I'm not talking about just by journalists or just by academics. I'm talking about the public. Prosecutors run for office. They are elected by us. Yeah, every public official works for us, but these are elected by us. We're the only country in the world that elects these people, and then they don't publish the data. You know, is this a resource issue? Of course, that's what we hear. Should they have data analysts? Should they have better data systems? Of course. But we should demand that they have that capability in the name of their accountability to us and our democracy. That applies as well to judges. We had a great discussion here about judges. It applies to prisons. It applies to jails. It applies to public defenders. Sorry, guys, you have to be accountable too. It applies to people who run probation and parole agencies. They do their work in our name. We are entitled to know what they do. The easiest way to actually track, other than journalistic sort of getting in the weeds, is to look at the data of their operations. And then we can send smart students from John Jay, thank you for your question, by the way, to do some analysis in your DA's office. Imagine, right, if we just opened it up and said, what about Eric Gonzalez, with our funding and from WT Grant, published a report on racial disparities in his office. I think, actually, that's probably the third DA. You did the work with Chisholm and then with Cy Vance. There aren't many. Why doesn't every DA's office have an annual report on racial disparities in their prosecution? Why aren't we demanding that? So the movement is really missing the point, which is democratic accountability. So the data and evidence lens is not just the stuff that we talk about in terms of crime, it's really about a public accountability. Speaking of data, let's talk about the understanding that we have or don't have about the rise in violence in America. So people say, what's happening? Everyone's got a theory. Mine has a lot to do with the pandemic. It's guns, there may be more guns, but but the theory is we're still at theory stage, hypothesis generating stage, rather than real strong knowledge stage. And we have to just say that to people. We really don't know. Now, journalists don't like that answer. Sorry, but that's probably the right answer. At the same time, we should quickly acknowledge how extreme the level of violence is. And by that I mean violence has always been too high in communities of color in particular, and it's now extreme. Thousands of lives lost last year because of gun violence. But who's doing the work to try to understand what to do about it? Carol's program on reimagining safety is important. I have my own concerns about what's happening in New York City in terms of whether anything that's now being talked about is going to bring levels of violence down. But there's a discussion we should not shy away from, in my view. Violence is not anathema to the reform movement. It actually has to be central to. And then the fourth lens for our time together today, I think, is in some ways the biggest. Maybe the Constitution is the biggest, but this is a question of social justice. So how many times today did we hear people talking about the need for services, or Russ just said resources, resources, resources. The DA said the Queen's DA was proud of how many programs they had to help people who were prosecuted in that county when he was there. So the social justice imperative should require us to keep a very big frame on the bail reform question. Both attention to what's happening to people who are incarcerated. There will always be jails. They should be humane. I'm on the Lippman Commission. Thank you, Judge Lippman, for moving the debate to shut Rikers and build humane jails. But remember the CJA data about how many people are out under supervision? That's a population of New Yorkers that we don't pay enough attention to, and their needs, and what would help make their lives better. That's the social justice imperative, is for us to pay equal attention, maybe, I don't know what equal means, pay sufficient attention to what is the lived experience of being out awaiting trial. I don't know if you know this, but our colleagues at Cases won an award 2 days ago, a national award for their Nathaniel Project. Great honor for them, and I think particularly fitting for Joel Kopperman, who's leaving Cases after running it for many years. And Joel sent me the video that was produced by the national, it's an insurance company that gives this award for outstanding services on the Nathaniel Project. And this was to me just this great, I encourage you to look at it, this great illustration of if we paid attention to the individualized needs of the people who are out on pretrial release, and we're serious about it, put resources behind it, in this case it's mostly mental health resources, boy, would the world look different. And there's nothing like, on that video, you see this young man who's out on ROR release, who, by the way, was given an offer, we were talking about plea bargaining, of was it a year or two, if he pleaded guilty. And he has social workers showing up to his house to help him with his medication, and he has phone numbers for them. So here we have, with our expenditure, taxpayers' expenditure, the ability to provide something that is absolutely needed, has a criminal justice purpose, but absolutely needed under a social justice rubric. Now, it's an interesting, I'll say, sort of philosophical question about why people should wait to be arrested and charged before you get something that you might be entitled to under some other understanding of what a just society looks like. That's a big one, right? And I think Katie again was saying something about we need more housing, we need more, we do. But at a minimum, for this group, there's an argument to be made for more support. And I know that Zeke is thinking about this a lot at Arnold. And it ranges from housing to mental health to substance use treatment. It also relates to the question about intimate partner violence. That's really under-resourced, under-conceptualized. So all of this, for me, fits into this idea of community well-being, social justice, and the final sort of twist on this that is just so important not to lose sight of is the way in which this plays out against this history, this country's history of white supremacy, and the way in which that legacy continues every day. We saw from our public defender colleague the visual representation of that racial injustice history of the dominance of white supremacy as a way of thinking about our democracy still plays out every day in the justice system. So that has to be foregrounded all the time. It can't be ancillary, can't be second thought, has to be foregrounded. There's a big role for data there, there's a big role for advocacy, there's a big role for community organizing. So when we think about what brought bail reform about all these years ago, I don't know, if you would agree with this, it was driven, legislators did what they did, and it was driven a lot by community organizing. And I'd love to hear from anybody who's closer to this than I am. Is that community organizing as vital and vibrant today as it was then? Not just to sustain bail reform, defense, but also to broaden the discussion, offense, so that we're paying more attention to the social justice imperatives. So we come to an end here, and just to go back to where we started, Senator Gianaris was asked by Errol Lewis to describe the sausage making. What happens in the legislature? It was great. Gianaris doesn't get enough credit for what he's done here, but it's a great description of sort of the back and forth of legislative drafting and tweaking. So that sausage making is what happens. It needs strong advocacy. But let's take a big step back and just remember that we all have a role to play here in promoting better policies, criticizing what's not working, advocating for something better, and being honest and not shying away from the tough topics. There are a number of tough topics in our field, and not making a trade-off between individual rights and public safety, as someone said on the stage, not being afraid to admit error. Don't you love the reference to nurses? Oh, it was so poignant. I've been here all day. I'm a nurse. I don't feel comfortable here because people talk differently about this in my profession than in our profession. We talk about evidence, we talk about healing, we talk about, and some people die in our care. And we go back and we ask, could we have done better? That's the attitude that we need to, could we have done better? How do we think about each one of these instances as an opportunity to do things better? And in the middle of all that, let's not forget the people on whose behalf we do our work. They're not here, all of them. I hope they're represented in ways that we all represent. But when we care about justice, we care about individuals, we care about families, and we care about our aspirations for a multiracial democracy in our country. Thank you.